Good morning and welcome. We are honored today to be joined by several members of Congress in due course, one of whom is with us right now. And it is our custom not to keep these distinguished guests waiting. Therefore, with the concurrence of my fellow board members, we will defer our opening statements and welcome Congressman Peter DeFazio to our hearing today. I will note that as I made my way to work, I listened to Congressman DeFazio on C-SPAN. He's already done at least one event this morning, and so, Congressman, I recommend you consider your scheduler for a raise. That's not our business, but we are honored to have you here, and on behalf of my colleagues, welcome. Take as much time as you need, and when your colleagues from Oregon, the two senators, arrive in due course, we'll do our best to work them right in immediately to not keep them waiting as well. Thank you.
Right. Well, thank you, Mr. Chairman. I think your custom perhaps could be well adopted in Congress. I always find it puzzling that we invite people in to testify, and then the people we work with every day feel that they have to hold forth for sometimes hours on end before we hear from the people invited to testify. And I appreciate the courtesy, and we'll try and return the favor the next time you come before the Hill. Probably can't get down to no opening statements, but we can sure cut them down, in my opinion. I come not as before you as an expert. You all are the expert on these issues, but clearly, given the crowd here today, this particular topic has excited a lot of interest. And I'm going to, if it will not be problematic, since I know the board also is involved in a potential enforcement, I am going to mention a specific case, which I realize you may not be able to comment on, but I think often we are instructed by specific instances in terms of how the law and the regulations really are working to serve the public or not properly serve the public. The common carrier obligation obviously is vitally important, and with increasing fuel prices, I think even more burdens are going to be turned toward rail, and we have to see how we're going to be able to accommodate them. We're trying to deal with that issue on a policy basis, and obviously you're trying to deal with it on a ongoing oversight and enforcement basis. So I'm going to talk about the carrier-imposed requirements for infrastructure investments by shippers and the proper use of rail embargoes in particular. And as I mentioned, I'm going to talk about a situation in Oregon. We had the Corp, which is a subsidiary of Rail America, and Rail America has now been purchased by a hedge fund, which is another topic of concern to me. The ownership of these vital assets. We all know that I just inadvertently made the chair go down. There we go. We're constantly engaged, and yesterday we're engaged in a discussion before the rail subcommittee, or the day before yesterday, about the need for capital investment. The nature of the capital can determine whether we get the needed investments. I think there'd be substantial agreement that virtually all of our rail infrastructure needs investment if it's going to play a key role in the expansion of the burden we're putting on it. In this case, the Corp running a short line down to between Coquille and Vaughan, Oregon, was closed rather precipitously, less than 24 hours notice to the shippers. There were questions about the need for the closure, so I asked the FRA to review it, and the FRA said, in fact, that they felt that those unsafe conditions exist. Now, the unsafe conditions did not arise overnight. Rail America had owned the line for 10 years at the time of the embargo, and Fortress Investment purchased Rail America last year, and one would assume that such a sophisticated group of investors would have done their due diligence, and they would have known of the condition of the line. In fact, and Mr. Griles from Rail America testifying before the committee said, yes, they knew about it. I knew, and he said, and you knew about it too. I don't know what that meant, but in any case, I didn't purchase it. I just happened to represent the district that was served by the line. But then, the confusion ensued from the precipitous closure, and this, I think, perhaps is instructive for the board and for future instances such as this. I mean, they had known of the condition, general deterioration, at least over 10 years. They had more specifically brought in a consultant to Shannon and Wilson, who conducted a study of the line between March 30th and July 9th. And again, they must have had at that point much more specific knowledge of the problems on the line, Corp and Rail America. But it was 73 days later with no notice that the line was embargoed. Now, at the time of embargo, they did say that they were going to embargo any future shipments, but they were going to operate to bring their equipment out and not strand it at the far end of the line. And I guess, although that certainly wouldn't have been a major help, but it would have been some help to the shippers if they, as they had brought out the equipment, they had brought out that one last load. That would have given the shippers at least a few days to begin to make alternate arrangements, since generally they were running a couple of trains a week, but the shippers were not given that courtesy. The train and the cars left, the cargo stayed behind. Now, you know, this has had a dramatic impact. We had very quickly a sawmill that temporarily shut down, laying off 120 people. The small businesses served by this line are seeing costs that are between 10 and 15% today. I would expect more with fuel prices of the premium of the surcharge for trucking. Now, much confusion has arisen since then as to how we can get the embargo lifted. Clearly, there's tunnel work needs to be done. You know, the Rail America and Corp announced via press conference to the shippers and the state that they had a plan, and the plan was that 4/5 of the cost would be paid by other than Rail America or Corp, and that all of the operating costs would be subsidized by the state of Oregon. That wasn't acceptable, and obviously that neither the shippers nor the state had been involved in any discussions prior to the press conference, despite the protestations, again, of Mr. Giles at the hearing, where he said they had worked with all parties, and you'll hear from Alan Ford with the Coos-Siskiyou Shippers Coalition later to, you know, to make clear that there were no discussions. I asked, given the fact that that was not well received, if the governor would host a meeting of all the principals and bring in everybody and see if we could work something out, because this is a vital line. The shippers have indicated they would be willing to pay more. The state says that they're willing, once the line is reopened, to consider working with, partnering with the rail company. In fact, Oregon, I think, is a leader among many states. So we have something called Connect Oregon, where our state is partnering with Union Pacific. No easy thing to do. They're really adverse to being involved with the government anyway, but they felt Oregon was making a benign offer, and they've worked together to enhance capacity on the main line through the valley by partnering on building sidings. So I think the state has shown that it is willing to work in partnership with rail companies. And in this case, the governor said if they would reopen the line, then the state would sit down with them and work on the longer-term issue of their costs and other problems along the line. But the governor said, you know, you just got to get it reopened, and then we'll sit down. Corp said they'd consider that, but they came back with a different proposal, which again seems pretty heavily weighted on their side. The state would pay all the costs under their new proposal, but they would get 50% ownership in the line, you know, and there are other conditions, and perhaps folks can go into that. But I really feel that we haven't seen a real good faith effort here on the part of Corp, and the question becomes, what are their obligations under an embargo? When does an embargo become an abandonment? I know the board, again, is looking at a potential enforcement action there, so we probably can't get into too much discussion about that today. But I think that's probably a policy question that you may cross in this one particular case, but you may have to look at in the future, because I assume we are not unique in this instance. There's been tremendous disinvestment in the rail network in America, and I expect there are other places where unsafe conditions are going to crop up that may lead to the need for closure. And then the question becomes, if an embargo for safety purposes is put in place, how does one demonstrate that there were, the owner of the asset working in good faith with the shippers and other affected parties to get the lines reopened. And so I guess the reasonable amount of time for an embargo, I think, is something that probably has not been particularly defined. I'm certain there are precedents that you're aware of before the board. But in this case, I think what started as a proper embargo, which we would all agree that tunnels were unsafe, has now sort of devolved into questionable use of an embargo, and it's seemingly an embargo that will stretch into the future, because Corp has further said they have no plans for abandonment, but they've also said that the line is not profitable, and they're not anxious to reopen it and operate it. So then that really brings us back to the common carrier obligation. Can we leave these communities and these shippers in an indefinite limbo, or is there a point at which there's going to have to be an abandonment or some other process that might allow another operator or the shippers an alternative for the future? So I'm pleased to be here today, and I understand that you're looking at enforcement action, and perhaps we can't discuss the specifics too much, but I think in these specifics are questions of policy that will probably confront the board and other short lines and other shippers around America again in the future. So I thank you for the opportunity, and would be happy if you have any questions that you'd like me to address those questions. Thank you, Mr. Chairman.
Thank you, Congressman DeFazio. Just a couple brief questions. We won't keep you here too long, I can assure you, but you mentioned the 120 layoffs and some of the economic hardship that's been caused by this embargo out in your state by the Corp Railroad. Can you elaborate on that? We've also heard, received letters, met with a number of shippers who talked about just enormous financial hardship, and just if you could, because sometimes here in Washington we get a little insulated as to how the real economy works. You've got a very much a timber and lumber oriented economy in that part of the state, is my understanding. It's very dependent on rail transportation. They basically have no such rail transportation now, but if you could just help us understand that.
Well, I think again, Alan Ford can address this in much greater detail, but we're looking at a sector that's already been hit fairly hard because of what's going on in the mortgage market and with housing. But there is still ongoing demand for the product, but obviously the prices are down. So we're confronted with a time where basically we've seen some decrease in demand and some decrease in potential profitability or price, and at the same time we've now find that the cost-effective shipping alternative for the lumber and wood products does not exist, and to access rail, in particular now that problems are coming up also with the Siskiyou line in the Corp. Again, something Alan Ford can address. I mean, most dependably, they would have to truck the product all the way up to Union Pacific in Eugene in order to access dependable rail service at this point in time, and then. And when it rains, it pours. And UP is having problems out of Eugene because their main line over the mountains suffered a catastrophic landslide, the likes of which no one has ever seen. It is reopened now for limited service, but they were having to reroute all the way up around through Portland and down the other side for a while. So we have both the challenge of the limits being proposed on the Siskiyou line and the cost increases being proposed there, the closure of the Coos line. So that's had a dramatic impact on the lumber wood products. But there's another company, American Bridge, who was attracted. Their main facility is here on the East Coast, but they decided in order to be more competitive in the West and Midwest, they would open a facility in Oregon, and they have in my district on the coast. But what's critical to them, they have components that cannot even be shipped by truck. They have to go on rail because of weight and size. So they are, I guess maybe this is a harder thing to actually document, but they are foregoing bidding on a number of projects just because they can't, they have no way of getting the product there. So you have the lumber and wood products, and you have, a bridge manufacturer, and obviously we clearly have tremendous demand for bridge manufacturing and repair in this country, given my other role as chairman of the Surface Transportation Subcommittee. We have 175,000 bridges in America that are either structurally deficient or functionally obsolete, and we're trying to address that issue. And now we have a company in my district that potentially has a lot of work that can't even bid on that work because of the loss of rail access. So and this is not an area that has a tremendous amount of alternatives. The only other major alternative is fishing, and we're about to see a total closure of the salmon fishery. So I know that's not your jurisdiction, but it's very, very difficult times for the people on the coast. And at least if we could get the rail access, we would be able to be assured of the jobs at American Bridge, probably see that company grow, and our lumber and wood products folks would be, again, more competitive in what's a difficult market.
Thank you. I am familiar with the American Bridge Company and their situation. I come from a highway background, federal highways, and before that, the Virginia Department of Transportation. And I can tell you, as you know, there's not enormous competition when you get into some of the sophisticated providers of steel and bridge components. And my understanding is American Bridge was positioning itself to serve the western coast. California, for example, has some significant plans to do some major projects, and so it is a very tough situation. This might sound like an odd question from STB, but I want to ask about weather. We heard a lot of things last fall, as you did in the press, coming from Corp and Rail America. We heard about, of course, the safety concerns. Those seem to have been endorsed or ratified or confirmed by the Federal Railroad Administration. Then we heard, though, almost contemporaneously with the closure, about the lack of profitability of the line as perhaps a reason for the railroad to not be in a rush to reopen it. Then we heard about weather. We heard that rain. Of course, it rains a lot in Oregon in the winter months, and that wouldn't be perhaps a smart time to initiate challenging tunnel reconstruction and repair. That resonated a little bit with me from a highway background. Weather can often dictate the schedule of a complex infrastructure job. But I know you're in Washington probably more than you'd like to be, not at home, but is it drying out there?
No.
I know here in the East Coast it's spring, and a lot of projects are starting to move forward. But
Well, normally we have spring before Washington has spring. This is one of the most severe winters we've suffered in a very long time. I was just home last weekend and actually snowed, which has never happened in April before on the west side that anyone's aware of. So we're waiting for our weather to change, but inevitably it will. One day we'll wake up and it'll be as nice or nicer than this, and we'll get into what is typically a very long dry spell. I guess the issue there is I think it's plausible that it would have been very difficult, if not impossible, to do the major tunnel work. There is other work that they've talked about that I think perhaps track work and other could have been conducted during the winter season, at least in certain areas. But I guess the key thing is, do they have someone lined up? Are they ready to go as soon as things dry out? And so far as I know, there are no immediate plans, even when weather and conditions do permit to begin construction. So, we might miss that window for this year if they aren't geared up, committed, and ready to go by the time, the construction season begins. Granted, it is a bit later than usual this year.
Thank you. I'd like to defer to Vice Chairman Mulvey.
Thank you very much, Chairman Nottingham. I want to welcome Chairman DeFazio to our committee. I had the honor and pleasure of working with him and for him a bit when I was with the T&I committee, and I'm very happy to see him here today. You mentioned the embargo and the problems with embargoes, and I can assure you one of the concerns, one of the things that has triggered this hearing has been the alleged misuse of the embargo process by railroads, which have caused them to quasi-abandon or use it for abandoning lines when they put on these embargoes that become permanent. And it's one of the things that concern us, especially today. One of the things about the situation that you referred to is the port is of the port of Coos Bay. And Coos Bay, as I recall, has a lot of potential to develop, and that development could be impeded if indeed there's not adequate rail access. You wanted to discuss that a little bit?
Sure. Coos Bay actually, as many people are aware, our ports on the West Coast are at this point at or above capacities, tremendous congestion for, Long Beach, Seattle, Tacoma. Port of Portland is not in capacity, but it's a very long run up the Columbia River. The port of Coos Bay is actually ideally situated in terms of being in the middle of the Oregon coast and being, if it could feed into the main lines or UP or Burlington Northern, just north of Eugene, it's an excellent transshipment point and an alternative without sitting in a line of ships that goes far out to sea. Coos Bay has a new and very active port commission for the last few years, and in particular, they've been in serious discussions with Maersk about the potential for a major container facility there, because unique characteristics exist in Coos Bay, not only the very convenient and short run into the harbor, but also the fact that the port actually has developable, properly zoned, already vetted, ready to go land that would allow uniquely unit trains to be put together without an incessant number of pulls. Basically, you could put together with one pull a unit train out of Coos Bay. That's unique. I mean, property values are certainly lower than in the other major port areas, and the land is available, which it isn't in many of other major port areas. That has raised concern, among a number of us, and particularly myself, whether or not Corp would like to string this embargo out until such a time. I mean, there is no commitment yet from Maersk, but this is tremendous potential. So what you have here is a potentially very valuable asset, but in the interim, it's, as they said, the Coos Bay line just doesn't have enough business on it today to justify us making the repairs. So I think they potentially profit from an indefinite embargo. Obviously, it's detrimental to the existing businesses, but they could be betting on the upside, which is, well, if Maersk comes in, then we're in the catbird seat here with a tremendous asset, for the future, which, of course, is something that hedge funds are very good at doing. They bet on futures, and I think that's what we see here is a bet on the future. And the problem is I don't think they should be allowed to essentially embargo their common carrier obligation for an indefinite period of time while they wait to see whether or not their asset becomes more valuable.
Thank you.
Right. Commissioner Buttry, any questions?
Thank you, Mr. Chairman. We certainly welcome you here today, Congressman. Appreciate very much your taking time out to come down and.
This is my second visit, so I think it probably might be one of the few members of Congress ever to come twice, but I thank you for the opportunity.
You probably do hold a record for that at the moment. We appreciate very much your coming down and sharing your views with us. You can tell by listening to you the tone of your voice that this is of great concern to you, and that, and I'm sure you certainly know that our determinations here are not based on compassion and sympathy.
I understand.
Although I can tell you that there is compassion and sympathy that is alive and well here. I happen to grow up in a very rural part of my home state of Tennessee, where logging and lumber is a very big deal. And I think we bought our little farm many years ago for $2,000 and sold the timber off about a month later for about $15,000. So that was a pretty good deal for us. But I, for one, sort of understand what you're talking about and have a sympathy and compassion for the people that are affected by this. And I'm thinking primarily when I talk about people who are affected by this, I'm talking about the people who go to work every day and work in the lumber sawmill down there, because this in many cases means, you know, these people don't have brokers and 401ks. These are people who are working basically paycheck to paycheck. Essentially, at least the ones that I knew worked that way. And it means basically jerking up their family, taking their kids out of school, and moving someplace where there's a sawmill still operating. And frankly, you know, there really aren't very many sawmills operating anymore in this country, not only in the lower 48, but in Alaska and other places. So it's a real sensitive issue for me, because I've been close to it before. So I just want to let you know that we'll be seriously considering these issues as we go forward here, and we appreciate very much your coming down and sharing your views with us. Thank you very much.
I appreciate that, especially since at times we've been in rather fierce competition with some of the southern providers in terms of the U.S. market, and also obviously with the Canadians. It is a very competitive marketplace, and with the decrease in demand right now, as I said, there is ongoing demand. In particular, I have a couple of firms, and I believe, again, Mr. Ford may be more specific about this, but it's my understanding that a couple of the companies, family-owned, are at the moment perhaps losing money but continuing to operate, and the closer they can come to breaking even, the more likely it is they'll be able to keep that up for a while until the markets pick up again. And this 10 or 15 or 20% margin on transportation is that difference for them. I mean, if they weren't paying that much more, they would be, you know, perhaps slightly in the blue, you know, on the profit side. But you know, I have a lot of operators in Oregon that are older family firms, and they try and keep their workers on because they realize the markets will come back. But you know, when you compound the market problems with the shipping problems, it becomes very difficult for them. So, thank you.
Chairman DeFazio, just please know that this board is here as a resource to you and your constituents. We will stay with this controversy as long as it takes to make sure it gets to an outcome that comports with the law and also ensures that the board is stepping up and meeting our obligations. And we have sent already in the last few months a couple senior staff out to Oregon to better understand the situation on the ground, to meet with stakeholders. We've invited and have had the CEO of Rail America come to our offices for, along with a number of the stakeholders, shippers from Oregon, to conduct some informal just negotiation. And we will, and now we've, as you know, in the record, we have called on the railroad to, through a show cause order, to make some very specific responses to us, which we'll be receiving soon. So. And we'll have Rail America before us later in this hearing, too. So you will be hearing more from the board on this, and we appreciate the information you provided today. And thank you for your service to our country, and look forward to working with you in the future.
Thank you, Mr. Chairman. I thank the other members of the board. We still miss Frank. So, but especially as we're confronting some of these very big policy issues about rail these days. But thank you again. I appreciate the consideration, and just on behalf of those I represent, we appreciate the fact that we, you know, they do have recourse. There are laws, and even when dealing with with a local firm that's been bought by a national firm that's been bought by an international hedge fund, there is still recourse for our citizens. That's a great thing about America. So thank you very much. Appreciate it.
Thank you, Congressman. We will now return to members' opening statements. I'm advised that we have two members of the United States Senate who will join us soon, and so we'll be keeping our eyes open for them. When they do arrive, we'll bring them forward, along with the rest of the first panel, including Mr. Ford from the Siskiyou Shippers Coalition. Again, welcome to all of you here this morning. Today we will hear testimony on a topic that has generated much interest both within and outside this agency, the common carrier obligation. I'm sure that it will be often mentioned today that the common carrier obligation is a long-standing legal principle. In fact, as one historian has noted, the principle that common carriage is open to all upon reasonable request has been imposed upon transportation companies as a feature of English common law since the Middle Ages, and its roots go back even farther to commercial codes enacted by the Roman Empire. Today, that common law principle, as it applies to railroads, is codified in the Interstate Commerce Act in the provision stating that, quote, a rail carrier providing transportation or service subject to the jurisdiction of the board shall provide the transportation or service on reasonable request. At the heart of the board's mission is our responsibility to serve as a forum for resolving disputes, both formal and informal, between shippers and railroads, and even between a railroad and another railroad, regarding whether and how well the railroads are carrying out that obligation to provide service on reasonable request. Recently, for example, a shipper in Lubbock, Texas, complained that it was receiving inadequate service from the railroad serving it. In that case, the board first issued an order permitting another railroad to operate over the incumbent railroad's lines to serve the shipper, and ultimately we forced the incumbent railroad to sell its line to another carrier that demonstrated a commitment to improved rail service to shippers. This particular forced sale was complex and lengthy, but it demonstrates this board's commitment to enforcing the common carrier obligation and protecting shippers from unreasonable denial of service. The board acted also to preserve shippers' service options in another recent case in Ohio involving a railroad that would not let another railroad cross its line. In that case, a Class I railroad had unilaterally removed the crossing diamonds that were needed for a short line to serve several potential shippers. The board made clear that a carrier may not undercut another carrier's ability to fulfill its common carrier obligation by unilaterally severing track of the other carrier that is part of the national transportation system. The board directed the Class I carrier to promptly reinstall the crossing. And pending before the board right now, as Chairman DeFazio has discussed, is a proceeding involving a line of railroad leading to Coos Bay, Oregon, from Coquille to Vaughan, which was embargoed by the short line that owns it last September. In that case, we're looking into whether that railroad has violated its common carrier obligation by failing to restore the line to service and failing to even begin the process of restoring the line to service. In fact, we will hear testimony at this hearing from some of the principals involved in that case. As we examine today and tomorrow many of the questions and controversies related to the common carrier obligation, one thing is clear. The common carrier obligation must not be allowed to be redefined either by railroads or by shippers in a manner that is inconsistent with the broad public interest in the free flow of interstate commerce. However, exactly what is a, quote, reasonable request for service is a matter of great debate, as is revealed in the statements you have filed with us. There are tensions and trends surrounding the common carrier obligation that I'm sure we will hear discussed today and tomorrow, including the railroad's need to make market-based decisions versus the national interest in ensuring that all markets are served, the status of exempt commodities, which the board has found are not subject to a common carrier obligation unless the exemption is revoked, the trend in agricultural transportation towards large unit trains and the effects of that trend on single-car shippers, the effect of the modern-day tort liability system and security concerns and resulting insurance costs on the common carrier obligation, whether service to a shipper can be conditioned on a shipper contributing to the capacity investment the railroad would need to serve that shipper. The strain on the common carrier obligation is even more acute given the transportation trends that demonstrate there will be increased pressure on the railroads to carry more and more freight in light of factors such as highway congestion, truck driver shortages, and increased fuel costs that make rail more attractive than less fuel-efficient modes. We heard about many of those trends just over a year ago. when we gathered with many of you who are here again today in this hearing room to discuss infrastructure demands and capacity constraints in the railroad industry. At that hearing, a representative of one of the nation's ports testified that container traffic typically carried by truck or rail entering North American ports from overseas will grow by more than 100% by the year 2020, from over 48 million 20-foot equivalent units, or TEUs, in 2005 to an anticipated 130 million TEUs. Furthermore, representatives of the Class I railroad industry testified that despite their plans to increase investment levels in the system every year, they would not maintain a pace to actually keep up with demand. We look forward to getting into these and all of the other issues today. At this point, I'd like to turn over for his opening comments the dais to Vice Chairman Mulvey.
Thank you, Chairman Nottingham. I want to thank my fellow board members for agreeing to hold this hearing, and I want to thank our staff for their preparation and assistance. And good morning and welcome to our panelists and other attendees here today. I have thoroughly read the testimony submitted for this hearing, and there was a considerable amount of it, and I'm eager now to engage in discussion with our panelists. I also want to thank those stakeholders, including Rail Labor, who submitted written testimony only, which I found very, very helpful in framing our inquiry today. I want to add, though, that I am dismayed that some witnesses believe the board is holding this hearing today to build a foundation for reducing the scope of the common carrier obligation. And I am, quite frankly, puzzled as to how this perception has arisen. That was certainly not my concern, my intention, and I don't believe it was that of the other board members. I recognize that there's a tension between the concepts of the railroads as organizations with significant public utility characteristics and as private enterprises that must maximize their profits for their shareholders. The purpose of this hearing is to explore that tension. Historically, the common carrier obligation has cast the railroads in the role of public utilities. But I have heard some railroad executives claim that railroads today no longer have any common carrier obligation because the vast majority of rail traffic either moves under contract or is exempt from board regulation because it is considered intermodally competitive. This disturbs me. What does the concept common carrier obligation mean today? Has it changed in recent years, and if so, how and why? Are any of the railroad's current marketing and operating practices inconsistent with the common carrier obligation? And finally, what is the responsibility of the board and the legislature to ensure that railroads live up to their common carrier obligations? These are some of the questions that I hope that we will explore today. Thank you very much, Chairman Nottingham.
Thank you, Vice Chairman Mulvey. Commissioner Buttry.
Thank you, Mr. Chairman. The term common carrier obligation has been around for a long time. It's said to arrive in statute, yet the Interstate Commerce Act does not define that precise term. That act does have a section 11101, with the heading Common Carrier Transportation Service and Rates. In that section, the statute says that a rail carrier shall provide transportation or service upon reasonable request. It is the meaning of that somewhat cryptic phrase, provide transportation or service upon reasonable request, that we're here to probe and consider at this hearing today. I say cryptic because those words used in the statute are so very general and nonspecific in nature and require a lot of interpretation and fleshing out in order to ascertain exactly what they might mean. And that's the job of this board and the courts. There is quite a lot of history that we can look at to determine what this board and the ICC before it and the courts have thought the common carrier obligation meant in the past. But it's clear to me that the interpretation of this cryptic phrase must change over time as circumstances change, and that it may be found to impose different requirements on rail carriers today in the present capacity-constrained environment than it did 10 or 50 or maybe even 100 years ago. I know at least one person who claims that the concept of the common carrier obligation is so well established that it actually originated in Hammurabi's code in ancient Babylon. There are probably some who would argue that the concept has some connection to the Dead Sea Scrolls. I'm advised that the concept actually has roots in the English common law dealing with public utilities. And we all have heard said that the concept is as old as dust. Now, there's an old story about an arrogant young man who was feeling pretty confident one day, and he challenged God by saying that he would make a man just like God did. God responded by saying that he accepted the challenge and would meet the young man in the Gobi Desert. At that meeting, God bent down and took a handful of dust and said, "From this dust I will make a man." Then the young man bent down and took a handful of dust. At that moment, God said, "You have to provide your own dust." Now, I'm not suggesting that we repudiate or dishonor the progress that has been made under the original concept, but I am suggesting that it may be time to get our own dust. We may need to get our own concept of the common carrier obligation that recognizes the new realities in the current constrained global transportation marketplace. Take the question of whether railroads are obligated to transport the most extremely toxic, hazardous materials without being properly protected against the horrendous liability exposure that could ensue. In my view, there must be enacted a liability cap for hazmat transportation, perhaps something akin to Price-Anderson. I believe that would be good public policy. Until the Congress deals with the liability cap issue, I, for one, believe that rail carriers may be well within their rights to refuse to carry the extremely toxic hazardous materials without indemnification. I can tell you that as a businessman, that's the decision I would make. I simply do not feel that it is a reasonable request for a shipper to ask a railroad to transport these types of commodities without some kind of meaningful protection from the unreasonably high bet-the-company type liability exposure. While I know we need to stay focused today on the concept of common carrier obligation, I cannot resist the temptation to comment on some things I've observed over the past few months which persist today. There are people and groups who seem to be espousing legislative or regulatory proposals that are based on totally incorrect information. I've tried to find explanations for such activity: faulty advice, misunderstanding, intentional deception, or a combination of these. Whoever is paying for these activities might consider asking for a refund. It's clear to me that deception and diversion are the true evil twins when it comes to today's debate in the public arena. We could spend a couple of days at least looking into these claims, but we do not have that kind of time. However, I must expose a couple of them that bother me the most. First, it is simply a misunderstanding of the current state of the law to state that the railroads are not subject to the antitrust laws. They are and always have been subject to the antitrust laws. Congress has carved out very limited exceptions that generally apply to those specific activities that are covered by official board actions which are directly and immediately reviewable by the federal courts. But that leaves a very broad range of egregious conduct that is subject to the full weight of our antitrust laws, including price fixing, bid rigging, and market allocation. Another fallacy that I've heard asserted as gospel truth by some is the claim that the Staggers Act was intended to spur or increase competition, and that the board has somehow failed to live up to that goal. But I've looked at the legislative history, and it's clear that the balance that the Congress struck in the Staggers Act is that where competition exists, it should be the regulator of rail rates to the extent possible. And only where competition does not exist is regulatory relief available. The Staggers Act does not contain a mandate to increase competition, and anyone who says it does is trying to rewrite history. Another misconception I hear is that captive shippers cannot get meaningful rate relief, but that term captive shipper is often used inaccurately. A shipper that has a truck alternative simply is not a captive shipper. The Staggers Act makes that very clear. Turning now to some good news. I'm very pleased that the board is going to start making agricultural contract summaries available to and accessible on the board's website. Section 10709D1 of the Act directs the board to ensure that the essential terms of each contract for the transportation of agricultural products, including grain, are made available to the general public. This new web posting procedure is a good first step to help to do that. It will help to shed more light on what is going on with grain contracts and make this very dynamic market a bit more transparent. And now I'm here to listen and look forward to hearing the testimony of the witnesses. Thank you, Mr. Chairman.
Thank you, Commissioner Buttrey. Your point towards the end of your remarks about the posting on our website of the agricultural shipping contract information. That, I'm told, is effective today, and so folks who are interested in that, these are filings that have for a long time come to the board, but we've learned recently haven't made it onto the internet. So now we've addressed that, and we hope that will make that information more accessible. On a couple of procedural notes, we have a number of witnesses, and we appreciate all of you who've come from long distances and medium long and short distances to be with us today and tomorrow. It's an extraordinary occurrence here at the board to have a 2-day long hearing, but we thought that was better than to pull an all-nighter. I hope you'll agree. And so for that reason, though, we will be particularly firm today and tomorrow about limiting witnesses to the prescribed time limits that you've all been given in advance. That's the only fair thing to do, so everyone can be heard, and that we're not here at 8 o'clock tomorrow night still hearing from individuals. As usual, we will hear from all the speakers on a panel prior to questions from the commissioners. Speakers, please note that the timing lights are in front of me on the dais. You will see a yellow light when you have 1 minute remaining and a red light when your time has expired. As you can see from the published schedule, we have quite a few witnesses appearing at this hearing. Therefore, I will be keeping an eye on the clock and ask that you please keep to the time you've been allotted. I assure you that we have read all of your submissions, and there is no need to read all of them here in their entirety. After hearing from the entire panel, in each entire panel, we will rotate with questions from each board member until we have exhausted the questions. Additionally, just a reminder to please turn off all your cell phones. I look forward to hearing the testimony of the parties, and would now like to call forward Mr. Alan Ford of the Coos-Siskiyou Shippers Coalition from our first panel. And as soon as we're joined by, I don't think we've been joined yet, but as soon as we're joined by Senators Ron Wyden and Gordon Smith, we will bring them forward as well. All three members of the Oregon delegation made a special request, Mr. Ford, that you be allowed to sit with or near them as best as their schedules permit early in the proceeding, and so we were happy to accommodate that. You may well have come the farthest as well, and so we welcome you back to the board. As we mentioned earlier, you have been here already at least once in an effort to informally resolve the situation you're faced with out there, and welcome you back. Look forward to working with you. Please proceed. Oh, Mr. Ford, I'm so sorry. There is a button on your microphone. If you just depress that and see a red light.
Okay, is that proper? Thank you. On behalf of the Coos-Siskiyou Shippers Coalition and my own company, Roseburg Forest Products, I wish to thank the Surface Transportation Board for holding this hearing. I am the president of Roseburg Forest Products, an Oregon family-owned corporation with forest products manufacturing facilities heavily concentrated in southern Oregon and northern California. We employ over 3,500 employees manufacturing engineered wood products, composite panels, softwood and hardwood plywood, lumber, with raw materials sourced from our own timberlands. Most of our facilities are located in rural areas, and we represent the principal employee in these communities. As with most wood products companies, we are heavily dependent upon the ability to ship both our raw material and finished products by rail. Roseburg Forest Products has had a close relationship over the years with the various railroads, including in 2004 assisting with the reopening of the rail line between Winston and Dillard, Oregon, when the line was closed to a major landslide, and providing financial assistance for repairing tunnels involved in the reopening of the Siskiyou line in 2006. In addition to my company, I'm here on behalf of the Coos-Siskiyou Shippers Coalition, whose membership includes American Bridge Company. Hi, Ron. How are you, Senator? Georgia Pacific, Southport Lumber Company, and Timber Products Company. These entities are dependent upon shipping materials on the Coos and Siskiyou lines, which are operated by Central Oregon Pacific Railroad Corp., a short line railroad wholly owned by Rail America. Membership in the coalition, in addition to shippers, includes representation from county and city governments, area businesses, chamber of commerces, and other economically dependent groups. These entities, which number over 45 members, have joined the coalition because of the fear that Corp's actions to curtail service on both the Siskiyou and Coos lines will hurt rural Oregon and California communities. In the face of recent embargoes and deteriorating conditions of these railroad lines, these organizations have come together with a common goal of restoring and maintaining safe and efficient rail service in southwestern Oregon particularly on the Coos and Siskiyou rail lines. This coalition formed shortly after Corp's September 21, 2007 embargo of the Coos line. The embargo left the shippers scrambling not only to find alternative shipping, but just to keep their businesses operating. Compounding the difficulties was the fact that the embargo was imposed with 1 day's notice. My company had orders awaiting shipment and targeted for delivery on specific dates, and as a result of the short embargo notice, we really had to improvise to find timely alternative transportation. Our story was experienced by other members of the coalition as well. Not only were coalition members' shipments disrupted, but in the case of American Bridge, who builds trusses for bridge throughout the United States, its ability to compete for contracts and orders was severely impacted. While the Coos line embargo was based on tunnel safety issues, the railroad was aware of the tunnel problems for a period of time. It only provided 1 day's notice of embargo. Clearly, tunnels did not become unsafe overnight. In fact, an earlier Corp was cited for maintenance and safety issues on the line. Historically, the shippers have been willing to provide both financial assistance as well as equipment to repair tunnels, landslides, and to resolve deferred maintenance issues. Corp, however, clearly did not see this as a railroad-shipper partnership and cavalierly shut the line down. Prior to the embargo, no attempt was made by Corp to address the issue with the shippers or to explore ways for the shippers and railroad to solve the tunnel problem and to, in turn, keep the line operational. In fact, Corp did not provide an assessment of the capital needs to restore the line to service until several months after closure, and only then after pressure from our state legislators and the governor's office. On both the Siskiyou and the Coos lines, Corp has benefited in the past from shippers and local governments' willingness to step up to the plate and provide assistance in resolving maintenance and other disruptions of service. Notwithstanding this history, in this case, Corp did not embark upon a similar path to reopen the line. Rather, it simply viewed the embargo as a way to extract further concessions from the shippers and subsidies from the government. At the time of the embargo, Corp's analysis, which was not made available to the shippers until several weeks later, identified the tunnels could be repaired within 12 months at an expenditure of approximately $2.8 million. However, rather than make the repairs on the 3 tunnels and reinstitute service, Corp stated it would not open the line unless the shippers, the state of Oregon, Port of Coos Bay, and the Union Pacific agreed to pay 3/4 of not only the immediate tunnel repair costs, but also what Rail America described as the neglect and deferred maintenance that had taken place over the line over the last 20 years. The proposed solution was for an investment of approximately $23 million to bring Corp's rail line up to safe operating standards. This funding was to be derived from the state of Oregon, Port of Coos Bay, Union Pacific, shippers, and the Corp, each an amount of $4.66 million. In addition, Corp also stated that even if these monies were forthcoming, Corp would not reopen the line unless the state of Oregon provided an additional operating subsidy of $2 million a year, as well as a $1.5 million a year in revenue subsidies. This latter condition is one that the state of Oregon cannot accept, which Corp obviously knew when they laid the proposal on the table. Also disturbing to the shippers is the fact that in the past, the shippers and government entities have provided assistance and agreed to surcharges. However, Corp and Rail America have not always used these funds for either the stated repair or maintenance on the line. In the face of our situation, the Surface Transportation Board decision to examine the railroad's common carrier obligation is particularly timely, and we very much appreciate this opportunity to provide testimony. Of the items identified in the hearing notice, the Coos-Siskiyou shippers' experience has demonstrated that with respect to the issue of carrier-imposed requirements for infrastructure investments by the shippers, it is clear that the Surface Transportation Board needs to assert additional oversight and control. Further, with respect to the issue of what constitutes a proper use of rail embargoes, it is also clear that our situation, that Corp is willing to abuse the embargo power to extract monetary concessions. While it is clear that embargoes play an essential role with respect to rail transportation, the current system is subject to abuse. It is our position that the Surface Transportation Board needs to assert a stronger role in ensuring that the railroads meet their common carrier obligations. We have always assumed that inherent in a common carrier's obligation would be a duty of good faith both in maintaining the rail lines and in dealing with the shippers. However, it is becoming abundantly clear that it is common practice to defer maintenance, in effect, milking the asset. We have also assumed that the rates are set at a level that not only covers operational and maintenance, but also to provide a reasonable profit. In our case, the short line operator has admitted that the lines have not been maintained for a period of 20 years, and clearly they were not reinvesting the maintenance component of the rate into the line. The net result has been a history of derailments and curtailments that affect the safety and economic stability of the local communities and industries. The question of whether it is appropriate for the shippers to pay for the cost of maintenance, particularly deferred maintenance, is not an easily answered question. However, it should be readily understood that when Fortress recently acquired Rail America, they knew the condition of both the Coos and Siskiyou lines, and they assumed operational responsibility. The purchase price surely reflected the condition of the infrastructure. The short line should not be allowed to blame the poor condition of the line on prior operators, when in fact the maintenance of the line is a safe standard was an obligation they willingly undertook, and the negotiated sale price was so reflected. The ongoing failure to repair or maintain the lines is not a reflection of rates. Rather, it is a reflection of short-term inflation of the bottom line without making investments any prudent businessman will undertake. The situation on the south end of the Siskiyou line, where the track climbs over the Siskiyou Summit, connecting southern Oregon to northern California, is a more recent development and another example of the arrogance of Corp in dealing with the shippers who have for decades relied on rail service for delivery of finished products to market as well as to raw material to their mills. In a letter to the shippers dated December 13, 2007, Corp announced that they would no longer take finished products south to California for mills in southern Oregon. With that change, all freight now generated in southern Oregon is taken north to Eugene, then transferred to Union Pacific for delivery throughout the country. Aggravating the situation is a recent major landslide on the UP line that Congressman DeFazio mentioned just east of Eugene, which forced all this freight to be delivered from Eugene north 100 miles, 150 miles to Portland, east to the Columbia River Gorge, then connecting the main lines that travel south and east. In December 13, 2007 letter to the shippers, Corp also announced they intended to curtail shipments of raw material, green veneer, and logs north over the Siskiyou Summit from Roseburg Forest Products Plant in Weed, California, and from Timber Products Plant in Wairika, California, to their finishing plants in southern Oregon. Prior to this letter, Corp had been pulling cars 5 days per week. Pursuant to the letter, they now intended to reduce the service to only 2 days per week. While Corp explained their goal was to improve profitability, it is clear that the strategy was to make it sufficiently uneconomical so that the shippers would allow them to discontinue service. Corp further stated by April 15th, if operating revenues resulting from the reduction to 2 days per week did not increase, the line would be shut down and all deliveries would be made by taking freight on the UP line north through Klamath Falls, Oregon, across the Cascades, Eugene, and then back down south to the affected southern Oregon mills. The shippers in good faith have tried to negotiate new rates to incorporate Corp's revenues, but the demand by Corp of a 300% to 400% increase in shipping rates over the Siskiyous makes the haul cost prohibitive. Both companies are now evaluating that the only alternative left for them is to truck their raw material up Interstate 5 to the southern Oregon mills. Based on normal operating conditions, this could result in an additional 36,000 trucks per year on Interstate 5 for a less efficient mode than rail, and further contributing to traffic congestion on an important segment of the interstate highway. The actions by Corp on the Coos and Siskiyou lines are unfortunately a perfect example of why the Surface Transportation Board needs to establish more oversight over the short line railroads to provide the shippers, our employees, and our communities with reliable rail service. Certainly the April 11, 2008 order that the board issued to Rail America and Corp to show cause why the ongoing failure to provide service on the Coos Bay line is not an unlawful abandonment. This sends a very clear message that the common carrier obligation is a serious one and one that cannot be ignored. On behalf of Roseburg Forest Products and the Coos-Siskiyou Shippers Coalition, we sincerely thank you for weighing in on the Coos Bay line situation and also for this opportunity to testify today. Thank you very much.
Thank you, Mr. Ford, for those very thoughtful remarks and for your personal report from the field and firsthand report on the situation. We are delighted to be joined this morning by both distinguished United States Senators from the great state of Oregon. Welcome, Senator Wyden and Senator Smith. It's quite a remarkable occasion for us to be joined by both of you. And we also had a few minutes ago, and he had to leave, but Congressman DeFazio was with us. And we'd like to now turn it over to Senator Wyden, and then following Senator Wyden, Senator Smith, for anything you'd like to say for as long as you'd like to say it.
Mr. Chairman, thank you very much, and to you, Chairman Nottingham, and Vice Chairman Mulvey, and Commissioner Buttry, thank you particularly for having a significant percentage of the Oregon congressional delegation coming today. This is a critical issue, as you can tell, for the people that we represent. At my town meetings in southwestern Oregon, this issue comes up again and again and again. And in our view, this board has the legal authority to secure a fair shake for the people that we represent. Obviously, the economic impact of an efficient rail system cannot be overstated. Across the country, diverse businesses rely on rail for timely and economical transport of goods. And an efficient transportation infrastructure is simply the lifeblood of our economy. Now, in today's environment of crumbling infrastructure and record high fuel prices, what's needed is more efficiency, not less. And in general, that's what the railroads provide. Many of the railroads are reporting record profits, reinvesting in their infrastructure, and doing a very good job of serving the economy and the public. Unfortunately, we do see some railroads reducing and restricting service, raising prices, and putting the squeeze on shippers in an attempt to maximize profit. In my view, the Surface Transportation Board is the last line of defense against unfair and unconscionable conduct, and we ask you today to step in and protect the public. The actions of the companies involved run directly counter to their common carrier obligations. And we feel that federal law is plain on this point. Railroads have a duty to provide service upon reasonable request. By federal law, a railroad may not refuse to provide service merely because to do so would be inconvenient or unprofitable. The common carrier obligation is critical to the fair provision of rail service in this country. And the fact is that even though the Congress has changed just about every aspect of how railroads are regulated, the one constant over all these years has been the common carrier obligation. As the Senate was debating the Staggers Act in 1980, Senator Tasselbaum, who helped write the bill as a member of the Subcommittee on Surface Transportation, said, and I quote, "I would like to make it clear that the attitude of the Senate is that the common carrier obligation is critical and must be strictly enforced." But now we are facing a time when, regrettably, some railroads have refused to honor this explicit legal obligation. And I think you've heard a bit from both Mr. Ford and Congressman DeFazio what this means for thousands of the people we represent. And let me just kind of summarize some of the concerns that I have heard at home. Rail America, of course, is a short line and regional rail service provider that, with its parent company, Fortress, currently owns and operates 7,800 miles of rail lines in the United States and Canada. One of these railroads, Corp, operates 439 miles of track, including 136 miles of the Coos Bay branch. Last September, as you heard, with essentially no warning, the Corp just announced that it's going to embargo the Coos Bay branch line between Coquille, Oregon, and Vaughan, Oregon, in our home state. Corp said the embargo was due to unsafe tunnel conditions which were the result of the lack of maintenance. Now, this is a vital shipping line for the entire south coast of our state. And so what we have is companies all over the region, in effect, scrambling to find a way to meet their obligations, to move their products and adjust their operations. So we've seen havoc all through our south coast economy as a result of this. And all of this is taking place during a time of great economic uncertainty caused largely by national conditions. You've already got a sense of what it means for one of our leading employers, Roseburg Forest. American Bridge is losing money and has been forced to abandon a planned expansion because of the embargo. We could take you through scores and scores of these kinds of examples. But the point is, our region does not need an economic body blow at a time when we are already seeing, as a result of national economic trends, serious concerns about where our economy is headed. Now, there's been great pressure from elected officials in our home state, and as a result, Corp announced that it had a plan to fix and reopen the railroad. Unfortunately, the plan was to demand $4.6 million each from Union Pacific Railroad, the Oregon Department of Transportation, the Port of Coos Bay, and the shippers. This money looks to us like it's vastly more than is required to repair the tunnels, and in effect would be used to upgrade the entire branch line. In addition, shippers such as Southport, which ships 70% of its product on this line, it's a forest products company, was asked to pay $204 more per carload, and along with 3 other shippers to guarantee that they would move at least 4,600 carloads annually for 5 years. Corp also demanded that the state of Oregon pay an annual fee to keep the railroad running. So let us now juxtapose these extraordinary demands that are put on key Oregon industries and our state with some of the other activities that we see Corp involved in. Corp and its parent company, Fortress, obviously isn't broke, and what we saw is that at the same time it was demanding an operating subsidy from the state of Oregon, Fortress loaned $24 million to Michael Jackson for his Neverland Ranch. With the money that was loaned to Jackson for Neverland, they could have upgraded the entire 136 miles of track to pristine condition and protected jobs for thousands of workers and their families by making transportation available and attractive for businesses along the line. That would have been in keeping with their public trust and their common carrier obligation. But in financing of Michael Jackson's property, it's made it clear to us that Fortress and Corp are somehow in their own Neverland, a world where others pay for their businesses' long-term infrastructure investments and the government directly subsidizes their business operations. So the question before us is, who wouldn't want a deal like that if you thought you could pull it off? Corp has also begun using similar business practices, apparently designed to maximize profits, even if they leave behind ghost towns on the Siskiyou line. Their Corp reduced service to a trickle and has asked shippers to pay rates 250% to 350% higher than is currently paid. If the shippers don't agree to the rate hikes, Corp has said it may simply stop operating the line. If the line is closed, the impact to agricultural shippers in particular will be quick and obvious. Freshness and quality of produce will be affected, customer expectations won't be met, and we will certainly see their profits go down. Now, the Corp claims that these incredibly high rates are to pay for $5 million in repairs to the rail system. But it's unfair and I would argue illegal for a railroad to require that customers pay outright for long-term capital improvements. These are investments that should be recovered by the business owner over the life of an asset, which in most instances for railroad infrastructure can be nearly 50 years. Now, I've written to the board about the Corp's actions, and we're pleased that the board is taking this action to investigate and to follow up. We appreciate your recent finding that the Corp must now show why their actions on the Coos Bay line don't add up to unlawful abandonment. We intend to watch closely and hope that the board will also investigate the Corp's actions along the Siskiyou line. But I discuss these examples not just to highlight the kind of business practices that extract profits and leave behind shells of what are potentially vibrant communities, but also to point out that some railroads are using embargoes and the threat of embargoes to subvert those common carrier obligations that are so explicit under federal law. It's my view the board ought to do everything in its power to enforce the common carrier obligation and to keep railroad lines, especially the short lines, open. Short line railroads save shippers 20% to 50% compared to truck transportation. They also take an awful lot of truckloads off the highway, which saves us a significant amount, an estimated $1.3 billion per year in highway damage costs. And compared to trucking, short line railroads save 356 million gallons of fuel each year. Railroads do face pressure to maximize profits. We want railroads to be profitable. I want it clear that we think having profitable railroads in our country is important. But we also want shippers on their lines to have decent and affordable service. In some cases, a desire for faster and bigger short-term profits has led some railroads to push aside long-term investing like maintenance of rail beds. When a railroad makes this choice, they cannot use it as an excuse to extort their customers by threatening to withhold service. Companies like Rail America act as if their only options are to force shippers to pay for infrastructure improvements or to close the line. But another alternative is to improve service and grow business. America's railroads and everybody else won't win if this becomes like monopoly with loads of players going bankrupt. Instead, rail companies have to look at shippers as partners in creating economic opportunity. When short lines work cooperatively with shippers and communities rather than scaring them into abandoning rail, they find that opportunities for growth exist. The Port of Coos Bay, for example, may provide more freight if cargo vessel operators are assured they can move the freight via rail once it gets offloaded. So in effect, we're laying out the case for the symbiotic relationship that works for the American economy and particularly for southwestern Oregon. Affordable pricing and reliable scheduling that attracts shippers. The current shipping picture isn't static and it isn't permanent, but providers and shippers must cooperate in order to improve market opportunities and grow the demand for rail service. The common carrier obligation is a vital protection for shippers who rely on regularly scheduled, reasonably priced transport. I think it's important to note that providing rail service is not a get-rich-quick proposition. It's a public trust. Railroads have long been considered to have public obligations, owing something more to the public than just the company's own business concern. As such, railroad companies have to take into account not only the bottom line of the company today, but also the repercussions of the local and national economy on operational decisions. We very much appreciate the board's holding of this hearing. I would ask that you consider the Coos Bay line embargo as a signal that a serious decline in long-term investment is around the bend. We cannot let that happen, and I would ask that the board use its power to ensure that railroads are performing their obligations to invest in their long-term needs. Again, we very much appreciate your giving us this opportunity. I assure you, you don't get so often this kind of turnout from the Oregon congressional delegation at a board hearing, but it reflects the concern that we see throughout our region. I've got a hearing in the Finance Committee I've got to be at, but you are in very good hands, Mr. Chairman, Mr. Vice Chairman, Commissioner Buttry. You're in very good hands with my colleague, and we just are grateful to you for your consideration and, again, would ask that you step in and take those steps that will protect our economy during this extremely vulnerable time, and I thank you.
Thank you, Senator Wyden, for that very compelling testimony. And as I know you need to leave, I just will repeat something that I said to Congressman DeFazio on the record this morning. This board will stick with this controversy and see it through to its rightful end, and we will be availing ourselves of every legal and regulatory tool we have to make sure the right thing is done. Obviously, we have a pending matter now. We can't promise any particular outcome. We'll see where the record and the facts take us, but this will be a priority, will continue to be. We have sent some of our senior staff already in the recent past out to Oregon to report from the front lines as to what's going on. We've had the CEO of Rail America here at my invitation on a few days' notice to meet also with Mr. Ford and some of his colleagues in an effort to informally avoid having to be here today talking about this today, and that was a few months ago. And so we will have Rail America before us at this hearing too. So stay tuned. There'll be much more coming out on this, and we look forward to working with you and your very able staff. And thank you again for being here.
Mr. Chairman, your message today makes us hopeful, and the fact that you are willing to involve yourself in this kind of direct fashion is something I very much appreciate, and the people I represent do as well.
Thank you.
Thank you.
Thank you. It's now my honor to introduce Senator Gordon Smith. Senator Smith, the floor is yours.
Thank you, Chairman Nottingham, and members of the board. I certainly echo the sentiments of my colleague, Senator Wyden, and I do want to note that it is probably rare that you get 2 U.S. senators and a congressman from the representative district before you, but I think it is an indication of how urgent we feel this matter is, and so we do take your words of attention on this issue with appreciation, because this is a very vital issue. And we are here without regard to a party or without regard to parochial interests between urban and rural kinds of differences. We're here in a united way because we feel so keenly about this issue. The last time we were together, Chairman Nottingham and Commissioner Mulvey, I was behind the dais and you were in the witness chair. Today those roles are reversed. Unfortunately, after all these months, the topic of our discourse on that occasion before the Senate Commerce Committee is the same, that being the Central Oregon and Pacific Railroad, or COR's, ongoing embargo of the Coos Bay rail line. As a member of the Senate Commerce Committee and ranking member of its subcommittee for surface transportation, it is my privilege and my responsibility to work on issues affecting the rail industry and its partners. And my congressional record, if anyone cares to check, is one of staunch advocacy for a vibrant railroad industry. I believe a healthy railroad industry is absolutely vital to our economy. I understand that railroads need to earn adequate returns if they're going to continue to serve the public and provide the capital investments necessary to meet our future transportation needs. However, I want to emphasize this point. I also know that buying a railroad is not like buying a fast food chain. There is a responsibility to serve the public that comes with owning a railroad. We talked in that commerce hearing, Mr. Chairman and members of the board, about the tendency now for hedge funds to buy railroads. And I respect the profit motive. I think it's essential if they're going to stay in business and make the capital investments. But I also want to note that those who buy railroads cannot just look to a short-term hit because there is a long-term responsibility. Unfortunately, after months of watching events unfold, it seems clear to me that COR and its parent company, Rail America, are not interested in meeting their obligation to the shippers on the Coos Bay line. Mr. Chairman, members of the board, I live in a rural place of Oregon, and I know what it feels like when you see a rail line abandoned, and I know how frustrating it is when that occurs not for what are obvious economic advantages, but to some predetermined conclusion that they will simply continue to or not invest in a line and its maintenance. I know the board is familiar with the circumstances surrounding the embargo, which the board lays out in its April 11th decision. So I won't belabor that point. I think others have done that very well today. However, I do want to focus for just a moment on the issue of deferred maintenance, and more specifically the railroad's obligation, consistent with its common carrier obligation, to maintain the track and tunnels. Commissioner Mulvey, during your renomination hearing last December, I read to you an excerpt of the Federal Railroad Administration's inspection report on the safety of the Coos Bay line. I'd like to again read it because I think it makes it very clear what we're talking about. According to FRA's inspection report from last fall, this is the quote, predominant problems observed were decay of untreated cinder timbers, lagging and footing blocks, The FRA's inspectors noted that some of the timber sounded hollow and decayed when struck with a hammer. End of quote. Now, clearly, this situation did not happen overnight. As the board rightly points out in its April 11th decision, this was not a situation of CORE being caught off guard. They had ample time to study the problem and take corrective action before embargoing the line. They chose not to do so, and instead have engaged in a slowdown with the state and the shippers, trying to extort financial commitments from the public. Mr. Chairman, it has been more than 7 months since the embargo on the Coos Bay line. And unfortunately, it seems that we are no closer to seeing the line reopened than we were last September. I believe that this is a clear misuse of the embargo process and would set a horrible precedent if the railroad is allowed to shirk its common carrier obligations by allowing the line to slip into a state of disrepair and halting service until others come up with the financing to repair the line. This line provides a critical transportation link for communities in southwest Oregon, and CORE's inaction is literally putting hundreds of family wage jobs in our state at risk. I'll let Alan Ford, I think he already has described the impact of that to his workers. It is very, very serious to him, his businesses, and other Coos shippers in the coalition. I cannot stress enough the importance for the STB to take the appropriate action to restore service to the Coos Bay rail line as expeditiously as possible. The economic toll and job loss over the past 7 months have been unacceptable and cannot continue any longer. I realize that this hearing is about issues broader than just the embargo of the Coos Bay line. However, I could not let the opportunity pass without again making the case for the board to take quick action to force an end to the embargo. I believe that we are far past what could or should be considered a reasonable period for CORE to show progress towards making the repairs to reopen the line. The board has the authority to rectify the situation, and I hope you will do so quickly. I await the board's next response to the Coos Bay rail line enclosure. I thank you for your time this morning.
Thank you, Senator Smith, for your excellent remarks. If I could just follow up with we won't keep you here long, but just a question or two, if your time permits. You've been tracking this controversy as closely as anyone. Clearly, you're right. You raised it very directly and emphatically with me when I was last before the Senate Commerce Committee, as you rightfully should have. And I know you reiterated your concerns when Mr. Mulvey was before you more recently for his renomination confirmation hearing. Have you, in your close monitoring of the situation, have you heard about any progress, any procurement activity, any bidding, any engineers writing up, kind of doing the advanced work that you can do? Frankly, you can do in rain or shine. You can do it in an office to get ready to actually do the nuts and bolts engineering that would need to be done to actually get those tunnels restored.
I hope it's occurring. If it is, however, I have not been informed of it.
Okay, and we'll be asking that question to others too who may have more firsthand knowledge. But you're also, as you mentioned, very much on the front lines on the Commerce Committee as a leader there in the debate about the future of the railroad industry, how it perhaps should be regulated or not regulated. A situation like this, what does it do? A controversy like this, how does it impact the Senate in deliberations? Does it make it? I mean, in many respects, this reflects. Sadly, it's one railroad, but it reflects. Could reflect. It occurs to me on the broader industry, and you're there in the front lines. How does it play in the Senate?
Well, in the cloakrooms of the Senate, frankly, the concern is arising over the role of hedge funds in buying these private assets, which are attached to public responsibilities. And the concern is that perhaps there is a view by some in financial industries and hedge funds that they can make some quick killings by buying these properties, carving them up without regard to common carrier obligations, pulling money out and putting in other places where they may think that there's a higher rate of return. Again, I respect the profit motive, And I know how important our financial instruments are and institutions are to the functioning of our economy. But I will also want to say that those who buy these kinds of assets do so subject to public obligations. And the same calculations that may be made with respect to a fast food chain cannot be made with respect to a railroad because there is such an overriding public responsibility. So those who are looking to turn a dollar fast, I think better think again about how they look at railroads, because there's an entire governmental apparatus that's very concerned with the folks at home who depend upon their job continuing by the continuance of railroads. And we need people to invest in railroads, but we need them to understand that the long term, not just the short term turn of a dollar.
Thank you, Senator Smith. Out of respect for your time, Senator, I'd like to turn it over to Vice Chairman Moley for any questions you may have of the Senator, and then also to Commissioner Buttrey after that, and then Senator, we'll let you leave if you need to after those questions, or you're welcome to stay as long as you'd like. We'll be here for 2 days. I imagine you have some other things on your schedule, but just you are warmly invited.
I'd be honored to answer any questions you have.
Thank you, Senator. When I first came to the board, I was under the assumption that the common carrier obligation for railroads was pretty absolute. I've been informed that that's not true, that under staggers, that the common carrier obligation only applies to traffic that is regulated by the board, and for other traffic there has to be an exemption given, revocation rather, of the exemption in order for that to come under the common carrier obligation. And given that, do you think that there's a role here for the Congress to play in perhaps changing the law to broaden the common carrier exemption without going to the extreme of re-regulating the railroads?
I do think that there is considerable interest on the Commerce Committee to look at that. Look, I didn't come to Washington to re-regulate things. I believe in modest regulation, but I also understand public responsibility. And my own view is that we should be careful as we do this, but I also know I have many colleagues who want to re-regulate the railroads. I do not. But I also want those who own them to understand that we have a responsibility to the broader public. So if they're serious about staying unregulated, I think it's very important that they get more serious about serving the public. And that is my word of warning. And so I would simply say to all those who want to invest in railroads, understand that it's a long-term investment, it's a good investment, it's a capital-intensive investment, but that our nation's need for more, not less, railroads. And as a parenthetical, I would say if you re-regulate railroads, you'll get less investment. You'll have less capital to improve and expand our railroad system. That's why I'm not here to re-regulate them. But some of the modest tinkering you're talking about in terms of common carrier obligations, yes, I'm interested in that, because I don't want to go the next step of total re-regulation, because that is the wrong incentive if we're serious about projecting and meeting the future transportation needs, the freight needs of this country. They are growing, they're not diminishing. And so we need those who come to the table to understand there's profit to be made in railroad, but it's long term, and it takes a commitment of a career to make this happen. So the quick buck artists on Wall Street who want to look at railroads as a turkey to be plucked, I'm sorry, that's not going to happen.
Thank you.
Commissioner Buttrey?
Senator, I'd just like to add my word of welcome.
Thank you.
To you here today, and we're certainly glad to have you here and to hear your comments. Obviously, your presence here today says a lot about how you feel about the importance of this issue. We know it's on your mind and the minds of a lot of other members of Congress. I just wanted to tell you that, and I wasn't aware of this either because I haven't been here a terribly long time and won't be here for a terribly long time. But in any case, my understanding is that for the board to issue a show cause order in a proceeding is a somewhat rare occasion. And I think it says something about our commitment to getting into this matter very seriously and in depth. To see it through is an indication of how we feel about that, the fact that the show cause order was issued. And I can certainly add my word of assurance to what the chairman said about the fact that we're going to stick with this and see it through.
Thank you, Commissioner, and I commend you for that. And thank you also very much for your public service and for your attention to this vital issue. Coos Bay is in southwestern Oregon. It's rural. It's beautiful. There are great people who live there. I'm from northeastern Oregon. It's beautiful. It's rural. We depend on railroads, and we need owners of railroads who are real serious about us because we're real serious about them.
Thank you, Senator Smith. I know it was not in your testimony, but I do need to take note. This may be at first. You know, the Interstate Commerce Commission was the first regulatory agency in the government. We're the successor agency, STB. We've had probably, safe to say, into the thousands of hearings since the 1880s when the ICC was stood up. And but I'm hazarding a guess here. I haven't checked this out yet. Haven't had time to. But your colleague, Senator Wyden, invoked Michael Jackson and Neverland and Fortress of Investment, and I think we've plowed in some new territory there.
Well, we're trailblazers in Oregon. The Oregon Trail leads in interesting places.
Usually our friends on the Federal Communications Commission get all the sexy movie star type issues, and we're relegated to things like cost of capital and standalone railroads and exciting things. But this has been, if you see Senator Wyden, I couldn't say this before he had to rush off, please thank him for putting a little spice into the proceedings. But he did raise a very good point with that, too, as have you with your testimony, and we really appreciate your service, and we look forward to working with you and your very capable staff.
Thank you, gentlemen.
I was going to mention, too, if he had stated that he was not thrilled with Fortress America's investment strategy.
We're thrilled to be here.
Thank you, Senator. I think we'll probably have a couple questions for Mr. Ford while we've got you. Thank you, Mr. Ford, for your patience, and welcome again. Let me ask you the same question I asked the Senator. Have you heard about any progress in preparing the way for reopening the tunnels?
Not specifically, just via the grapevine. We understand there's plans to do so, but it's our understanding, and perhaps your questions are better directed to people from Rail America, that everything's kind of on hold pending the resolution of the outcome of whether or not they get what they are asking for. We're not aware there's any active activity taking place at this time.
You seem to have a very good relationship with your elected officials across the state, from the governor on down, as understandably you would as a major employer. You probably have a better read on the sort of the political and policy landscape there than we might, but we follow it closely now, of course. Corp seems to have come back over and over again with offers or these cost-sharing offers we've heard about, sort of 1/4, 1/4, 1/4, 1/4, or things like that. Do you sense, I mean, my read of the governor, for example, is that he's pretty clear. Reopen the tunnels, get the line moving, and then we'll talk about a partnership. Do you see that changing? Because the position seems pretty clear here, but you may be you are closer to it. I want to get your sense.
Well, certainly I don't sit in the governor's office, but I think the governor just forwarded a letter to Corp here very recently, I think it was last week, stating that he was staying with his position. I may be reading into what the governor is saying, but I think the governor is looking for a commitment from Corp to they make the move, and then the state is willing to sit down and discuss it. Obviously, the governor cannot sit down and say we can obligate through bonding or other financial arrangements at this time. The governor has to go through a legislative and regulatory process. Also, the proposal that's been made by Rail America that involves support of Coos Bay, they have a process to go through, and certainly as a shippers group, we have to, so to speak, sit down and see what we can do. But I think I can express that people are willing to step forward to help, but we need an indication that Corp and Rail America are willing to do their fair share, and I think the governor has staked out very clearly that his expectation, the first thing they need to do is show movement in getting that line back into operation. I may add to this, I think politically and otherwise in our state, You have to understand Coos Bay is a beautiful port facility. I think Congressman DeFazio talked about the potential, he's talking about containerization, whatever. But also, you asked Congressman DeFazio the question about the nature of the market. It's a difficult time in the wood industry. But it's also a transition time for Coos Bay. What's happening, we're seeing a lot of reinvestment, people stepping forward. Our company is an example. We just invested $20 million in modernizing our operations, a brand new mill that Southport built in. They're over 20, I think they're 35 million or something like that. And you heard the story about American Bridge. So here you have a facility that's really first class, has a tremendous potential. It's on the move. And then, in this particular situation, what we perceive to be a very abrupt process, boom, we feel like the rug's been pulled out of us. So a lot of people were really quite shocked in the way this was handled. Now, hopefully that can be resolved, but I can assure you that certainly from a shippers and a community standpoint, we're willing to step forward and do our fair share. But I think we're watching our governor and our elected representatives, Senator Smith and Senator White, and they are very engaged in this. This is a very key issue in our state.
Thank you. And I've worked for a governor in my past, and it seems to me, from a policy perspective, it's an interesting proposition that Corp makes. Underinvest in your infrastructure for 10 years or longer, then shut it down, and then ask to be rewarded with a huge public subsidy. What kind of message would that send to you? You operate major equipment and facilities. That's a pretty good deal. Would you like to not invest for 10 years, shut down your facility, lay off hundreds of people, and then announce that you're deserving of millions of dollars of contributions from the taxpayers?
Chairman Nottingham, I certainly share that opinion. We certainly are shocked. We appreciate and understand there's some work that's required, but frankly, maybe it's just our perception, but the attitude and the willingness to work with us in partnership and resolving this crisis, we just haven't seen that. It's been very confrontational, very much, I don't know, it's a role of the lawyer. Our expectation is we need to sit down and work this thing, and it's too important to let go. But your point is very, very valid. So far, it seems to be very much a one-way street and no interest in participating and trying to work out a partnership.
Mr. Ford, I want to make sure while you're here you do understand. I think you do, but just while we're here on the record and we have a room full of interested parties and spectators. Of course, one outcome, possibly, I can't predict or I'm not promising by any means an outcome at this point in this pending controversy, but one outcome, as you know, I believe, could be that the line could be abandoned. In fact, the railroad, could very well announce that the big bad STB forced us to do it, and what a tragedy that might be, and that raises the possibility of some additional time of lack of service there. And do you think that you and your colleagues are sort of ready to face that possibility if it had to come to that? I mean, is it something that you're mindful of, that's one possible scenario as we explore this issue?
Well, certainly, I guess you look like that's a voice of doom to say that we wouldn't have rail service to Coos Bay. Some of us have some alternatives. The economics are such that we would obviously pull investment out of the port, and Coos Bay, it's just not going to work economically. For previous to this point, we thought we had a future. But in saying that, our willingness to you call it to the extreme of shutting the railroad clear down, and whether or not there's something in between, I think the shippers and certainly in the coalition and those communities, again, we're very much community oriented because we are in a rural area, to work with the railroad. I think we'd step forward. What that looks like and how that plays with the Surface Transportation Board, I'm getting in an area I don't belong in. But all I can tell you that we are very, very concerned. It's putting a terrible cloud over our economic future in this given area. I think one point I would like to make, an example like American Bridge, they just had to totally almost stop. And we've had a lot of shutdowns because the economics are so bleak, even some of the plants operating there. But people are looking for a long-term solution. We're not looking for a Band-Aid. That's the worst thing we do because all of us are investing in long-term investments that are looking at 10, 20 years. And we are looking for a permanent solution, not just the Band-Aid. So if that means we have to shut it down, I sure hope we don't have to go that route. I think there's a tremendous future in this area, and I'd hate to see that happen. but we understand that's a game playing. But again, we're looking for that long-term solution.
Thank you, Mr. Ford. That concludes my questions. Vice Chairman Moley?
Thank you. There's been a lot of discussion lately in Washington about public-private partnerships, and what that has mostly meant is increasing roles for the private sector in providing services that are typically provided by the public sector. And this, in some ways, is kind of the reverse of that, where we're looking for the public sector to help out the private sector and make investments that normally are made by the private sector. There's a lot of railroads, a lot of short line railroads around the country that are low density lines that have some of the same problems that CORE has in Coos Bay. Do you have, based upon the experience you've had in the last few months, do you have any opinion as to whether or not there needs to be a greater role for communities, state and local governments, groups of shippers to acquire these lines and operate themselves rather than rely upon these traditional short line railroads?
Well, if you put a gun to our heads and you say that's the only option left, sure, we're in favor of it. But I would strongly agree with what Senator Smith said, that we would much rather stay with the private entity. The concern we're seeing, there's been a tradition, though, is the long-term perspective of railroad management. And what we're seeing is this point about turnover, and we have to have look for returns in the next 6 weeks or the next 3 months. That is counter to what typically has been the style of management we've seen in the rail service area. So my preference certainly is that we would stay with a private operator, but with a private operator who would, frankly, his decision process was fairly, we can work as partners, and if there's a problem, we work it out together, which frankly we have in the past. But it seems to be the trend line in the most recent 5, 6, 7, 8 years that especially with the turnover of ownership taking place on the short lines, that the investment and maintenance has just gone to nothing. And they're just running appears to be from our perspective, running into the ground. Does that require the state and or a public body of some sort to get into the operation with the intent they have a longer term perspective? They can bring the social values to bear where needed. If you give us a choice, we'd have to go that route, but our preference was certainly not to go that way.
Thank you.
Mr. Buttry?
No questions.
Thank you, Mr. Ford. That concludes our time with you today. Thank you again for coming all this way. We hope you can stay as long as you can, but we also wish you safe travels as you head home as well.
And thank you very much, gentlemen. Appreciate the opportunity to be with you today. Thank you.
We'll now call forward panel 2, Mr. Richard Weicker, Mr. Michael Hemmer, and Mr. David Reeves. Welcome, panel 2. We're pleased to have you with us today. Our first witness I'd like to call on is Mr. Richard E. Weicker, Vice President and Senior Regulatory Counsel of the BNSF Railway Company. Welcome.
Good morning. Thank you, Chairman, Vice Chairman, and Commissioner Buttry. It's a pleasure to be here. We appreciate your giving us this opportunity. I will go through some overview concept slides and discuss some of the issues that we have seen in the order. I have read and skimmed through many of the statements filed in advance and summaries. I don't know that I've read every one of them, despite a good effort, but I'm working my way through them. we do see certain themes that we think it's important to place into proper context. And I would like to add, as the first railroad panelist after the first 2 hours of the morning, my name is Richard Weichler with the BNSF Railway. We operate in the Pacific Northwest, but have nothing to do with the past, present, or future of the serious issues that were discussed earlier this morning. And I will be talking about issues of railroad investment, but I'm making no inferential or otherwise comments on any of those other issues. The themes that we hear echoing that appear to be directed at BNSF and that echo in the board's orders are issues of service to our grain and agricultural customers, our service and capital investment more broadly across our system, and the offerings we make. And first, I would like to say, as a general matter, you've seen the and already quoted the reasonable request standard for service. We would certainly admit that rail transportation in this country is not 100% perfect, but we think that we are serving our customers remarkably well. There may be limited numbers of shippers who do not see the system working as well as they think it should, or have all the service they might wish all the time for all kinds and degrees of service. But having said that, we think we're seeing a somewhat different thrust of arguments in many of the commentators. Less discussion than in past years of do they have all the alternatives they would like with truck or barge, and more almost implicit assumption that they are asking for or requesting unilateral assurance of virtually unlimited rail capacity in any quantity, whenever and however it might be needed. We at BNSF are driven by market demand. We do not believe the law requires that one invest in non-economic capacity or to make service available for anyone at any time, but we have very aggressively invested, and we look for those opportunities. In the past 10 years, we invested $24 billion in our infrastructure. Last year, $2.6 billion, and we're investing across the board. And sometimes in these dialogues, it's each group saying, oh, well, where are we compared to the other one? We've invested aggressively in coal service capacity, including to deal with prior service issues and meet growing demand as we move record volumes. We've invested aggressively in intermodal capacity, including in the late 90s when our company was criticized for investing for traffic to come, that we were overdoing it, and we have continued to invest and continue to look at new facilities and track capacity on our transcontinental main line, and in agricultural areas where we've invested to make possible the movement of the tremendous volumes we move and the infrastructure to serve shippers in ever-increasing volumes. There are some themes in these comments that, including from people we work very well with, like Washington DOT, that perhaps there should be equalization of investment or investment in short-haul moves that don't make economic sense. We don't believe those are the ways railroads should invest. And I have to add with Washington State that we have excellent relations with them, as I spoke with Mr. DeWitt this morning. And I've spent a lot of time out there working with Sound Transit in King County and Port of Seattle, and that's the closest to the Pacific PNW issues you've got on the calendar today that I would get. If I may, turning to our next, we have also, we believe, pioneered and expanded a number of tools for maximizing the utilization of capacity through market-based offerings. And I will spend some time this morning to talk directly about a couple of the areas that are mentioned in many of the comments. These are our so-called COTS logs. We have a program that I know the board is familiar with and has historically been before them, the Certificate of Transportation Program, which is a mechanism that allows customers to bid on and get future equipment commitments with, if they choose it, rate protections. This is something that is, it has a history before the board. It is common carrier service. It does not limit the options for a shipper. We will move traffic in all different ways for all different kinds of varieties, but these are the kind of tools that have helped us better plan logistics and improve efficiency and manage our corridors. It's expanded over the years to programs that we, in other commodities, our so-called LOGS program, Loading Origin Guarantees, for center beam flat cars, box cars, gondolas, other kinds of equipment. We think these, relating to some of the questions you raised in your order, are areas that encourage shipper involvement in planning with us and give other options and expand common carrier options for everyone. Another area that's mentioned by many of the commentators in our ag area are shuttle trains and how they impact the movement of grain. We think these programs, which do provide price incentives for volume shipments, referred to in the board's orders, they give us the opportunity to provide price incentives for economies of scale in our business and the grain transportation business. They do properly involve infrastructure requirements by us and the shipper. They are not offered to the exclusion of smaller car volumes or shippers' options at all. And if I could turn to our slide 5, this shows since 2005 the growth in unit trains on our system and shows singles as well as units. We are proud to say that it's all increasing. We are moving more shuttles, including in some years in relative terms. We are moving more single car shipments. And most of all, through the efficiencies in the planning and the investments in our infrastructure, our velocity has been excellent, not always, but moving record volumes with powerful concepts that help us move more and more ag and ag products for our customers. This also indicates that these programs do not, as sometimes accused, disadvantage the non-participants. They help the whole system. They help the whole system be fluid. If you choose to be in them, you have great advantages. If you choose not to be, you still have common carrier service. It's all common carrier service in our ag segment. Similarly, in the next slide, our grain fleet capacity. I speak for BNSF. I know railroads accused of investing in this, not investing in that equipment wherever. We have been aggressive investors in infrastructure, in our plant, in locomotives, and in cars, including covered hopper cars. As we show in our annual report, our fleet increased approximately 3,000 cars 06 to 07. We have a general fleet. We have a shuttle fleet. We've grown it all. You hear the comments of you can't have everything for everyone at all times, or the Easter Sunday analogy, but we have grown aggressively in this area, both in terms of investment and the capacity through velocity and productivity of what we can move for shuttles, as well as the general fleet, as well as the folks out who are not using shuttles or who do not have the volumes for those kinds of movements. With respect to the service issues that the board raised in its order on embargoes and abandonments, the board has well-established principles for this. There's industry practice. We believe we have used embargoes judiciously and carefully in accordance with the procedures, and we follow the rules on abandonments, and believe that we fully intend to continue to work within the spirit and the law of those processes. With respect to the scope of the common carrier obligation, it is on reasonable demand. It's not universal for everywhere. I will say a word or two about exempt traffic. It is true that the common carrier obligation doesn't generally apply to exempt traffic that has been properly exempted by the STB and is subject to revocation if there were a reason, or the board wanted to look at the revocation on, looked at the exemption on the particular widgets in one of the columns in CFR. It has that right. In that sort of way of the dialogue you had somewhat earlier this morning, all of our traffic is common carrier traffic in that residual sense, and the exemptions are properly justified by competition. We intend to continue to invest as long as demand justifies. We ask the board not to limit the price flexibility for us to do that. And I will stop.
Your time's expired. If you want to take 30 seconds to wrap up, that's fine, but we do need to move along.
we appreciate the opportunity. We will continue to respond to increases in demand as best we can if the market permits us and the system permits us. Thank you.
Thank you. It's now my privilege to introduce Mr. Michael Hemmer, Senior Vice President for Law and General Counsel at the Union Pacific Railroad Company. Mr. Hemmer?
Thank you, Mr. Chairman, Mr. Vice Chairman, Commissioner Buttrey. I have relatively few slides. It's about 30 years ago that I had the privilege of sitting in on a conversation among the court-appointed bankruptcy chairman of the Penn Central Transportation Corporation and some other experts in the rail industry. And the topic of that discussion was, what's the future of this industry? With that kind of rail operation being pretty prominent, especially in the East, it was a pessimistic forecast. We imagined that the railroad industry by the year 2000 would be a skeleton of its former self, handling some coal and some grain, and that would probably be about it. What a delight that we're here. What a delight that we're having this conversation. America recognizes that it needs railroads. We are here really because of the fact that the need for railroad service has expanded and is projected to continue to expand in a secular increase. It's true that in the short run there is a softness in the economy right now, and that's given us a little bit of breathing room, but we hope the economy will recover, and when it does, we expect demand to continue to grow and to put pressure on our investments. Union Pacific, unfortunately, has demonstrated rather publicly what happens when a railroad has more traffic than it can handle. In late 2003 and early 2004, as is well known, we were caught by surprise by a surge in traffic. We didn't have all the resources we needed, and the impact was clear for our customers and for us. It was expensive for us. We had congestion in a number of places. Our service declined, and we didn't perform all that well, either financially or for our customers. Since then, we've been a good deal more careful and thoughtful and disciplined about the way we manage our capacity. We've tried to forecast with our customers as well as possible what future demand will be and how we can meet it. We have developed a substantial number of new operating techniques to maximize the efficiency of our service and the quality of the service. We've invested in new technology and new operating practices, and most importantly, we have invested more than anybody else. We have been investing at a rate, as shown on this map, of about $3.1 billion a year. We target that again this year. For those who are concerned about whether we're committed to maintenance, about $1.6 billion of that investment is capital investment in maintenance, excuse me, to keep our tracks and bridges in good condition. In addition, we are investing in new capacity throughout the system. Some of that investment is in the Powder River Basin and on other parts of our coal network. We're investing in areas that generate ethanol traffic. Down in Texas, we're investing for removal of bottlenecks that could affect our chemical transportation. And, of course, we're investing in our Sunset Corridor, where we're adding double track between El Paso and Los Angeles. This is a very strong commitment to the future by this company, and we believe that we can get the returns on this investment. As long as we believe that, we'll continue to make them. These efforts, all of which I've summarized here, have made a difference. I've decided to show you our southern region service metrics. This eye chart's a little bit hard to read, but basically what it shows you is on a number of basic measurements of service quality, we are at best ever levels in our southern area. And whether or not anybody will be prepared to admit it today, in many of our meetings with customers in that area, they are reflecting that level of service. Our commitment is to try to continue to maintain it by matching capacity with the volume that's coming at us. I'd like to talk for a moment about embargoes. Union Pacific has used them extensively, and we've acknowledged that in our filing. We've explained that we've had very significant successes with those embargoes in eliminating congestion in places where the combination of our efforts and our shippers' efforts otherwise wouldn't have succeeded. We have not used embargoes in the way that has been most problematic for the board and for the ICC, and that is to avoid making investments in lines to keep them up to serviceable standards. On the contrary, as you know, we are spending right now something on the order of $75 million with 200 people working 18 hours a day and hundreds of pieces of large machinery to literally move a mountain in Oregon and keep our main line through Oregon in operating condition. There have been some comments about the long embargo that Union Pacific adopted in the Powder River Basin, and I think a lot of those comments are speculation and misleading. It is true that we had an embargo that began when the Powder River Basin literally melted down during some weather conditions. We did not do that, as some have speculated, in order to restrict capacity and increase prices. Quite the opposite. We would love to have carried more of the coal demand that was out there. It was very attractive business. It was more attractive than the business that we had already committed to handle. But we believed that our obligation was to handle the commitments that we'd already made, including those customers' growth projections. So we put on an embargo to avoid taking on business that we could not handle. We treated the customers who paid low rates the same as the customers who paid high rates. We treated the customers who had contracts the same as the customers who were using tariffs. That was what we believed was our reasonable obligation to discharge our duties to our customers. I'd like to leave, if I may, a few final thoughts with the board and some recommendations. This proceeding is very important. Assuming that the predictions by the Department of Transportation, AASHTO, and other outside observers are correct, over the long run, the industry will need to invest very heavily in new capacity, and even that may not be enough. As a result, it will fall to you to make decisions about how to deal with capacity shortfalls when they arise. Our recommendations to you, if we may be so bold, are four. First, please try to keep in mind that it is crucially important to protect the rail network's capacity to maximize service. It is possible, for example, that the public will benefit most from actions that do not benefit a particular customer at a particular place on a given day. You'll be asked to weigh those considerations. Secondly, we urge you to recognize the complexity and the integrated character of a railroad network. Quite literally, if we were obligated tomorrow to start serving from our main line headed northeast out of El Paso, a shipper that required a lot of daily service, that would cause auto traffic going to Phoenix to be delayed. It would cause transcontinental intermodal shipments to be delayed. It would delay shipments of chemicals between Texas and the West Coast. And I believe CSX tomorrow is going to give you a physical demonstration of why that problem arises. So we ask you to keep in mind the need to protect the network. Third, we would love to have some simple bright line rules to give you, but on the contrary, our recommendation to you is that each of these instances will be very fact specific. It's important to understand the difference between putting a new shipper adjacent to one of our branch lines in Iowa and putting that same shipper next to our quadruple track main line west of North Platte, where we're running a train every 6 minutes and also trying to maintain the track. One of those isn't going to have serious adverse effects. The other one could be catastrophic. So we urge you to focus on these fact-specific considerations. Finally, we want to point out that your customer assistance program works, and you're reorganizing it to strengthen it. It brings together customers and railroads. It gives us a chance to learn from each other. We have changed our minds about some of our actions because of what we've learned through that process. And we urge you to consider whether that should be a step that is always taken before the board gets involved in a formal process involving common carriage. Thank you very much for listening to my comments.
Thank you, Mr. Hemmer. We'll now hear from Mr. David C. Rees from the Kansas City Southern Railway Company.
Chairman Nottingham, Vice Chairman Mulvey, and Commissioner Buttry, good morning.
Hold that mic right in front of you.
All right. Is that better?
Much better, thank you.
All right, thank you.
Getting old and hard of hearing.
I'm pleased to be able to offer these comments on behalf of the Kansas City Southern Railway Company. KCSR welcomes this hearing and the board's examination of the meaning of the common carrier obligation in today's environment. KCSR strongly believes, however, that the board should avoid any pronouncement of a one-size-fits-all standard for what is and isn't a railroad's common carrier obligation, and should continue its policy of considering these matters on a case-by-case basis. For the record, KCSR has joined in the comments filed by the Association of American Railroads. Accordingly, I will limit my remarks to issues of capital investment, the distinction between disputes about rates and about the common carrier obligation, and the burdens of handling TIH shipments. One of the issues raised by the board's notice of this hearing is what service limitations, if any, a railroad can adopt in the context of a capacity-constrained environment. Another way to look at this issue is to ask whether a carrier can tailor its network and operations to maximize the efficiency of its rail network for the vast majority of the shippers that it serves, or instead must be subject to deploying its assets and changing its network solely to accommodate random requests for service, regardless of the impacts of those requests on the overall shipper community that the railroad serves. Recent studies show that the demand for freight rail service will continue to grow, requiring more and more capacity. KCSR is already doing its part to use its revenues to build capacity for the future. In 2008, Kansas City Southern, the parent of KCSR, plans capital expenditures of approximately $529 million for new infrastructure and equipment, plus another $111 million in new locomotive and equipment lease programs. The KCS 2008 capital expenditure program represents approximately 28% of KCS's expected revenues. Over the next 5 years, KCS's capital spending is projected to average approximately 20% of its revenues. This compares to capital spending of about 3% by the average U.S. manufacturer. Infrastructure and capacity drive the ability to provide service. Through its capital spending program, KCSR is committed to doing its best to meet the demands for service placed upon it by its shippers. Sometimes the shipper requests a certain level or type of service that it believes to be reasonable, but that the railroad cannot meet due to capacity constraints or the needs of other shippers. That shipper may complain that the railroad has failed to meet its common carrier obligation because it did not provide what the shipper asked for. Meeting that shipper's particular need, however, could mean that several other shippers' needs would not be met, potentially leading to complaints from those shippers that the railroad is not meeting its common carrier obligation to them. Thus, railroads must plan their capital spending and design their service plan to meet the needs of those shippers who are most using the system, even if this means an individual shipper may not always be able to obtain the level or type of service that it desires. Designing a service plan that accommodates the needs of most, yet being sensitive to the needs of the individual shipper, is not an easy task. KCSR works with its shippers to achieve the type of balance that is necessary to ensure that adequate capacity and corresponding service levels are available now and will be in the future. Nonetheless, even KCS's plan to expend capital at almost 6 times the average rate for U.S. manufacturers does not guarantee that its system will have the ability to meet every request for service. As such, there are going to be instances in which shippers that do not receive the level and type of service that they want complain to the board that the common carrier obligation has been violated. In such cases, the board needs to carefully evaluate the specific merits of that particular case, and to do so in the context of the overall needs of the entire rail network. Any attempt to resolve such issues without such a case-by-case approach would be flawed and could lead to long-lasting harm to future capacity and service to other shippers. I would briefly like to address the distinction between disputes about rates and disputes about the common carrier obligation. As has been stated already this morning, the common carrier obligation stems from 49 U.S.C. 11101. That section imposes no substantive standards or requirements regarding the level of rate quoted or the frequency with which the railroad must provide the service. Those issues are covered by other provisions of ICTA. The distinction between these different statutory provisions is important. In fact, some parties in this proceeding will try to use the informal nature of this hearing to air their specific service or rate complaints, rather than to file specific complaints or to follow the board's statutory, regulatory, and evidentiary processes, or to use the informal program that Mr. Hemmer referred to. It is neither possible nor appropriate to try to refute the specific allegations in oral comments at this proceeding. In the context of this proceeding, therefore, the board needs to carefully ensure that it will not adopt any policy or pronouncement that would allow complaints, which are really about the level of rates, to be treated under the procedures developed to resolve complaints about a failure to abide by a carrier's common carrier obligation. Finally, I would like to address KCSR's views regarding the transportation of highly hazardous materials, especially so-called TIH. Despite the rail industry's outstanding safety record in moving TIH materials, the risk of even one accident related to TIH materials is potentially devastating, especially for smaller carriers. If a carrier attempts to account for this risk through its rates, it may be subjected to a rate complaint. However, the board's rules for simplified standalone cost cases and 3 benchmark cases do not provide a carrier with an opportunity to recover the particular costs associated with the risk of transporting TIH materials. A rail carrier can thus be stuck carrying TIH materials at terms that do not fully account for the extreme risk of the release of such chemicals. This situation should be corrected. Certainly, improving the safety of transporting TIH materials is an important step. KCSR therefore supports the industry's efforts to establish new standards for tank cars carrying TIH, to cooperate with communities that are developing and evaluating emergency response plans, providing training to emergency responders, and to improve necessary information flow. KCSR also supports efforts to replace TIH materials with safer product substitutes whenever possible. Nonetheless, despite these efforts, as long as a carrier must transport these materials as part of its common carrier obligation, the risk of a catastrophic accident remains. As such, KCSR believes the board needs to carefully examine the numerous issues surrounding the transportation of TIH material and develop regulatory or legislative solutions. In particular, others have suggested a separate proceeding, I believe, on that subject, and we would concur with that. KCSR has always understood that the common carrier obligation required KCSR to provide a rate and service upon reasonable request, and has always abided by that requirement to the best of its understanding and ability. What constitutes a reasonable request for service is, in the first instance, a matter for business resolution by the involved companies, and if that fails, a matter of case-by-case analysis by the board. Again, the board should avoid the temptation in this proceeding to announce a one-size-fits-all formula about what is a reasonable request. Thank you. I'll do my best to respond to your questions.
Thank you, Mr. Reeves, and I appreciate all the answers, limiting your remarks to the prescribed time. It's very helpful. Just to get this out of the way and segue away from the earlier panels, which were very helpful, but into this panel next, it occurs to me, Mr. Hemmer, that your railroad, Union Pacific's name, was mentioned a couple times in the earlier panels in discussion of the Corp embargo controversy in Oregon. Help me understand. In case you weren't here for all of it, the suggestion was made that Corp somehow believes that the Union Pacific is responsible or should be responsible for a financial commitment to reopening and maintaining the line to Coos Bay, Oregon. Is that a line that the Union Pacific Company is a part owner of or has any legal responsibility for?
have any. Union Pacific doesn't have any ownership of the line that was discussed this morning. We were listed and asked, along with a number of other parties, most of them public, to contribute $4.66 million to the rebuilding of that line. And I can't say we reacted with any more enthusiasm than any of the public entities you heard about or from today.
Is that a common occurrence? I mean, does the UP have a program or a budget allocation for donations to other railroads to help them out with their maintenance problems?
We tend not to be volunteers to help our connecting carriers.
Wouldn't you have some explaining to do to your shareholders if you were to develop that kind of a policy?
I think it would be difficult for us to explain that, particularly if we believed, as is the case here, that there is little prospect that we could earn any return on that investment.
Rail America has made several overtures and shows a pattern of possibly continuing for a good period of time to continue to ask the Union Pacific and others to contribute to their to the maintenance and repair of their line. Do you get the sense that the Union Pacific will change its position if the request just comes 3, 4, 5, or 10 or 20 more times?
I don't think repetition is going to affect our views on this subject.
Thanks. And I promise not to turn this into the hearing on only about one controversy, but since your railroad's name was invoked, I wanted to make sure we cleared that up on the record. Thank you. I'd like to talk about the hazmat issue, the toxic inhalant risk management issues that all railroads face, the attendant insurance costs, the tort liability exposure. This issue comes up in much of the testimony that we'll be hearing today and tomorrow, and I want to make sure that we've got a couple of the biggest railroads right before us now, along with Kansas City Southern, not the biggest, but also Class 1. You all, of course, are required to handle and move, and you do, significant amounts of hazardous materials and toxic inhalants, often called TIH. I believe you're all also lawyers. If you were hypothetically to have an accident on any one of your rail lines, where either because a motor vehicle crossed the path of a train, or under this hypothetical, all safety and DOT and FRA and other regulations were abided by and followed, and you were using the right cars that met standards, but there was tragically an accident. It could have been because of a landslide. It could have been because of a vehicle crossing onto your track, whatever the cause. And depending on the location, tort liability, it seems to me, is administered and applied somewhat differently depending what state or locale the accident might happen. But some have said that if you just act safe and follow the regs, you shouldn't have much to worry about. Is that accurate? And help add some context and some color to the type of risk management you're confronted with in that kind of a hypothetical where all regulations and safety standards are complied with, but nevertheless there still could be an accident resulting in release of a TIH, perhaps in a populated community.
My colleagues will allow me, since we carry more of this stuff than anybody else, offer a few comments. First, you are absolutely right that there are some accidents that we cannot avoid. In 2008, so far this year, and this is a little bit unusual, but we are running at a rate of 30% of our our vehicle train accidents being instances where somebody runs into the side of our train. It's a little hard for me to know how much we can do to prevent that sort of thing. So that's an example of the kind of incident that you're talking about. What we're all worried about here, of course, is that out beyond the range at which we realistically can get liability insurance, that there's that nightmare scenario. Hasn't happened yet. Graniteville was terrible. Our incident near San Antonio was as well, for those who were involved and for us. But it's the death of 5,000 people, or Some have suggested even 100,000 people. What's changed, it seems to us, over time is first that the American tort liability system has become more extreme and more dangerous for corporations, and perhaps for all of us. Second, you have the terrorist threat that didn't previously exist until September 11. And third, we are looking at a very wide range of new PHMSA, DOT, and DHS requirements, some of which we don't know how we're going to meet, that could disrupt networks, could increase costs. Those are all major factors for us. We agree with those who say that if these shipments are going to move, rail is the safest way to move them. We are substantially safer than truck. We also have made substantial improvements over the last couple of years in reducing the risk of an accident. I'm speaking only for UP right now, but we have done a lot. For example, we spent tens of millions of dollars to add signals on a so-called dark line between Shreveport and Houston. We had to do that for the bizarre reason that we carry coals to Newcastle on that line. We bring southbound shipments of chlorine into Houston where they make this stuff. But we've made the investment for safety reasons. All of that said, we agree with the AAR that this is a topic that deserves much more extensive and separate investigation than can be accomplished here, with it being one of a half dozen or a dozen topics. And that's why we think it would be appropriate for the board to look at those changes in the environment, to look at the extent to which product substitution is real or ephemeral, to look at whether we can realign incentives associated with risk in some way that's a little more equitable than the it's just your problem approach. Finally, I would point out that there are partners of ours, Dow in particular stands out, that have worked with us very cooperatively to reduce risk throughout the entire supply chain, and we're very grateful for that.
If I may,
if you could, and also if you could add, that was a very helpful answer, Mr. Hemmer, but also Mr. Wecker or Mr. Cerise, if you could also add just a little bit of context to the part of my question about could you still face, if I heard, I think Mr. Hemmer touched on this, but you could possibly still face enormous liability even without any violation of a established safety or standard. Is that fair to say?
Certainly, if I may, and I'll make a few brief remarks. We are not as big of a mover of these kinds of commodities as some of the other major railroads, but they're important commodities. We move a lot of anhydrous ammonia. In the area of actual TIHs, the most discussed ones, I think it's less than 0.3% of our movements. Having said that, we're very concerned about the risks of these movements. They present significant potential liability, as you have suggested, in situations where we may have no fault or something could occur either through a third party or a random event or a terrorist event or event that we have no control over. We believe there are serious public policy issues here. We run a very safe railroad. We are the safest way in many instances to handle these commodities. There's a wealth of regulations coming. It is a very serious topic that the railroad industry, the consumers and producers, as well as the rail industry of these commodities, need to address, to manage these risks and not leave them on the railroad. In keeping with some of the comments this morning, we are open to a more focused proceeding from the standpoint of the STB. What are reasonable terms of common carriage in this day and age is a question worth examining.
Thank you. As any business, I know that railroads need to work with insurance providers to make sure you properly manage risk. I have heard in my visits with some of the railroads about the enormous costs, increasing costs of that insurance coverage in recent years, that insurance companies often point to their concerns about this very topic. They're being asked to basically become your partner in covering unpredictable and unlimited, perhaps, liability exposure. how do you handle those costs? You're all sharp businesses, and I can only assume you need to recapture those costs, as you need to all your costs. How do you pass this along? Are you able to basically sit down only with your chemical shippers who are the driving force in those cost increases, and pass those costs on to those handful of, or maybe it's more than a handful of shippers, or do you basically have to pass them on to everybody, including grain farmers and other shippers who've got nothing to do with TIH, other than, of course, some do, of course, receive fertilizer and all that, but people who may well not have any role in TIH, are they asked to basically pony up?
In general, I would say that some component of those costs is probably allocated throughout the network. Some portion of it may be allocated more towards the particular traffic involved in determining the cost for the particular movement, which is part of the calculation of the prices. But some portion of the cost bleeds over into all of the traffic.
We believe that about half of our excess insurance cost is attributable to these types of shipments. I don't look good in stripes, so I'm not going to talk more about how we price. I would point out, with all due respect, though, that the simplified standalone method that you have developed does not appear to allow us to allocate those costs to the shipments that cause them. Beyond that, though, that's really not the ultimate concern for us at Union Pacific. Our concern is what I call the nightmare scenario. The derailment in a perhaps because we've been hit in the side or we've run into something, and it could be because of our own operating failure. The scenario, though, in which there's a major derailment, a major chlorine or anhydrous incident in a major populated area, there is no insurance to cover that. Stockholder equity would be wiped out. The company would probably be in a prolonged period of bankruptcy if something like that happened, where all of this investment I've described would probably be put on hold. That's the kind of situation we're worried about.
If I might add, and I'm not prepared to discuss pricing practices or what options we may look at or deal with a specific shipper. Having said that, I think it's fair to say, in a similar vein, that this is an area where our shippers in general and our system and network in general are being forced to bear or try to spread a risk we may not be able to spread across other commodities, other shippers, to keep our system going. There is no mechanism out there now that deals with it. There's nothing like the Price-Anderson nuclear material type structure that has recognized these are public needs and public risk. I realize that's a matter for Congress, not the board, but there are serious issues that today leave us as the only vehicle to try to deal with these across our system, these risks.
And please be sure I'm not asking for any specific pricing information other than just the general concept that all businesses need to recover costs, including insurance costs. But it is worth noting that at least one of the witnesses was willing to share, just generally, I appreciate it, Mr. Rees, that all of your customers are paying for this problem, one way or another. Some perhaps more than others, if I heard you correctly. And that's important because when I meet with some rail stakeholders, customers of yours, I sometimes come away with the impression that they feel this is not their problem. This is just your problem. I'm looking forward to getting into it more with the other panels, but it occurs to me that perhaps it is all of our problem, whether you're a user of chemicals, as we all are, or whether you are a grain shipper or a coal shipper or any kind of shipper interested in keeping your rates down. The fact that these costs are creeping in that you may have no direct relationship to makes it all of our problem. Let me pause there. I do have some more questions, but I'd like to let Commissioner Buttrey take a turn at questions.
Thank you, Mr. Chairman. I don't really have a question for the panel, but I think I made my views on this perfectly clear this morning in my opening statement, and I stand by those. I know that saying what I said this morning may waltz up to the line of something that maybe was a little bit too strident, but and it goes to the issue of what is a reasonable request. And I think, as I said this morning, I think we may need to take a real fresh look at what that means in the context of hazmat. Thank you, Mr. Chairman.
Vice Chairman Moley?
Thank you. I want to begin by once again trying to drive a stake through the heart of an analogy I've always hated, and that is the Easter Sunday analogy. Churches are built for Easter Sunday. Go to churches when it's not Easter Sunday, and you'll find that they're built for that. So while the point may be well taken, I've always hated the analogy. Let me start off with Mr. Hemmer at Union Pacific, and to raise a point that's concerning the board right now. And you may or may not be familiar with this. You said some very, very nice things about our consumer assistance program, and we appreciate that. But it has come to our attention that Union Pacific lately has been the least cooperative of all of the railroads in terms of dealing with customer problems or working with our consumer assistance group in dealing with those problems. And I would hope that you take that back and you look into that matter, because we have been having more of a problem lately with your railroad than with the other railroads, and that hasn't been true in the past. So I will hope you take that to heart. To the BN, to Mr. Weischer, you argue that railroad's capacity is constrained, and that when it's constrained, its common carrier obligation is, quote, to act fairly and reasonably to provide service with its available capacity. But if the railroad is the organization that decides how much capacity is going to be offered, then the reasonableness of the service is bounded by that capacity. So in a sense, the railroad is determining what is reasonable, what a reasonable offering is, rather than this board or any other group. Is that true? I mean, basically, you determine how much capacity, so therefore you can determine what is reasonable.
We have the responsibility to work with the capacity we have at a given time. I should say at various times in some areas right now, we might not be as constrained in capacity as we wish we would be, but that's in light of current economic terms. We have the responsibility to grow capacity from the standpoint of our shareholders and our company and our customers when the returns justify. And we do have a responsibility I would say, from the standpoint of the common carrier law, to act reasonably in allocating or queuing or whatever the issue might be in a given situation in the commodity we were talking about, by definition as the managers of the property. That is also not to say, and this hasn't happened in many, many years, but there are remedies before the board if that wasn't done right. I'm thinking way back to grain car allocation many, many years ago. There are remedies for such things. But in the first instance, we have to deal with our customers and the demands they come together with the commitments we've made to them in the rates and the offerings we've done.
It's been argued that railroads sometimes cannot service new customers because it serves existing customers, and that serving a new customer might affect the overall service system-wide, network-wide. And that may be true, but how does the board then handle the needs of the new shipper that comes before us saying the railroad is refusing to serve us, when in fact the railroad is refusing to serve them because it's making the argument that it's going to affect other customers? Should we be making judgments and say that, well, look, there may be these these downside effects, but in fact you must serve these new customers when they come to you?
I'll comment briefly, and then I sense the other railroads also have views on this, but it's hard to hypothesize exactly what we're talking about. We're not in the habit of turning away new business. We look for business opportunities. We want the business opportunities. There can have situations where someone is asking for a kind of service, and the kind of hypothetical you could talk about is someone wanted to connect with our transcontinental main line, high volume, and set something up where they wanted to come out on the line and switch cars or have us do a function that could not be supported without serious impact on other other shippers, or coming out of the Powder River Basin, somebody wanted to interfere with the flow. That could lead to compromises, or there could be someone asking for a form of benefits. Sometimes these are rate issues. They want the benefit of a high volume rate, and they're not going to do that. But there are remedies if we acted unreasonably, either on the rate side or otherwise, and those are very, very, I believe, fact-specific situations.
You frame the issue as denying service or refusing to provide service. We prefer to look at it at Union Pacific as the terms on which we can get to yes, the terms on which we can provide service. There's been a lot of debate in the filings that have been made here, and it's an interesting and important debate about the extent to which a railroad can ask a shipper to provide infrastructure that on a very busy main line supports the service to that shipper. But if you don't, there are many, you may not like the Easter Sunday example, but there are many others. There are stoplights on the New Jersey Turnpike. There's requiring Southwest to fly from every airport in Wisconsin to Midway, no matter what effect it has on Midway or the economics of the business. Fine. What we are trying to do is find a way to attract new business and to be able to do it while continuing to serve our existing customers efficiently. I'm very surprised to see, for example, the concerned coal shippers weighing in heavily on this subject. They are major beneficiaries of our policy because our objective is, because they use a lot of our highest density lines, and they therefore would be hurt most if we started doing a lot of switching off of those lines and blocking those lines for an hour, 2 or 3 hours a day.
You mentioned about requiring shippers to make investments in the infrastructure, and a lot of the testimonies that we receive from shippers have complained about these requests. What considerations or what obligation do you have to the shippers if you require them to make this investment? What guarantee do they have that after they make the investment, they're going to be served?
Well, it's in our interest to serve them once they've made that investment. This is the way much of the ethanol business is moving right now. We've had a lot of shippers who've made significant investments, and we want to carry their traffic. We are carrying their traffic. We are increasing our ethanol shipments 40% and 50% on a compounded annual basis, and we expect to see that continue. If they want commitments and vice versa, we get commitments from them. We're happy to sit down and work out a contract. That's an alternative way to proceed.
The Union Pacific has, as you mentioned before, used the embargo more than the other railroads. In fact, since the beginning of 2006 to I think last week, the Union Pacific has put in more embargoes than all the other railroads put together. I believe you could put 154 embargoes in place. Is this consistent with the AAR's TD1 circular with regard to embargoes, saying that embargoes should not be used except in terms of safety or weather-related emergencies, and they should not be used for commercial reasons or to monitor or meter traffic? Do you find that to be a little bit in conflict with the AAR's TD1 circular?
We think that the AAR's circular contemplates inability to serve a customer for reasons beyond our control. And we have had a number of instances, this is the principal use of some of these smaller embargoes, where there are simply too many cars coming at the customer at one time. I used an example in our testimony of an ethanol receiver in Texas that simply said, we can't control this. And so we had an extended embargo for that receiver. And we weren't refusing to accept shipments. We were permitting them in. And we finally now reached a sufficient capacity situation on the shipper's facility there where that embargo is no longer necessary. The alternative is very ugly. We showed what happens in Phoenix when you have literally 700 cars in a 1,100 capacity yard that are waiting to get into shippers someplace. That happened when Phoenix was booming and lumber was coming in from all over creation. There were just too many cars coming in. So we couldn't meet our obligation to the recipients of those shipments or the recipients of other shipments, such as our auto customers, unless we did something to stem the flow. Now, we aren't stripping down, under our approach, we aren't stripping down our yards where we say we will not allow a single car to be stored there. We understand there's some bunching that takes place. We're responsible for that. So what we tried to do is compromise at about 3 days worth of business in our yards. And that's really our objective right now.
You would agree that embargoes are always temporary, correct? That you shouldn't have a permanent embargo constitutes abandonment, no?
If you have a situation where you're not doing anything to get rid of the embargo, and you're not repairing a line, or you're not doing anything to resolve the cause, then yes, I would agree you have to use one of the other mechanisms that's available. Your show cause order in the court case seems to me to state the law precisely.
Thank you. Mr. Reeves, you mentioned in your testimony, that the IRCS does not incorporate the fully allocated costs of transporting TIH materials. I'd like to explore that a little bit with you more. As I understand it, all railroad costs, including the cost of handling TIH chemicals, are captured in the uniform system of accounts. As reported, the railroads are one report, and they're assigned to various activities through the IRCS process. So the question I want to ask you is this: are you asserting that IRCS understates TIH costs because it's not capturing those costs in the first place, or is it a matter of assignment that the costs are misassigned and some of the TIH costs are being assigned to other traffic?
What I was particularly referring to was the small rate case decision that adjustments to IRCS would not be allowed for shipments that had particular issues. But
in IRCS, aren't the TIH costs actually captured, because aren't your insurance costs overall captured in IRCS? And is it in the sense that the other shippers are already picking a part of those costs when we look at the revenue to variable cost ratio of other movements?
I can't profess to be an expert with IRCS. I apologize.
Okay. The other question I did have about IRCS is IRCS is thought to be problematic for many, many reasons, and it's been around for quite some time, and it's based upon econometric analysis and modeling that was done many, many years ago with all the data. And I, for one, am wondering about the feasibility of redoing IRCS and bringing it up to date. And we might be able to address some of the TIH issues at that time. Do you have any comments or thoughts on doing that?
Before saying yes, one has to swallow very hard and wonder about whether you have the staff that can do it or we have the staff that can do it. Nevertheless, as you say, it is quite outdated. We know some of the allocations are very questionable. You performed a bit of a fix for TOSC traffic that helped some. There are some other allocation issues that, and one ancient one in particular, which is the treatment of essentially land costs and right-of-way costs that I think need to be revisited. Speaking only for Union Pacific, we would be willing to join with you in pursuing that initiative if the board wanted to do it.
Thank you.
And, Vice Chairman Mulvey, if I may add, I would have to agree that it's a fine system because it's the board system. It's been there a long time, but I remember when it evolved from Rail Form A, there's things in there that the regressions and the things that go way, way back. In reference to the question you were posing earlier, there are various costs, no doubt insurance as well, that are simply spread across vast quantities of traffic, but it would be a very daunting effort to take on. But we would participate, of course.
I recognize it's daunting, and it would be very, very costly as well, and it would put a lot of demands on the board's resources, and we might even need more resources. But I do think having good data and good information and good models is critical to doing our job correctly, and it's been a long time since this has been reviewed in total, and I think it may be time to do it, but my other board members may not agree with me, so. Thank you.
Thanks. I have a couple more questions. Please appreciate your patience. Mr. Weicker, this relates to the grain sector. What would you estimate is the total percentage of your grain fleet devoted to contract movements of grain?
Quite small. I don't know a precise number because COTS are not contracts. They are commitments forward, and the vast bulk. Now, in the ag products area, we have corn syrup. We have a number of things that move under contracts. On the whole grains, I believe it's quite small, but I can't give you a number.
Okay. Jumping back to the risk management discussion we had a few minutes ago, and triggered by primarily by your required handling of toxic inhalants and hazardous materials and the liability that exposure that is attendant to that. Is this liability exposure something that is grown to the extent that the railroads need to actually, and do you report them in various filings, like Securities and Exchange Commission filings? I mean, sometimes businesses, when they have a certain type of risk, they need to sort of put that out there, and some people see that as a indicator. If it's real, you'd have it in your SEC filings. If it's not there, then maybe it's not quite as imminent or problematic as people suggest.
It's real, and it's in our SEC filings.
There are extensive discussions of the various kinds of risks, forward-looking and otherwise, that we are facing, very, very, very carefully crafted in our annual report and our 10K.
Mr. Reeves?
I'm not certain whether that's in there or not. I would believe it would be, but I don't know.
Okay. Perhaps if you, these are all items in the public domain, but if you wouldn't mind just maybe making those SEC reports available to us, that we can make them part of the record. Thank you. Mr. Reeves, I have to confess that in my travels and dealings with shippers, the issue that I hear most about the Kansas City Southern in recent weeks and months is not one of the gigantic issues that we've maybe touched on already today. Really kind of a smaller one, but I need to, while I have you here, to raise it. Apparently the Kansas City Southern, in an effort to promote the use of the internet by customers to check on the status of train movements and car availability and car location, has an interesting incentives policy now, whereby if shippers choose to call, sort of the old-fashioned way, pick up the telephone and call someone at the KCS to ask, hey, what's the status of my shipment that was supposed to be here yesterday? I need to know where it is. That there's a $25 fee levied on the shipper in those cases. Is this something you're familiar with?
I'm not. I don't know. I could find out, I'm sure.
Okay. Well, I can maybe help you, because I know that the dozens and dozens of shippers who have pulled me aside, and of all the issues out there that we have to deal with, from the rate dispute resolution processes and cost of care, this issue, the common carrier obligation, the cost of capital, I mean, all these big issues. That's the one I hear about from KCS customers more than anything else. And just to me, it sounds, you deserve credit for trying to promote e-commerce and getting folks to use the internet, but I'd like to suggest it's from a public relations perspective and a customer relations perspective, it's a really questionable approach, because it sends the message that don't bother us customers. If you do, we're going to charge you a $25 fee. And I mean, if you can imagine if the STB started doing that, yes, we have our filing fees, and those are not always popular, but if we didn't answer status inquiries, but for a $25 fee, we'd be hounded out of existence in a matter of weeks. So just please take that back if you could. If I've got it wrong, please correct me too, but I've heard it from so many shippers, and I had you here. I wanted just to raise that. I will say it kind of relates to perhaps just a customer service orientation and perhaps a training opportunity for all the railroads. In my travels and extensive meetings with shippers, I hear over and over again that railroad employees will say, we can't provide that service. We won't provide that service. Not going to happen. Just no. And when I ask about that, the railroad, the way it's recounted to me by shippers, is the railroad employees never, ever mention the common carrier obligation. Never say, well, of course we have an obligation to serve you upon reasonable request, but here's why it's complicated, and here's why it might be awfully expensive for us to meet your needs the way. It's just, sometimes it's just no. And if you could take that home to headquarters, talk to your HR people and your training people and your marketing people, because it sends a terrible message when people call the board and they say, I just got told, heck no. And it leaves the impression that not enough railroad employees actually know that there is such a thing as a common carrier obligation. And it's almost, to me, maybe I'm old-fashioned, but I sort of think it should be somehow in the, in or close to the mission statement that every new employee gets briefed on and understands to be sensitive to.
Well, I've had two comments today that suggest that we may need to take a close look at what we do. What we have attempted to do is to set up a process by which requests for new service are reviewed, including by counsel who are familiar with the common carrier obligation. I'll take a good look at that process and see if we've got some shortcomings in it.
Thanks. And my last question really is, I appreciate everyone's patience. There's much in the record from different statements that were filed for today about the question as to whether the STB has really anything to do with looking at, possibly adjusting, possibly changing the way the very broadly and worded common carrier obligation is spelled out in statute. Can we actually, through rulemakings, regulation, through the work we do, actually change the way the common carrier obligation impacts certain shippers, certain types of shippers? I'm thinking, for example, the exempt commodity process. You all are very keen observers of the board, pretty experienced with our procedures. Do you have an opinion on as to whether the board, under certain circumstances, can actually make meaningful adjustments to the way the common carrier obligation is actually implemented and to whom it applies?
Short answer, yes. Clearly, it's within the board jurisdiction to define the term reasonable request, reasonable demand, and so forth. And this board or its predecessors granted the exemptions or enacted the exemptions in various commodities and more broadly. These are carefully structured, and there's a lot of industry that relies on what's out there, but it's within your jurisdiction if the exemption on widgets at 49 CFR or something didn't make sense. I believe you have the jurisdiction to revise that, and by the same token, on the regulated commodities, just as you have done, including with things and programs my company's had, you are the definer of what is the reasonable response to a common carrier request.
I agree that although you don't change the underlying law, the law calls on you to take into account what is reasonable, and that in turn depends on a totality of circumstances. What was reasonable in 1983 with a shrinking railroad industry ought to be wisely viewed as quite different from what is reasonable under very different circumstances in 2000, let's say 2010. With respect to exemptions, I'd also point out that individual shippers are free to come to you with a request to revoke an exemption. FMC did that successfully in a case that we litigated, and so that opportunity is always out there.
Mr. Reeves, any thoughts on that?
As suggested in my prepared remarks, why we understand that you will interpret how that obligation applies in various circumstances, but would encourage you to do it in particular facts and cases rather than by a general pronouncement.
Sure. And it's a matter of record that the board and ICC before us have made over 100 exemption decisions, some at the behest of industry, some on the board's own motion. And so that precedent is alive and well out there, and I just raise it because there are some in their statements who have indicated that only Congress has the authority to make meaningful adjustments to how the common carrier obligation is implemented. And I think it's just important to get the facts out. Thank you. Any other questions from my colleagues?
And what the Price-Anderson law with regard to hazardous nuclear materials have been raised. Do you support some sort of Price-Anderson legislation for hazmats for the railroads, and would the railroads be willing to contribute to that fund, which I don't believe so much occurs with Price-Anderson, but the railroads would also contribute to the liability fund? Or would you prefer something like the Warsaw Convention as amended by the Montreal Protocols, which would give you a cap on liability?
if I had my choice, I would prefer a cap on liability. I have a sense that there are trial lawyers in America who might not react very well to that idea.
I'm not a lawyer, but my colleagues might.
The Price-Anderson model is an appealing one to us and seems to me to have some value in this context.
I don't disagree. I'm not sure I would be prepared to parse the different proposals so much as that something along the model of that kind of structure that deals with the public risk as a public issue would certainly be something appropriate.
The unlimited liability is the big issue, the potentially ruinous and difficult to calculate liability, and either of those would to some extent address that, maybe the liability cap more directly.
I think it's a very good question, Vice Chairman Mulvey. Thank you for raising it. I just would say, I mean, something's got to change here. The status quo seems to be unacceptable. We're just waiting for, we hope it's a long time from now, but, accidents happen. When you have a system across the country that operates 365 days a year, night and day, and all kinds of weather, and it just is crying out for attention and action. I certainly encourage all of the stakeholders, not just railroads, to get together and develop solutions, or else you're going to have others trying to develop them for you that might not work as well. We talk a lot in this town about the challenges in the healthcare sector, for example, huge challenges, and the liability problems that disincentivize physicians from practicing in certain states or in certain lines of the medical practice that are particularly subject to massive tort liability, and then trigger these enormous insurance premiums to doctors. I will say doctors compared to railroads seem to have it pretty good, and I'm very sympathetic with doctors. Doctors, they have a terrible situation, but their terrible situation seems to be terrific compared to the railroads. They can actually choose to move across from, let's say, D.C. to Virginia, where they might have a result of would be a lower insurance premium in many cases. They can, it's not always convenient, and I feel for them, they can adjust their practice and not offer certain types of procedures or certain types of specialty. Railroads have none of that luxury. You have to be there to handle whatever folks want to stick you with, and it is just an enormous public policy problem. I think we don't hear about it as much as perhaps the healthcare predicament, which is very serious, but in many respects it's much more serious and much more threatening to our economy and to everyone who relies on rail transportation. Welcome any parting comments on that, but if not, we'll move along.
Appreciate your interest in these very serious topics and bringing them to the fore. Thank you.
That is the one that keeps me awake at night, so thank you.
Thank you, panel. We'll now call up panel 3 from the state of Washington, and we'll take a couple moments as they get up here for board members and anyone else to stretch legs, but we will keep this moving along because we do have a full day today. Bring forward Mr. Scott Witt, the Director of State Rail and Marine Programs at Washington State DOT, and Roger Johnson, President of the National Association of State Departments of Agriculture, and we'll let them get settled, and then we'll be starting off with the panel momentarily. You're poor.
any other question, of course, would be welcome. That'd be one alternative. The other alternative would be contract with.
If I could ask the audience to take your seat or else step out into the back corridor if you need to, but we're going to start with our next panel. Welcome, Mr. Witt and Mr. Johnson. We're glad you could be with us today. You've each been given 15 minutes. Feel free to use as much or as little time of that. We have read your complete statements and look forward to hearing your summary today.
Okay.
We'll start with Mr. Witt.
Okay. Officially, this afternoon, good afternoon, Chairman Nottingham, Vice Chairman Mulvey, and Commissioner Buttrick. My name is Scott Witt, for the record. I'm the State and Rail Marine Director for Washington State Department of Transportation. I want to thank you for this opportunity to submit testimony on behalf of the shippers of Washington and the DOT. The department and the state, I will say, and follow up to the Burlington Northern UP, have very good working relationships with both our Class 1 carriers and enjoy opportunities for leveraging infrastructure investments between the two of us. We work very heavily on both rail and highway-related construction projects, and as the state required and the systems requires both to leverage investments for both public and private good. One thing I would like to mention is that the testimony that was put together in the written format was rather unique in at least our position. That was created as a result of polling many of our shippers after the announcement came out and meeting with a broad range of shippers and or receivers, including ports, agriculture, chemicals, lumber, and industrial. This information was coming in until the last minute as we formulated our comments to you. It also spanned the spectrum as to position, as you can well imagine. The written testimony I submitted was largely a compilation of edited comments and ideas that perhaps should be considered by the board. Under the abandonment heading, does the department necessarily believe a 25-year hold on abandonment is practical, as in some other countries? And in a word, no. But we felt it important to tee up these comments for you so that we can, and I will address those additionally under the abandonment portion of my presentation, to showing a degree of concern of what we believe to be a previously uninvolved constituency. I will attempt to summarize or in some cases simplify the points in the written testimony, giving context to my comments. And by doing so, I will be basically giving you a picture of how Washington State views the infrastructure, some of the constraints, some of the capacities. So if you'll give me a little latitude here, it's going to be more of a story with everything kind of twisted into it. So have a print. Oh, there we go. Okay, the goal of Washington State's freight system strategic plan is to support a broad industry sectors. We classify it as three: the global gateways, which includes our container ports and international and national trade flows through Washington to the gateways in Chicago and East; our made in Washington, which is our regional economies that rely on freight systems, and was mentioned earlier by the Class 1, some of our shuttle loading grain facilities, et cetera; and our delivering goods to you, which is the third segment, which is primarily our retail and wholesale distribution systems. There we go. And I know you may have to squint a little on this one, but this is our state rail map illustrating our three east-west main lines across the state routes and the main north-south route along the Interstate 5 corridor. Washington's carriers, Class 1 carriers, include the BN and the UP, and we have 22 short line railroads within the state. This is one component of our multimodal transportation along with the roads, ocean, pipeline, and air systems. I would also like to note that as early as last year, the state of Washington is now the owner of a short line rail system in the acquisition of the Palouse-Cooley City lines in the eastern part of the state of 308 miles. Last year, I had the opportunity to attend your hearings on infrastructure with Dan O'Neill as I was running his state rail study for him and the Transportation Commission. This is one of the slides from that as a result of that study, and illustrating that, in our opinion, because Washington State is a smaller player in the national scheme of railroad business, investments in our state can be slower in coming than elsewhere. It is probably difficult to read, but the red line indicates congestion, the yellow lines indicate constrained, and the green lines are reliable. Needless to say, you see more red and yellow than green. Probably one of the most important investments as far as capacity is concerned would be the crowning of Stampede Pass, which would allow double-stack container traffic to move east-west as opposed to using the Vancouver to Pasco line in the south. BNSF and the state have worked towards that end with a memorandum of understanding that could move the project forward if and when the state is able to secure a funding source. The I-5 corridor line owned by the BNSF is the backbone of the Washington State rail system, controlling access to east-west lines. Most of the line is owned by the BN, but they share operating rights over the line with Union Pacific, in addition to Amtrak's intercity rail services and the Sounder commuter rail operations. There are at least a half dozen sections that are chronic choke points, causing delays that ripple across the entire Washington network. Some of the programs WashDOT has taken on are twofold. One is addressing capacity. We have a produce rail car program, which is started in 2003 of 26 refrigerated rail cars to supplement shipments for small shippers for availability. It is an ongoing program, and we have the option to augment that program by another 40 to 50 cars if need be. The second one is the Washington Grain Train, as you can see illustrated below. There are 89 total cars in that pool, and that is primarily focused on the shuttle programs with the Burlington Northern and Union Pacific Railroads, basically shuttling either two barge facilities off of short lines or interchanging two large transload facilities for grain. Can Washington State successfully adapt to changes in a national freight system? Ideally, roads. Many of our low-volume shippers are going to have to truck their products to central intermodal centers. Timber, grain, and industrial products are heavy, and Washington State roads will need upgrades to handle the new traffic patterns. Some shippers, most high-volume shippers, are adapting on their own, but low-volume shippers will need help making the transition to BNSF and UP Railroad's new shipment requirements. And then there's our short lines. An opportunity exists for short line railroads to build trains for the BN and UP, but if they don't have the high volume customers and do have deferred maintenance track, they won't survive without ongoing capital and operational subsidies. I'd like to speak a little bit about the railroad infrastructure projects in Washington. WashDOT will invest over $350 million between 2007 and 2017 to relieve bottlenecks and choke points, increase system capacity, and preserve and maintain rail lines. At this point, I'd also like to note that the lack of an overall federal rail and infrastructure strategy in place concerns our department. With major infrastructure needs coming to the forefront of all transportation modes, carriers, shippers, and the state can only fund a finite amount of the needs. While the requirements for infrastructure investment may have traditionally been with the carriers, the costs have been partially shifted to both shippers and the public. In some instances, only a relatively small amount, and others a larger amount. How does the state of Washington fund our rail projects? Gas tax receipts cannot be spent on rail projects. This is part of our regulations. Rental car taxes, taxes on the sale of new and used vehicles, vehicle weight taxes, and some federal earmarks. This map illustrates the passenger and freight rail projects where specifically they sit within the state between 2007 and 2017. There are a number of projects. The lighter colored ones are primarily passenger related. I will have a slide here coming up on our Amtrak Cascade service. And also the black ones are primarily freight driven, although you'll see there are some, like in the Vancouver area, that benefit both. They are actually combined multimodal improvements. Some of the challenges faced on the Pacific Northwest Rail Corridor. It is a shared corridor. One of the issues we have, and as well as our partners, is integrating operations with other rail users. Operating plans, operating practices. We have an international border. We have freight trains inspections, and we have passenger pre-clearance. U.S. federal funding, a whopping $12 million in 12 years. The province of British Columbia funding, 8 years to fund one project. It allows the second train movement to Vancouver, BC for the Olympic Games. The Washington State and the initiative process. The people giveth and the people taketh away. Our Amtrak Cascades passenger service, the state of Washington owns 3 Talgo train sets that are under the guise of Amtrak and being operated by Amtrak. Ridership in 2007 reached 677,000, a 7.4% increase over 2006. I'd also like to report in the first quarter of 2008, ridership was up 14% from 2007. Obviously, high fuel prices, congestion, and a strong environmental concern are some of the drivers. We are looking to continue. We are working on the mid-range plan at this time to put our proposal forward to the legislature to possibly increase funding and add additional train sets. Our investments constraints exist, political, financial, and economic. Washington State's freight system strategic plan must balance the cost of investments with resulting economic output. We have to direct limited resources to their most productive use, and by setting clear priorities linked to the growth of jobs in the state's economy. Our issues and challenges. Non-gas tax transportation funds are in high demand right now, as in most areas. Inflationary pressures are eroding the value of our existing project dollars. As projects continue out over multiple years, or as we call the mega projects, or over 5 to 7 years, with construction material costs going up as quickly as they are, we quickly lose the ability to complete those projects on time and on budget. We have limited federal funding participation, and then we have the issue of private revenue and private investment. One of the comments we have is the demand for equipment of multiple use is going to the highest revenue for the carrier. Would any private sector entity not do the same? I most certainly shifted assets to where my company received the best return while I was in the private sector. This tends to come out primarily in car supply issues, along with the transition to unit train service from major origin destination points. We have worked closely with our Class 1 and short line carriers to, in effect, supplement those supplies with the state equipment. This mode also changes the business model for the state and generally smaller industries with less productive lines being sold to short lines, as in the case that we have purchased one. In many cases, the issues that motivated the Class 1s to sell the line to another carrier may in fact haunt the new short line carrier also. Primarily deferred maintenance of the infrastructure and low volume shipments on the line if new marketing or service combinations can't revitalize it. We've obviously seen that illustrated earlier. Ultimately, local economies may change dramatically as the business may be required to relocate for rail service or perhaps start trucking the product if applicable, therefore changing the wear and tear on the road system, both county and state. The issue of abandonment. Obviously, there's an STB process in place. Thank you for that. The Washington State Legislature in our last session actually introduced legislation to request the Washington State DOT to further enhance that process by stakeholder outreach, communication, education, et cetera, and review on a local government entity of any pending abandonments. We did testify, quite honestly, against that, as it was within the STB's purview. There was an established process. But what it did tell us is that the local government entities are taking a much stronger role in worrying about abandonments for future infrastructure, for future corridors, and for passenger. We would suggest perhaps we relook at an education outreach, some communication processes on more local levels if in fact there's going to be a pending abandonment. And I think a realization of the importance of abandonment to many of the local economies, perceived or otherwise, because there are times when, as we're finding out in spades, that some of the local government entities, port districts, counties, et cetera, are willing to come and invest in that. The common carrier obligation, I'll just leave it in my testimony, as that has been answered by many, many folks here and will continue to be so. My last point is on the toxic inhalation hazards. Obviously, the state of Washington has a very strong agricultural economy that is very dependent on the anhydrous ammonia and manufacturing involved with the chlorine. Obviously, there are folks here that are very well versed in this subject, and you'll be hearing testimony later, but we did want to make it as a comment to get it on the record. In closing, we'd like to say it will take all the parties working together in a systematic approach to deal with all the issues that are being brought together on common carrier obligation and how to move the national need for a comprehensive rail, both freight and passenger, strategic policy and direction in place for national guidance. I wish to conclude my testimony by again thanking the board for the opportunity to testify in this significant proceeding and expressing our hope that the comments submitted by all parties will assist the board. Thank you.
Thank you, Mr. Witt. Mr. Johnson?
Thank you, Mr. Chairman and members of the board, for this opportunity to testify, and a special thanks to you, Chairman Nottingham, for your visit to North Dakota recently and your outreach to a number of the folks that are impacted by many of these issues. For the record, my name is Roger Johnson. I serve as the Commissioner of Agriculture in the state of North Dakota. I am also currently serving as the President of the National Association of State Departments of Agriculture, which are the elected and appointed commissioners, secretaries, and directors of agriculture from around the country. As you can imagine, rail service is a huge issue for me and for all of my counterparts. Much of the testimony here is devoted to sort of historic kinds of issues, and so with your permission, I'm going to skip through some of this fairly quickly and get to the last part where I've got some more specific and more recent issues that may be of interest to you. As a national organization, we have a lot of interest in this. Obviously, rail transportation is essential to the industry of agriculture. And there are lots of issues that you've already talked about. On page 2 of my testimony, I summarize some of the positions that NASDA has taken over the years. And I would highlight that our most recent position is that Congress and the federal government should substantially increase oversight of the railroads, including rates and services where competition is not present. I know that's not the first time you've heard that suggestion. It is the first time, though, that we have spent as much time talking about it as an organization, largely, I think, as a result of the enormity of the concentration in the industry that's happened in recent years and some of the issues that have resulted from that. Obviously, with the deregulation of the rail industry over the last couple of decades, it has led to significant financial stability for the railroads, certainly compared to the past. But it has also led to fairly substantial consolidation and to a decrease in the physical infrastructure of the railroads in terms of the need that is out there, that is currently expressed. I give a lot of data from the recent GAO study that was done, which I'm sure you have seen, so I'm going to kind of quickly skip through that. But it certainly does make the point that I just asserted about income for the railroads with the chart on page 3, both general rates, rates for grain, rates for captive shippers, fuel surcharges, and line abandonment are all seriously impacting the agricultural industry. And each of those are discussed in turn. Let me turn to page 5 where we talked a bit about captive rates, because that seems to be one that gets a lot more attention. Captive shippers have been and continue to be victimized, in our judgment, by extremely high rates. And in fact, the GAO study puts several statistics to that assertion. Agricultural commodities are at the mercy of potential, if not apparent, monopolistic practices by the railroads. Since 1985, tonnage from traffic traveling at rates substantially over the threshold, the 180% threshold for rate relief, has in fact increased. In addition, tonnage traveling at rates greater than the 300% of variable cost threshold has more than doubled. On page 7, I give more detail to that, but I do want to draw you to your attention to the bottom of that page where I talk about the recent acts that Congress has passed, which have encouraged competition as the preferred method to protect shippers from unreasonable rates, and granted the STB broad legislative authority to monitor the performance of the railroad industry. However, the GAO reports that these processes have proven to be largely inaccessible because the standard process remains expensive, time-consuming, and complex, and the simplified process has simply not yet been used. Now, that is obviously just a little bit dated, but it is certainly the feeling that is out there. I talk about fuel surcharges and cost shifts in the subsequent pages of my testimony. On page 11, I get to the intermodal shipping. And one of the reasons I skipped over some of those other issues as quickly as I did is because I know that panelists, in fact, on the very next panel, are going to go into more detail on each of those issues. So far, I've not heard a lot of discussion about the intermodal shipping kinds of issues. In agriculture, one of the things that is happening over time is customers are becoming more attuned to very specific kinds of goods and services. Instead of all the commodity movement, we are, in fact, in North Dakota, we lead the nation in the production of about 15 different commodities. Many of these don't fit very well into the bulk movement category, and in addition, some of the bulk movement category, the large commodities, soybeans is a good example, also have very specific identity preserved markets around the world that require them to be segregated and moved through containers. And so that's becoming a larger and larger issue, not only in my state, but around the country for those reasons. Attached to my testimony is a letter dated January of this year that was sent to Senator Dorgan from North Dakota, from one of the intermodal shippers in North Dakota. I present that as part of my testimony because I think it explains in his voice what's happening to many of the intermodal shippers in that part of the state. It certainly is not limited to just him. And if you read that letter, there are several issues that will really sort of leap out at you. First of all, with intermodal shipments that move overseas, there is very much a lack of transparency in the rates. These shippers don't negotiate with the railroads. They negotiate with the steamship lines. And so the rates are combined and are harder to see. And you will see that the result of that is the second major point he makes is that we see some irrational kinds of pricing arrangements. And he points out how he's located very near to a particular terminal, Dilworth, which is where much of this industry is located close to. But yet, they are routinely draying cars from terminals that are about 300 miles away in both directions because the prices offered in the closest terminal are so much out of whack that it makes sense to go and dray from Minneapolis. In fact, they're even considering going as far as Chicago and pulling these empty containers in order to load them or put them back on the railroad and either send them back through Chicago or send them out to the West Coast. It's not unlike the issue that was very prominent a couple years ago with the inverse pricing relationship on bulk car shipments of grain through our state, and I know that you all know a lot about that, but it's the same sort of thing. What really puts salt in the wound is he also describes the fact that until very recently, as many as 200 empty containers were moving daily to the closest Dilworth facility. And they still had to go 300 miles away to get empty containers and, in fact, to pull the loaded ones back there as well. In an attempt to remedy this issue, a lot of people got involved, as you might imagine. Senator Dorgan got involved. The state of North Dakota got involved. and in cooperation with cities in Minot and Fargo, actually entered into a contractual agreement with a national firm, Wilbur Smith, who was hired to mitigate these costs in favor of the feasibility of a new co-load concept that would improve statewide access and service to container equipment and improve freight rates from the region. This idea, in fact, was suggested by BNSF, he goes on to say, and everyone was in agreement that this made a whole lot of sense, but this effort was unsuccessful. In fact, when it was, BSF even clearly informed this national firm, Wilbur Smith, that BNSF would not permit new intermodal service to divert business from current operating hopper car services and would use price as a mechanism to prevent this from happening. It would seem to suggest from the facts in this case that that's precisely what has been happening and what's likely to continue to happen. As a result of this letter and Senator Dorgan's intervention, BNSF and this shipper met, and pursuant to that, BNSF in fact publicly announced the rate equalization to provide relief. However, when the rate equalization announcement was made, it pertained only to bulk grains, not to identity preserved commodities in containers. I would argue that these practices are contrary to the statutory requirements dealing with that require carriers to provide service upon reasonable request, and that railroads, quote, shall furnish safe and adequate car service and establish, observe, and enforce reasonable rates and practices on car service. These issues I provide to you not so much because I'm here to say what the solution is, but to point out to you that here's a problem that you have to figure out how you deal with. And I would suggest, as my fellow ag commissioners, secretaries, and directors have suggested, that in the absence of competition, and more competition, at least in my state, is absent in the railroad industry, that in the absence of that competition, there needs to be some sort of regulatory oversight to provide some sort of fairness in how these issues are dealt with. Obviously, we would prefer that the industry would take their common carrier obligations seriously by doing the right things. I think the evidence that I've just described here would suggest that that has not happened. Your notice states that a railroad may not refuse to provide service merely because to do so would be inconvenient or unprofitable. The issues of rates and service really cannot be separated. Service offered at prohibitive rates, at uneconomic rates, is simply no service. It simply is no service. Concentration in the freight rail industry has led to monopolistic practices by carriers. The question is what's going to be done to bring this industry under control for the public good. Of course, that is the purpose of this hearing. And in the interest of time, Mr. Chairman and members of the Commission, I would be pleased to stand for questions. And thank you again for this opportunity.
Thank you, Mr. Johnston. Mr. Witt, appreciate your remarks. And Mr. Johnston, I really did enjoy the time we spent together in your great state of North Dakota. It was a very informative trip. I learned a lot and met some very good people. How are things going economically for North Dakota farmers this year?
Well, if you can make it rain, things would be really good. You know, obviously the prices in the last half a dozen months or so have been very strong for agriculture. I think the industry is making significant new investments. What's happened underneath all of that, of course, is you've got enormous increases in costs of production. Others, I'm sure, will testify to that. And on top of that, you have some problems with the the futures markets in terms of being able to actually lock in some of those prices. That's not in your under your jurisdiction, but it is to suggest that there's an awful lot of heightened nervousness, I think, about how this year is going to play out. On the good side, we've got some pretty decent crop insurance coverage out there, and so if it doesn't rain, it looks to be a pretty good year for agriculture.
You mentioned the GAO study of 2006, and you did concede that it was a little bit dated. Thank you for doing that, because I think I feel very strongly that it's dated. It was useful. GAO
Sure.
reports are almost always useful. They're usually not initiated with the goal of confirming how well things are working. They usually are initiated because someone believes there's a real problem somewhere.
Of course.
The report, I can tell you, it was one of the first, I came to the board in August of '06, and the GAO was finishing it up, and so you can be certain I spent a lot of attention reading the entire report, repeatedly meeting with GAO, commenting on it. The report, actually, having worked on the House Government Reform Committee, I've read a lot of GAO reports. That one, if you read its entirety, is a pretty favorable commentary on the overall the STB's stewardship of the Staggers Act and the overall national picture of how rates have been handled by railroads in over a period of years. Now, dated, a lot of things are dated now. The market and the rail industry is changing fast, as you and your constituents know better than anyone. And I just caution folks from over picking out a piece of a study that might have been done a couple of years ago that used data that was even a couple more years old, and then describing that or even intimating that that's an accurate reflection today. This board, we have completely changed our dispute resolution procedures across the board. We now have 3 pending small rate case complaints pending that are scheduled for decision in early July, and so we're open for business and expecting a lot more. And so you compare that to a period of years where you point out there were none. We now have 3 already, and the new system is in its first year of operation. So really the landscape's greatly changed. I encourage all witnesses. History is important, but I'm an amateur historian myself, but it's almost like a picture of the State of the Union address that President Lincoln would have given in 1864, and compare that to what his successor might have delivered in 1866. Something big happened in between there. A war ended, and so we have to be really careful picking our time frames, and let's focus on what's going on at the board now if we can.
Mr. Chairman, I certainly agree with what you have said. I'm hopeful that the processes that you've described are going to be more useful. I think, what we all know is history. We don't know what tomorrow is going to bring, or next year or the year after. And so we do have to look at history. But it is for that very reason that I focus more of my comments on the very real container issue that I spent more of my time talking about today. Because it has been said that history often repeats itself. And as I read that letter, I couldn't help but think that, it sounds a lot like a few years ago when we had farmers in western North Dakota loading up their semis and driving 150 to 200 miles east, paralleling the railroad, to deliver to an elevator to put that grain in a box car or a hopper car and run it right back across the same road traveled, if you will, about 2 miles separated, heading west because of the inverse rate structure. What I think is happening right now with the particular case that I cited is precisely that same thing, only with containers instead of with bulk grain. And so your point is well made about, and that's why I didn't spend as much time talking about the GAO report as I did about the more recent issues.
Well, thanks, and we want to hear about all of those concerns. We do have, as I mentioned, a very active rail consumer assistance program, which is a good starting point. By the way, there is information on that program, I'm told, in the back of the room or perhaps in the corridor as you leave. And I do encourage everyone to pick up that information, because in addition to being open for business on small rate cases, which we've got 3 of now, we have a pending case involving a paper barrier. Hadn't had one of those in a long time. We have a pending case involving a fuel surcharge complaint. Hadn't had one of those ever, I don't think. We've totally reworked our cost of capital measure in a way that seems to have redounded to the benefit of shippers. That wasn't the goal when we set out to it. We just wanted to make sure we had the right measurement. And it looks like it's turned out that way. So I mean, enormous changes. Things that people, when I came to the board, told me wouldn't happen, never had happened, probably couldn't happen, and unless laws were changed by Congress. And so we're going to continue moving forward in that vein. And I appreciate your comments, Mr. Mulvey.
Yeah, got the GAO report as somebody who directed and wrote about 100 GAO reports and testimonies before I came over here. GAO very often does present history, and all GAO reports have the same title, basically, as whatever it is, progress made, more is needed. And I think, as the chairman points out, we have made significant progress in the last few years from what GAO is reporting on. Mr. Witt, in your testimony, you mentioned paper barriers. And could you comment on the problems or the importance of paper barriers in your state and how it affects?
You bet. That was sure, Commissioner. We have some of our short lines the state did purchase. Now, understanding that there were conditions when those short lines were originally spun off, the current operators, we had an extreme measure, if you will. We had one of our trestles burn, which in essence severed the lines. We are looking at the possibility, as the state in this case, of reconnecting 2 lines, 2 that were formerly going by different class 1s, obviously. The current operators are asking questions of us, which we're asking for clarification. Can they, in fact, interchange with each other? Can they reconnect? And currently, some of them are saying, no, we have to go through the, moving it 2 miles this way so the other guys can come. And we're trying to look at it. Is there something that can be done? It's more of a question, can we do something to facilitate something without obviously negating contracts that were originally done for a purpose? So that was the concern of the shippers there. There were these minor short lines trying to deal with multi-million-dollar losses because of infrastructure.
You mentioned this new state-run rail line, the Police
City.
Yeah, I'm familiar with that area. So, how's that line doing? And is this requiring heavy subsidies? And is the state happy with the performance so far?
I think, well, number one, there is no subsidy. Part of the purchase, obviously, other than the purchase itself, there is a rehabilitation fund that was set up originally as part of the purchase by the legislature. We have $8.6 million to put over those 3 lines. We have 3 separate operators. One's operating each one differently. Each had a different goal for each line. I think it's fair to say that they're all struggling to some degree. It is certainly helpful that the grain markets, as most of those are grain-centric, has picked up and done well, as mentioned. But obviously there's a concern. There's always the dynamic. We have the barge system, the river system there close. So do you go rail or do you truck to the barge? Mm-hmm. The legislature, in their wisdom, has required the formation of a intergovernmental entity to, in essence, manage the railroads. The Department of Transportation does not manage the railroad. I'll be very clear about that. The legislature was, so we'll follow up on that. The fact what we do is we administer the contract with the operator. And in this case, we may be doing the rehabilitation at the bequest of the intergovernmental entity. But it is really going to be in their hands as to how they operate. Does it continue to operate? Can they make money? It's really up to the shippers and the operators of the local areas.
Thank you. In your testimony, you say that primarily we believe that the, quote, the railroads have a duty to serve all who apply for their services, and that's the overriding definition of a common carrier today. Do you believe that the common carrier obligation, therefore, currently extends to exempt traffic?
That has been the argument made to us by many of our shippers, obviously the grain side primarily. I'm not sure from our standpoint, we kind of put it forth as a compilation. The Department of Transportation doesn't necessarily take that view. That really isn't our purview, but we wanted to tee it up for you folks to, and I'm sure that you're going to get a lot more testimony along these lines both ways, but it's a question we really wanted to tee up, and I apologize if I was a little misleading with my testimony, but we wanted to actually tee up a bunch of the questions to say, look, this isn't in our purview, but it's certainly our people we serve in our state's concerns.
I appreciate that. Mr. Johnson, could you elaborate on your reference to a monthly rail shipper survey? Is that something that's already going on, or is that something you're proposing, and who would you do it, and how would it be distributed, et cetera?
Draw me to the appropriate page, would you?
Yeah, page 2, I guess it is, and you have several recommendations from your members.
Oh, yes.
And number 4 is the monthly rail shipper survey should be published. You also mentioned about a non-performance arbitration from the National Grain Car Council, and again, I was wondering if that was patterned on something else or something you're recommending de novo.
These actually, Commissioner, are a number of policy recommendations that NASDA has made. And the monthly rail shipper survey information, I think, was recommended in terms of pricing availability so that folks knew what the prices were. In more detail, there was recommendations that there be price availability from different interconnect from the start, the origin to the destination, any of the interconnect points along, that rates be quoted along those, and it was in that vein that was recommended.
Partly addressing the bottleneck rate problem, then, right?
Yes.
Okay. One last question, and that is you also mentioned about co-loading plan for intermodal customers to and from Dilworth. Could you explain what the co-loading is?
Well, co-loading was the idea was for there to be a cooperative approach between several different locations where they would load these facilities or load the cars, and then they would be they would enter the system as a unit then.
I see. Thank you very much.
That was actually one of the things that was suggested by the railroad that the communities work together on.
BNSF.
Yes.
Okay, thank you.
Commissioner Buttrey? No questions. Thank you, panel. We're happy to have you here today, and safe travels as you head home. We just do a little housekeeping. I'll invite the next panel forward, please. This would be the John Cutler of the state of Montana, Terry Whiteside, Idaho Wheat Commission, Kendall Keith, National Grain and Feed, Steve Strege from the North Dakota Grain Dealers Association, Terry Voss of Ag Processing, and John M. Frank of Frank Brothers. This panel will need to bear with us. I'd like to start this panel and get the first couple of statements in the record. Then we will do a 30-minute lunch break shortly after 1 o'clock, and then we'll let the rest of the panel finish their statements, partly because we're looking at the schedule for the rest of the afternoon. We need to try to get at least some of this panel going before we break for lunch. This may well have the distinction of being our largest panel. So
I'm here.
Largest in number. Sometimes there's power in numbers, so we're greatly anticipating your statements.
Sometimes there's a correlation between quality and quantity. So.
Again, please do try to keep within, and special good things will happen to people who actually find a way to shorten their remarks. I can't say what that might be, but you maybe get lunch quicker. That would be at least one thing. But we look forward to your comments. We'll start with John Cutler, representing the state of Montana.
Thank you, Chairman Nottingham. I'd also like to pass on the regrets of Attorney General McGrath and Montana Department of Transportation Director Lynch that they were not able to be here today. At the risk of getting a little bit into history here.
Water levels must be good out there right now.
Here? Water levels good?
On the plains, no, but in the mountains, yes.
For the first 25 years after the Staggers Act, The railroad industry's rationale for minimal regulation and minimal competition was revenue inadequacy. In rulemaking proceeding after rulemaking proceeding, the tiebreaker offered by the railroads was that the financial weakness of the railroad industry should not be jeopardized. This was also the rationale for requiring shippers to assume costs and burdens formerly borne by the railroads.
Mr. Cutler, excuse me. I'm having a terrible time hearing you, and I dare say the people in the back of the room can't hear you at all. Can you hear back there at all? I can't hear you. You have to speak more directly into the microphone.
I'm sorry. Speaker must be right here. I hate to repeat, but I will. For the first 25 years after the Staggers Act, the railroad industry's rationale for minimal regulation and minimal competition was revenue inadequacy. Is that better?
Bring it up just a little.
In rulemaking proceeding after rulemaking proceeding, the tiebreaker offered by the railroads was that the financial weakness of the financial strength of the railroads should not be jeopardized, and their financial weakness should be improved. This was also the rationale for requiring shippers to assume costs and burdens formerly borne by railroads. I started out as a transportation lawyer in 1976. I remember those days well. We won a few and we lost a few, but I have to acknowledge that the bankruptcies of that era were real and that Congress did include in the Staggers Act, along with protections for captive shippers, the mandate that the ICC promote railroad revenue adequacy. Today, we don't hear so much about railroad revenue inadequacy. Most railroads are near or above revenue adequacy. Some are well above. Financial reports for NS and CSX recently indicate improved earnings despite lower freight volumes. It's therefore understandable that the railroad industry needs a trump card other than revenue inadequacy. Capacity and congestion concerns are shaping up as the likely candidate. There have been numerous STB rulemaking proceedings recently, and the railroads have consistently cited the need for infrastructure investment as a rationale for opposing help for captive shippers. I expected similar arguments in this proceeding and feared that the railroads would call for a relaxation of their common carrier obligation. There's less of that than we anticipated, but I'm not entirely comforted. As we point out in our testimony, the railroads have many ways to turn down or deter service requests, even if there's no explicit change in the common carrier obligation. For a heavily rail-dependent state like Montana, arguably the most captive in the nation, rail service on reasonable request is important. However, so are the Staggers Act's protections for captive shippers, including reasonable rates, reasonable charges, reasonable practices, and the common carrier obligation. A sound infrastructure doesn't do much good for shippers who can't get cars, locomotives, or timely service. Infrastructure concerns are getting governmental attention, and for the freight community, that's a good thing. Our record of funding highway construction and maintenance has been poor, even ignoring diversion of funds to earmarked performing arts centers. On behalf of Montana Governor Schweitzer and other agricultural interests I speak for today, however, there's a different set of concerns. Specifically, we're concerned that capacity issues will delay action on captive shipper issues into the indefinite future, well beyond the attainment of railroad revenue adequacy. At a minimum, policy decisions by the board should be based on reality, not appearances. Today, you frequently hear that railroad excess capacity is gone. The railroads say this, and others have gone along, more or less without knowing the facts. I'm one of those people. Recently, when the National Surface Transportation Policy and Revenue Study Commission report came out, I read it not as a rail shipper lawyer, but as a truck shipper lawyer. I was concerned about the way we were going to fund highway construction and maintenance to meet future demands. However, I was surprised in reading through that report to find that that AAR data was cited in support of the proposition that railroad excess capacity is not gone. According to the report, 88% of rail corridors are under capacity, 10 or 12% are at or near capacity, 1% is above capacity. Now, I'm not here to argue against paying attention to infrastructure issues. As I say, I think the government has paid too little attention to infrastructure issues over the years. However, I don't want the infrastructure needs of the railroad industry to be exaggerated to the point that shippers have to wait another 25 years before their concerns are addressed. As I said before, the policy decisions by the board need to be made on the basis of reality, not appearances. Well, you might say if infrastructure capacity constraints are not fierce today, isn't it true that they're going to be soon? Well, here again, we have a study by the National Surface Transportation Revenue and Policy Commission, a group set up by Congress to study this, which included Matt Rose as one of its members who voted in the majority, saying that, yes, we could have a problem. By 2035, it could be serious. We could have 40 or 50% of rail corridors under severe strain. But the assumption underlying that projection is that there's no additional investment in infrastructure for the next 28 years. We think that assumption is completely unrealistic. In fact, we think the railroads deserve a lot of credit for the investments they've made in their infrastructure. I think some of that's overblown. I think a lot of routine maintenance is being characterized as infrastructure investment. But the fact remains that they're a capital-intensive industry, and they could have taken more money out of the industry than they have. Our hats are off to them for that. But they also say they're doing everything they can on infrastructure. And yet, if you look at some of the statements that have been filed in this proceeding, you see UP candidly admitting that there were times when they didn't have enough labor to handle the demand. UP also acknowledged that if they could add 1 mile per hour to the speed of their trains, it would have a huge impact on capacity. Things like positive train control can also help. Now, when the choice presented to the board is, or when the board is presented with a situation in which a shipper is denied service, isn't it incumbent on the board to ask how the railroads are doing on some of these self-help measures that are available to them, particularly at a time when they're not only not revenue adequate, but they're enjoying very high rates of return on their operations. It's also argued that the STB can't micromanage the railroad industry. We understand that, and we're not looking for an STB to stand at the shoulder of the railroads and tell them how to operate in order to maximize capacity. We don't think you can do that. But we also need an umpire when there are situations in which a shipper is concerned that the rationale for denial of service is either poor or non-existent or contrary to public policy. The railroads have also argued that rate issues should be separated from capacity issues. Well, this is sort of the railroads win, the shippers lose position for them to take. On the one hand, they themselves say, don't touch our ability to earn revenues. We need it for infrastructure. But when shippers complain, and it's also obvious that the ability to price is the ability to control demand for services. But when shippers complain about that fact, it's not acknowledged in the railroad's testimony. The bottom line is we think the board is doing some good things. We're glad that you've engaged the Christensen Associates people to look into some of these issues. We're glad that your consumer assistance people are working on these issues. And we're glad to hear that there was never any interest on the part of the board in relaxing the common carrier obligation. That's exactly where we think the board should be on this issue. But we do think the examples of denials of service, of waits for service, of pricing of service require someone to go to for regulatory recourse. And one of the main reasons I'm here is to ask the board not to be stampeded by concerns about potential future capacity crunches into making sure that everything goes the railroad's way today. Thank you.
Thank you, Mr. Cutler. Mr. Whiteside.
Well, good afternoon. Welcome to Washington. I left Montana on Monday morning. It was 0 at the house, so it's always nice to be here. John and I have worked very hard on this statement and trying to make sure it's responsive and responsible. Governor Schweitzer does send his regrets. He really did want to be here, and his schedule just wouldn't allow it, and so we apologize for that. But for the record, my name is Terry Whiteside. My background, I've worked with shippers every day. I have for about the last 30 years. We negotiate freight rates. We find solutions to problems. We work with the railroads. I have very good railroad friends. It's interesting in the provider for shipper services to solve problems. What we've noticed in the last 5 to 7 years is a difference of attitudes at the railroads. And what we want to do today is just really kind of talk about some of those. Some of them have bordered on the common carrier obligation. We don't find that every day. We don't find a problem every day with this. But we do find the problems becoming more pervasive in our conversations. And I'm going to cover just a couple of them. I covered a number of them in the statement that I wrote with John. The Staggers Rail Act, as it was outlined this morning, had really two basic thrusts. And one was to increase railroad finances, but there was a provision to protect the shippers from abuse. And the railroads have always had a special obligation. When they come into this industry, that obligation for common carrier service is there. It isn't something that suddenly they can become totally private like every other company. That obligation continues. At the time when Staggers was passed, the railroads were hurting. The ICC and the STB chose to adjudicate carrier disputes with an eye on railroad finances. We understand that. For 25 years, the railroads' cry was they were poor. And for every proceeding, they made the plea that they were poor and revenue adequacy was important, and it was really a juggernaut that kept rate relief and service relief from shippers. But during this period, there was a push by the railroads also to attract more traffic. They were in the business of finding new traffic and new things to do. Today, we have alleged shortages of capacity, but the railroads are rich. The railroads are doing well. When the capacity problems, whether they're real or exaggerated or partly mythical, I mean, one of the things that John and I struggled long and hard with was how much of this is myth and how much of it is real. Is there a capacity? Yes, there's capacity problems. Is it catastrophic? No, but yet it's being targeted for why we can't do certain things. But it brings a whole set of issues and a whole set of things that we didn't see 10 years ago. This proceeding was suggested or was initiated, I suggest, because the board is hearing of circumstances, of seeing circumstances, of such things as service denials and other complaints that we've heard about this morning. This panel is a very esteemed panel. We've testified together before. What you have is a whole host of knowledge here. The carloads or the railroads are private companies, to be sure, but they are greatly affected with the public interest. I've given several examples of the railroad operating practices that I have personal experience with, and I won't recall them all, but I want to cover a couple of them because I think they're kind of significant. One on page 25 was dealing with a company called Montana Seed Company. And here was a company who wanted to put in an ethanol plant about 30 miles north of Billings on a little place called Broadview, Montana. Service had been there for about 50 years. Broadview was a facility where they had 2 elevators there, both of them being used for storage. The service trains, that's on a sub-main line that goes between Billings and Great Falls. They go through there regularly. Here was the interesting thing. They wanted to ship corn inbound and establish a new ethanol plant. And at the time, there were occasional but regular movements of corn going in there to some of the farmers. Some of the Hutterite colonies were using them for feed. In response to Montana Seed's request to be in, said no local train worked the area. Thus, a passing merchandiser train would have to spot and pull cars, and it was something the railroads did not like to do. So the request by Montana Seed was, would they allow Montana Rail Link to bring them up? Montana Rail Link was willing to do it, 30 miles. It was a dark line. In January 2007, BN said no. and BN indicated they were unable to provide the service to drop off the service finally to Montana Seed, and if Montana Seed was willing to pay for a new train service, then they would be able to do it. Again, we're back to this rationalization of capacity. The second example that I really wanted to talk about was a situation that occurred in the western United States with a ag processor, and the processor was told that they were putting in a brand new plant on a captive line. Of course, what they do is, what they classically do out in that part of the world is they site the plant and then they come to us and say, can you negotiate a freight rate? And always on a captive line. And so you say, well, if you'd been here 6 months ago, we probably could have done something on siting. But the key is, in this one, the railroad came in and started quoting transportation contract rates higher than was in their published tariff rates. And so we sat there for a day, and I said, well, finally, at the end of the day, I said, you know, these are higher than are in your published tariffs. And they said, what tariff? They didn't know they had any. So we sent them home to look at them. They promptly canceled the tariff and then said to us, now you've got to deal with us. Now you have to negotiate a contract with us. It's these kinds of things, and you know, this is not prevalent. This is not every day, but it's a problem that I want the board to understand that does occur. The key to this challenge, I think, is to find what's reasonable. If the railroads act responsibly and reasonably, and all the shippers make responsible and reasonable requests, we probably wouldn't be here. But the real reality is, you've heard, some of the railroad employees don't know what the common carrier obligation is. There is some sense that the railroads want to condition all of the requests on downstream effects on other shippers. That would be like Federal Express saying, I don't want to go down to that ranch because it's 30 miles down that road because it would affect my schedules for all the rest of the day and the whole system. The real reality is, somewhere there has to be a balance there. Taken to an extreme, all the new service or change service could be saddled with handling enormous burdens if it's always comes back to capacity. Yet the railroads want and need new business. What's required here is a balance of a reasonable approach, and most importantly, a strong common obligation is mandatory to mesh public interest with the movement with the goods of the services. What we think is important here is that if the board finds, after consideration and evaluation, that it does not have the full authority to enforce the common carrier obligations the way it thinks it needs to, it should go back to Congress, as the Congress, or as the Senator advised this morning. The board has been invited to seek additional authority in front of several hearings that we've heard, and request additional authority it needs to ensure the development and continuation of what's called the sound transportation system with effective competition that meets the needs of the public. I want to thank this board for having this hearing. I think this is one of the most important hearings we've probably ever had, because it gets to one of the things that came up this morning with Roger with North Dakota was this issue of the intermodal service. All the intermodal service in Montana has been canceled. It's been taken out by the Burlington Northern. We have to go 600 miles now to get intermodal service. And yet, what we're developing across the seas, when we bring trade teams in, when the Montana Wheat and Barley Committee bring trade teams in, well, Idaho brings them in, the people will say, we want that wheat right there. And we can do that with identity preserved. Most of our pulse crops, most of our secondary crops are now out of the triangle being trucked to Canada and put in intermodal service. The Burlington Northern refuses to allow intermodal service in Montana, and they're doing the same thing in North Dakota. This is a service that right now we could utilize. I'm not sure that conversations with the Burlington Northern aren't continuing to go on. I will say this, that I think the Burlington Northern has done an outreach in the last year. I think this board has done some good work in outreach, and I compliment them on that. But we're still having problems with service denials, and they're being denied on the basis of efficiency or capacity. Thank you. Thank you to the board.
Thank you, Mr. Whiteside. And we will now break for 30 minutes for lunch. I apologize for making this panel stand in limbo, but we just need to do that. We will regroup here promptly in 30 minutes, and we have a full afternoon, so look forward to seeing you back. Thanks.
Where can you eat around here in 30 minutes? Huh?
Panel, thanks for being back with us. We will now turn to Mr. Kendall Keith from the National Grain and Feed Association. It's a pleasure to see you here today, Mr. Keith. Enjoyed spending some time with you recently at your conference. Thank you.
Yes, we appreciate the opportunity to testify today. Dan Mack sends his apologies. He had a conflict and could not make it. I will summarize our remarks. The common carrier obligation to us seems to be a rather simple matter of law, but it defies enforcement. We're unaware of any significant action on the part of the ICC or the STB to ensure compliance by carriers with this basic legal provision. Therefore, we are puzzled by some of the comments by the rail industry that express fear that the STB will suddenly take an extremely activist approach to enforce common carrier obligations. At the same time, we think it's rational to conclude that without some reasonable effort toward enforcement, any rule could be judged ineffective. Toward achieving more enforcement of the law in this regard, we would encourage the STB to think about ways to expedite agency action in situations where the common carrier obligation might be subject to violation, either in the distribution of rail service or in railroads' acceptance of additional business. We sincerely believe that a major part of the problem with agency enforcement and market discipline is that the process of filing a complaint and obtaining a decision by the agency is unnecessarily elongated. That adds to the cost and the risk of a formal proceeding. In 1998, NGFA and the major rail carriers initiated an agreement to privately arbitrate some forms of dispute. Specifically excluded from those arbitration provisions were any matters related to rates or service, such as the enforcement of common carrier obligations. Now, the reason for excluding service matters was that we thought it would be very difficult for a privately managed system to order service of any kind or nature. Our rationale was that to order service in one area could, but not necessarily require that service be restricted in other locations. Thus, we concluded that only a government agency like the STB could reasonably address such a regulatory need. But the STB also seems to be hamstrung in legal enforcement as well. In our view, the STB should not insert itself in daily operations of carriers. However, the carriers' comments in this proceeding are laden with dire warnings about the implication of any STB involvement in the enforcement of common carrier matters and what action by a federal regulator might make a bad situation worse. While we would not advise toward a major shift in regulatory intervention, the law does say that the STB is the agency with legal oversight over carriers, and that oversight should at times be exercised. In our view, railroads should not be able to operate without some degree of regulatory risk. We think that is a clear intent of Congress. To ignore problems in the basic provision or provision of basic common carrier services to invite abuse. Rail access and rail service are matters that in periods of constrained capacity should receive more regulatory attention, not less. It should also be acknowledged that railroads over the long term do self-determine their own capacity for delivering rail service. And to the extent that railroads are sellers to captive or inelastic markets, there are incentives to overly restrict the supply of service from what would otherwise be achieved in a competitive marketplace. If the STB does not take action to enforce common carrier matters, the clear message to the regulated carriers is that they should not be concerned about such legal obligations, and they should behave like any other profit-seeking economic sectors. We think this outcome would be a clear violation of the intent of Congress. A few specific concerns. First, many of the challenges of common carrier service in the relationships with shippers and carriers are an extension of the same problems that plague other aspects of the business. It is that the railroads tend to dictate most, if not all, the terms of the business, whether the issue is liability shifting to the shipper, the level of fuel surcharges, the timeliness of service, or other. And unless the customer wants to accept the service on the terms offered by the carrier, the customer is left to find its own alternatives for transportation, which many times don't exist. As for car supply matters, the grain industry has been compelled by the rail industry practices to purchase or lease the vast majority of rail cars used in the business. As part of this business arrangement, the grain and grain processing industry also has been forced to absorb virtually all the risk of variability in the use of this equipment. When a shipper needs changes in a switch agreement to permit, for example, an ethanol plant to begin operations at a location that traditionally has only shipped grain, a railroad should not unilaterally withhold approval of such switching arrangements for extended periods. Regarding the distribution of service, we have some legal precedent to rely upon. In the 8th Circuit Court of Appeals decision regarding the NGFA being Cott case, the court ruled that during periods of constrained capacity, a railroad cannot shift limitless rail capacity from one class of service to another. The court further stated that the railroad cannot offer premium price guaranteed service and simply tell the customer if they want service, they must purchase the premium service. While we have yet to see the STB take any specific action regarding this ruling, the fact that the ruling was issued at the appellate level should provide some discipline in the marketplace. Finally, the grain processing industry remains concerned about the rail service grain shippers receive versus the service provided to other sectors. In that GAO report from 2006, it indicated that of all major classes of shippers, rates for grain and grain products rose at the most rapid pace from the mid-'80s to 2004. If you look at rates since that time on the basis of revenue per cart, grain rates have continued to rise at roughly the same rates, if not exceeding the rates in many of the sectors. Yet, when rail capacity becomes constrained, railroads sometimes still view grain as a commodity that will wait on freight capacity. We acknowledge that grain does not disappear from its origin point simply because the freight is a few days late. But it's also true that in tight supply situations, grain that's not shipped in a timely way can lose a large portion of its economic value, and the cost of that falls squarely on the origin shipper and the farmers being served at that location. In setting priorities for service, we would urge that the carriers and the STB understand the full consequences of poor service in the ag sector. The carriers may not feel the economic pain, but their customers do. Look forward to questions.
Thank you, Mr. Keith. Now we'll turn to Mr. Stephen D. Strege of the North Dakota Grain Dealers Association. Welcome, Mr. Strege.
Thank you, Mr. Chairman, and thanks to the entire board for calling this hearing. I'm the Executive Vice President of the North Dakota Grain Dealers Association. Our state is served by the BNSF, CP Rail, and spin-offs of each of those railroads. 75 to 80% of our crop production moves to market by rail. Much of our state is captive to rail economically and for practical purposes. Huge volumes cannot be moved great distances by truck. All three of you gentlemen have been to our state. Two of you very recently. Vice Chairman Mulvey spoke at our convention this past January and visited with some elevator managers. Chairman Nottingham was there just last month. Mr. Buttry was there during harvest of '06, and the two of you visited some grain elevators and were again reminded of the vastness of the Great Plains. Grain elevators are scattered around where the crop production is, which is almost everywhere. And those wide expanses of crop production and long distances to market are reasons why the common carrier obligation is so important and why this board has a great responsibility in ensuring that it is honored. Getting crops to points of processing, consumption, or export is more than economics. It's keeping food on the table for Americans and foreign customers. Lately, this board has been dealing with cost of capital, paper barriers, and rate case rules. All important matters, but none matter if there is no service. And so the common carrier obligation to serve transcends all of those particular issues. It is the glue that holds our transportation system together, keeping the far-flung points connected. Railroads must be obligated to serve. They should not be able to pick and choose for only their own bottom-line interests. They owe their customers and the public more than that. They have been granted huge franchises to serve, not to exploit. Yes, railroads are private businesses. So are investor-owned utilities. Both provide essential services, and both have public obligations. If hauling containers of electronics and toys is more profitable than hauling grain or coal, it is not okay for a railroad to let the essential goods like grain, and coal fall behind while it hauls the containers. When railroads are granted larger service territories through mergers approved by a public body, such as the ICC or STB, some obligations to the public come with it, and providing essential service is one of those. Our written comments include 9 points regarding the obligation. In summary, those involve railroads making available to all of their customers an adequate supply of serviceable equipment under reasonable terms in response to market needs, and then delivering that service on a timely basis. Being 20 or 30 or 40 days behind is unacceptable. Imagine if delivery services to your local grocery store or shopping mall ran that far behind. Delays cost shippers money, and the grain backs up at farms. Selling capacity at a premium over already very profitable rates and then being late is even more unreasonable. Paying only a one-time penalty for being late is not reasonable when real customers' costs for the delay continue to accumulate. Inaccurate ETAs on trains that need to be loaded quickly is not reasonable. Delays related to severe weather are understandable. The railroad should remember that when dealing with their customers on loading times and demurrage. Regarding how much capacity is expected, I'll echo what Mr. Mulvey said this morning. If the common carrier obligation is only to distribute fairly the capacity a railroad has, then that puts defining the common carrier obligation in the hands of the railroad. And I don't think that's what we want to do. Our written comments address concerns with the marketing of capacity. Shipment sizes or duration commitments which do not fit customers do not honor the common carrier obligation to them. When middlemen are involved, there is some passing of the buck, and railroads are somewhat insulated from true market signals. Railroads should respond to market needs instead of pushing their concepts on the market. Leaving behind rail customers who cannot comply with expensive new concepts is not honoring the common carrier obligation. North Dakota has a diversity of crops. Some of these crops are typically marketed in small lots, not 100-car trains, so reliable access to single cars and small train sizes is very important. These should not be pushed to the back of the line in preference for only large shipments. The common carrier obligation applies to all of them, and most train shippers also load the smaller shipments. A grocery store might find it more efficient to sell potatoes in 100-pound bags only. If there was competition, that store would lose much business to stores offering 20 or 10 or 5-pound bags. The common carrier obligation means effective service to the smaller shipments. We've heard quite a bit said here and other hearings about market-based rates, and I would challenge that definition. A market is composed of a willing number, or a number of willing buyers and willing sellers. And in the rail transportation industry for grain elevators, that's not the case. Most of them have one railroad to go to. So I don't know whether I don't think that's really a market. Our written comments mention the Certificate of Transportation complaint to the ICC. That's been mentioned before here this morning and this afternoon. At least a couple of us at this table are veterans of that. The Eighth Circuit Court of Appeals made it very clear that a common carrier obligation exists and that a preferential program which impairs the railroad's ability to meet it is unlawful, and that decision still stands. A consistent supply of cars offered in ordering programs usable by all customers is essential. The trend, however, has been to more complex programs requiring larger and longer commitments. Frequent changes in train sizes, incentives, penalties, and more make it difficult to keep up with what's new, and the consequences of not knowing the latest railroad change can be significant. This should be a common carrier obligation, not a complicated carrier obligation. This morning, Mr. Chairman, you mentioned the $25 fee on bills of lading as being a problem with KCS shippers, I believe. It reminded me of a situation that a BN shipper told me about some years ago. And he used to call his local yard at Dilworth, Minnesota, to find out when his train was going to come. And the BN centralized things, and at that point, they were going to handle all such inquiries in Topeka, Kansas. So this guy called Topeka, Kansas, and 3 days later, his voicemail was answered, and the guy on the other end said, well, just wait a minute, I'll have to call Dilworth. And so it was a rerouting, a bureaucratic process, and it really intimidates and frustrates shippers when those kinds of things are done. Requiring rail customers to pay for switches that suffer much wear from the carrier's other traffic is not reasonable. Neither are onerous lease terms, including requirements to carry insurance to pay for railroad negligence, and another one is increasing lease payments. Earlier this week, I was told of a situation in Minnesota where one grain elevator's annual lease payment is to be raised from $1,454 to over $13,000. $1,450 to over $13,000. These things do not honor the common carrier obligation. Since staggers and so much rail industry consolidation, the balance of power has shifted even more in favor of the railroads. We believe the STB must take a stronger hand in calling fouls and correcting situations. Even though shippers are organized into associations like those here today, we have no authority over the ever larger and more powerful railroads. Another problem is shipper reluctance to say things for fear of retribution, and so rail customers look to the STB for assistance. Now, regarding the rail consumer assistance services, and this happened before the present folks are in charge. A few years ago, a shipper I know had a problem. He sent the information to that office. The office sent that information to the railroad. The railroad came back and said the shipper didn't have his facts correct, and that was the end of it. So we need more than that. In this proceeding, we think the board should define the common carrier obligation with as much clarity as possible, and then be more willing to step in and correct abuses of the common carrier obligation that have become all too common. Thank you.
Thank you, Mr. Strage. We'll now hear from Mr. Terry J. Voss of the Ag Processing Company.
Thank you, Mr. Chairman. I'm Terry Voss. I work for Ag Processing. We're a regional cooperative based in Omaha, Nebraska. We're owned by 195 local cooperative elevators spread throughout the Midwest, who in turn are owned by 200,000 farmers and ranchers in the Midwest. I'm here representing AGP, our parent company today, as well as the members and owners of us. The grain industry is heavily reliant on rail transportation. Our member elevators, for the most part, are served by a single carrier. Rail service is essential. There's been a steady transformation of rail service from one that was responsive to one that tells the grain industry today how it will operate. The rules are ever changing. I think we are no different than any other shipper or even a railroad. I don't think either of us know really what the common carrier obligation is, but we both have an opinion on what it should be. We at times will tell a railroad that they have the obligation to perform a service, and they disagree. We each have a different opinion. I am not here to complain or make accusations against railroads, but to contribute to the board's understanding of a shipper's view of issues that affect our businesses. Our view is not to address Section 111.01, but railroad service in general nature. This goes beyond having a line of track, locomotives, and crews to haul cars from point A to point B. Is car supply, specifically covered hopper cars, an obligation of railroads to furnish to the grain industry? If so, to what extent? Years ago, the ICC issued a service order requiring that railroads could not have more than 20% of their cars in unit grain train service. Shippers leased and purchased cars. The order later expired. However, the precedent had been set. Today, in the grain processing industry, it is the norm for shippers to furnish a large percentage of the covered hoppers needed. All tank cars, to my knowledge, are furnished by the shippers. It is simply a cost of doing business today for the shipper. Some railroads provide covered hopper cars through an auction system. Many of our members have called me and are concerned. They are confused as to where the common carrier obligation to furnish cars, if there is one, stops, and where the auction starts. The common carrier obligation should have reference to reasonable and consistent service. Inconsistent and unreliable service is extremely harmful to an industry. Let me give you an example. This month, we shipped some cars from one origin to one destination. We shipped cars on Monday, Tuesday, Wednesday, Thursday, and Friday. All cars arrived at the destination the same day. This causes inventory and/or production concerns. Another concern is that if all the cars could not be placed in the plant upon arrival, they would be placed on storage or demurrage charges or chargeable events. Inconsistent service has pushed shippers to lease additional cars and build additional track. Some facilities cannot expand because the town has grown around the plant and streets and houses restrict the expansion of track. The same issues apply to empty cars returning to origin that are bunched. As service changes, so does the need for cars. Consistency is critical. Recently, an elevator received and loaded a train on a Friday, billed it on a Saturday. The following Friday, a train en route to that elevator on a different railroad had to be diverted because the other train had not yet been pulled after 6 days. The elevator incurred the cost of the diversion to the other elevator, the interest rate of carrying the grain in inventory until another train could be placed, and a possible penalty from the buyer for being out of contract. The first railroad should have a common carrier obligation to have pulled that train in a timely fashion, or at least sooner than 6 days. Recently, we have faced situations from two different carriers. Both are requiring or requesting that we block or sort cars based on the destination which the railroad will be delivered to an interchange. I feel the railroads are being paid to do this either through their reciprocal switch agreements or in their line haul rates. We feel the obligation for switching plants, blocking cars, and delivering them is that of the railroads. Every shipper receiver is required to execute an industrial track agreement to receive service. There can be very one-sided and normally not for the side of the shipper. We are aware of an agreement where the shipper is required to waive any protection it may be entitled to under that state's workers' compensation laws, followed by a clause that requires the shipper to acknowledge that this waiver was mutually negotiated. It was not. This agreement was required to be signed as a condition of service. Railroads should have the common carrier or an obligation to be reasonable in this area. Board requested input on embargoes. I don't think they are used enough. When railroads see a problem, they should use an embargo before a destination is totally plugged up. We currently have cars sitting to be spotted to a customer. They have been there 3.5 weeks. The railroad says the receiver's track is out of service. They tell us not to ship cars there anymore to that customer until the problem is resolved. The railroad should really embargo the facility until the customer's problem is resolved, and before additional cars continue to accumulate there, and then we do have a mess, as UP talked about in Arizona. I thank you for the opportunity to present our views and those on behalf of AGP's member owners. Thank you.
Thank you, Mr. Voss. We'll now turn to Mr. John M. Frank of Frank Brothers Feed and Grain Company. Welcome, Mr. Frank. Oh, Mr. Frank, yeah, just push that button so the red light goes on.
My name is John Frank, and I'm the owner of Frank Brothers Feed and Grain Company, located in Wells, Minnesota. I'd like to thank you very much for giving me the opportunity to participate in this hearing and to share with you what is happening to my company at this time. I did testify here, I think it was 33 or 34 years ago, about railroad and shippers issues. I never thought I'd be back. My father purchased and started operating our grain elevator in Wells, Minnesota in 1933, 75 years ago. In 1973, I was very influential in getting the Milwaukee Road, who had our line at that time, to start using unit train shipments of grain. I convinced them that that was the future of grain shipments. In 1978, we had a death in our family. My brother-in-law passed away suddenly, and so I went to our farming operation and I leased my elevator out, by then a 50-car loading facility. It was leased to Pillsbury and eventually PB or ConAgra Grain with their acquisition of the PB Grain division. In 1999, ConAgra terminated the lease with me. We then leased the facility to Watt & Wan Farm Services, and hereinafter WFS, who also had a facility in Wells. It was leased to them for 6 years, from September of 1999 until July 31 of 2005, and they loaded rail cars out of our facility the entire time of the lease. We decided not to lease the facility to WFS beginning August 1 of 2005. They continually lowered the lease payments that we were getting and would do no maintenance to our facility. They had offered to purchase our facility several times, but at a fraction of its value. They told me that if I would not sell at their price, they would put up a bin at their facility and would offer me less the next year. I have 2 sons in the business with me at that time, and we decided to search for financing and operate the facility ourselves. We continued to receive and still receive the newsletters from the IC&E. In August of 2007, we were in talks with an ethanol company to purchase grain for them. We'd been in talks with them since March of 2007. We had also been in talks with a bank for operating funds since August of 2007. I had a question about an item in one of the newsletters emailed to me by Joanne Mortensen, Director of Marketing for the IC&E Railroad. So I emailed my question to her. I received an email back from her, which I have given you a copy of, on August 3rd, 2007, telling me I could no longer load rail cars because they had sold the track beside my elevator to WFS, my competitor. In a phone conversation with her, I asked her how she could sell the track and not contact me beforehand. She said that I hadn't shipped in the facility for years. I said that my lessees had been shipping on there all the time. She then told me that they could do whatever they wanted to do. She told me to contact the real estate department. I contacted Tim Carlson with the IC&E real estate department, and he said he had nothing to do with it, but if Joanne said he did, he would take the blame. He already had my file sitting in front of him. They had sold just enough track to go just a few feet past my facility so that I could not load. From the small amount of information that I've been able to gather, there's plenty of track to the west of my facility, but I can't load because the track beside my place belongs to WFS. Commissioner Butcher, you said in your opening remarks this morning that a shipper that has a truck alternative is not a captive shipper, although if the competitor on the other side of town has rail loading facilities and has a 6 to 10 to 15 cent a bushel advantage, I believe you are captive, and I believe that you're out of business, which is what has happened to us. I'm close to putting an agreement together with an ethanol company to furnish corn to possibly 3 of their plants. But I cannot go any further because they don't want to talk without me having rail. I tried to talk with Steve Milligan, Assistant Vice President of the IC&E, and all I got was a letter that Tim Carlson had sent to me on August 8th of 2007. It was addressed to me in Grenada, Minnesota. I have no address there. I never received the letter. I have 2 other land leases with the IC&E. It amazes me that with the facility in Wells, my home address in Winnebago, and our company offices in Fairmont, that he sends a letter to Grenada, Minnesota. The letter was full of erroneous statements and lies. Mr. Carlson's letter is in the packet that I gave you. Mr. Carlson was trying to cover the actions of the IC&E. That letter also stated that the transfer had taken place in December of 2006, which was 9 months prior to me finding out. On April 15th of 2008, I received a copy of the Tim Carlson letter dated August 8th, 2007. This was the first time I knew what the sale date actually was. Now that WFS and the IC&E Railroad knew that I knew about the track, they started to tell people. On August 6, 2007, I received a call from my banker. He stated that Mike Lepp, one of the top people with WFS, came into the bank and told him that my elevator had little value because they, WFS, owned the track beside my elevator and I could no longer load rail cars. We own a steakhouse in Fairmont, Minnesota. On August 8, 2007, Ed Bosenko, who's the general manager of WFS, came into the lounge of our steakhouse late in the evening when it was all employees, and he told them that I was losing everything I had. He also said my elevator was no good because he owned the rail beside it and I could not load rail cars. It was my night off and I was not there. On August 16th, Mr. Bosenko entered the steakhouse again, and I was there. I met him and told him he was no longer welcome and asked him to leave. He was no longer welcome on a totally unrelated matter. He called me about everything he could think of. He told me that he'd been trying to get me for 4 years for not selling to him at his price, and now he did it. He said he owned the track and I couldn't load rail cars. It is my contention that WFS and IC&E intentionally conspired to drastically reduce the value of our facility and keep us from competing with WFS. We were not given any chance of purchasing the track. There's plenty of track in Wells. They didn't have to sell them the track beside our elevator. We did not find out about the sale until 9 months after the fact. They did everything they could to cover it up as long as they could. The IC&E knew that we had a facility in Wells. We still have 2 land leases with them, and we had personally met with Joanne Mortensen and Steve Milligan about operating the facility. If they are allowed to do this to me, that opens the door for any large company to use its influence to put any small operator out of business. This cost our company hundreds of thousands of dollars in potential income and in lost value to our real estate, and they also hurt the area farmers by eliminating competition. I personally started doing business with the railroads in 1972. I've seen them let their tracks deteriorate and force shippers and state government to rebuild the track, while they invested their income in outside interests and say we can do what we want. In 1992, I was forced to purchase the land that part of my facility was sitting on from the land company created by the Milwaukee Road when they went out of business. The price was quoted to me at $32,000. When I told them there was no land in Wells worth that kind of money for such a small parcel, they raised the price to $47,000 and said if I didn't pay, that I should move my elevator. I guess they thought they could do whatever they wanted. I tried to reason with Steve Milligan. However, in his April 15th letter, which I've given you a copy, he says that they did nothing wrong and they could do what they wanted. I feel this is the ultimate in discriminating against one shipper versus another. I don't know how the federal statutes read, but they have clearly violated the Minnesota statutes. They simply broke the law. If I go out and damage someone's property by $500,000, I'm probably going to go to jail and have to pay restitution. Why should this be any different? Why is the railroad above the law? Why do they think they can do anything they want? If the IC&E is allowed to sell the track to my competitor and put me out of business, there will be no shipper safe from having the same thing happen to them. I intend to do whatever it takes to get the sale of the track by IC&E nullified so that we can enter a contract with the ethanol company and start shipping grain again and put some competition back into our area. I ask the board's efforts to nullify the sale and to let something like this never happen again to another shipper. Thank you.
Thank you, Mr. Frank, and I recently thank you also for copying me recently in the last week on the letter you sent to the state of Minnesota raising some of your state law potential violations, concerns. Rest assured, I've had staff looking into your situation, and we'll continue to be working with you on what, if anything, the board can do. We'll need to get to the bottom of questions like exactly what kind of track is it, what's the legal status of that track. Mr. Keith, it's coincidental you're here now too. We may, if these are actually 2 members of yours, we may prevail on you to see if you can help us untangle this a little bit, but you don't need to commit to that right now. I don't know. Do you know offhand if Mr. Frank's company and his competitor are actually members?
I am not.
Not, okay.
I'm not at this time. I have been off for many years, but right now I'm not.
Okay, that may help answer it.
WFS is a member and ICE is a member.
So. Okay, good. We may call on you informally to help us untangle that. Let's see, Mr. Whiteside, you mentioned a difficult case, the Montana seed experience. Do you know, and thank you for sharing that with us, do you know if they brought that to the attention of the STB? I just don't know the answer. I haven't had time to check that out.
Excuse me, I do not know. I do know they brought it to the governor's attention, and that's how it came to me.
Okay, good. Well, and we have heard a number of troubling reports from this panel, some in great specificity, some somewhat anecdotal, all troubling. But the main, I guess, message I want to impart is please let the board know, particularly our Rail Consumer Assistance Office know as soon as possible with enough specificity so that we can begin to try to do something about it. And it's helpful to hear about experiences at hearings like this, even when they're several years old, but it's even more helpful if we hear about them contemporaneously and in a situation where we can actually do something to make a difference. I personally enjoy, it may sound strange, but enjoy working on solutions to problems like these. I personally make calls to railroad CEOs and other officials and have had some success. And then we've got a very able staff, and I should say we're actively recruiting for additional staff in the rail consumer area. So if anyone here knows anyone who would like to work at the board, now's a good time to be getting in touch with us or checking out our job opening information we post on the web. Let's see. Mr. Strage, you had mentioned, and I heard about this a little bit when I was with you recently in North Dakota, a railroad practice of occasionally requiring shippers to pay for insurance intended to cover negligent actions on the part of the railroads. How does that work?
It's part of the lease where the grain elevator agrees to indemnify the railroad for losses on that lease site, and requires, I believe it actually requires them to purchase insurance. And we've looked into the market, and some of these insurances that are required are not even available. We had a bill in our legislature a couple sessions ago to nullify this, and the railroads, it was primarily the BN lease, they agreed to not oppose the bill, but the provisions apply to only leases from now on. So those who have an existing lease are subject to those requirements. And if they don't have the insurance, which I'm told they can't get, I've had insurance brokers that are experienced in the industry tell me this, then if there would be any kind of a loss, then the grain elevator would be responsible. It's like if the train jumped the track and hit the elevator and burned the elevator down, then the elevator would be responsible for its loss. And if it burned part of the town down, it might be responsible for part of that loss also. It's because the thinking is that if the grain elevator wasn't there, there wouldn't have been an accident. Or if it, I don't know if I'm quite describing it right. It's been a while since I looked into it, but it is a serious problem for grain elevators and other lessees.
Chairman Nottingham, I'd mentioned that I review quite a few sidetrack agreements. It's very common for the sidetrack agreements supplied by the railroads to require the shipper to indemnify the railroad against claims arising out of the railroad's own negligence or misconduct. Yes. Well, it's hold harmless clauses. There are legal defenses to these things. There are a number of courts that say it's against public policy for Party A to be indemnified by Party B against Party A's own negligence. So some of these things may not hold them in court, but they sure are common in these agreements, and not only for small companies either. Some very large corporations have the same type of agreement presented on a take-it-or-leave-it basis.
And there well may be STB staff who know much more about this, but I would welcome anything in the record in the way of examples of some of these clauses or contracts. It sounds troubling to me. I don't understand how a shipper can be expected to promise to reimburse a railroad as a condition of service for costs that are caused by negligent action of a railroad. It doesn't quite add up to me, but thank you for sharing that. Okay. Let's see. Mr. Buttrey, any questions?
I was just curious, Mr. Whiteside, if you could tell me whether you are aware of whether MRL brought that I guess what would be a paper barrier issue to the board's attention. We don't seem to recall it here, and I inquired just briefly about it, and maybe they did, but I don't remember hearing anything about it.
I'm sorry, I'm not following, Mr. Chairman, Mr. Butcher, I'm not following the question. Is it on the Broadview situation?
You had mentioned the problem where MRL could have carried some grain for a customer, and they were not able to carry that grain. They were ready, willing, and able to carry the grain for the customer, but they couldn't carry the grain for the customer because BNS, and the only way the grain's going to get there basically is either if BNSF carries it or if MRL carries it, or if they truck it someplace. And you said if the most economical, the most efficient way of handling this matter would be for MRL to carry it, interchange it with BNSF or somebody, and presumably BNSF, and then they would move it on to its destination. But you said that transaction was cut off, that opportunity for that grain to move that way was cut off by the refusal of BNSF to allow MRL to participate in the movement.
Okay, let's make sure we are talking, because I think we're close to understanding.
Yeah. I
Montana
heard
Seed,
you wrong, but I thought that's what you said.
Montana Seed had asked MRL if they would be willing to carry it, and they said yes, and then the BN told them no, that they wouldn't allow that. So I don't know whether it got to the point where MRL was saying it was a challenge to the paper barrier. That's obviously the reason why. Well, no, I'm not sure that's the reason why. I wouldn't even go that far. It's just that in the situation, Montana Seed asked and was told no by the Burlington Northern, and yet Montana Rail Link was willing to do it.
Do you know how the grain actually moved? Presumably it did move some way, somehow. Do you happen to know how it moved?
No, Montana Seed basically decided they couldn't make the deal work, and so they abandoned the property. I think we're talking. Are we? Hopefully, you're talking about the same issue.
I think we are talking about the same tax situation. Yeah.
Okay, I'm sorry. Okay.
I think we are.
Vice Chairman Mulvey?
Thank you. Mr. Frank, have you contacted the STB's Office of Consumer Enforcement and Consumer Affairs on the problem that you're facing, or have you contacted the board at all before today?
Yes.
You have, okay. And did you get any kind of satisfaction or any kind of assistance at all? Was it helpful, or has it been helpful so far?
Yeah, yes, so far it's been helpful.
Okay, thank you.
And Mr. Mulvey, just so you know, because we haven't had a chance to chat about this, just in the last few days, my office was copied on a letter that Mr. Frank sent to the state of Minnesota, the Commissioner of Transportation, and so I've had some discussions with Mr. Brugman about his work on this. It's all been in the last couple of days.
Okay, thank you. Mr. Strege, your neighbor to the south, South Dakota, has invested state monies in the rail infrastructure, et cetera, and it's been suggested on occasion that if North Dakota did the same, that some of North Dakota's problems might be ameliorated. Do you want to comment on that?
Well, I suppose the railroad would accept investment from anybody, whether they be shippers or the state. And there has been some of that in North Dakota with the rail assistance program. We've got a state fund that's set up. I don't know how much money is in it, but it has been helpful in some situations. I suppose it could be expanded, or you could have more money in it. But, you know, it actually is the railroad's responsibility, I think, to provide that infrastructure there. I was thinking of a line in the couple lines in the central portion of North Dakota that were sold from the BN to a short line to the Red River Valley and Western, and they became well, they were old lines, and there was a lot of CRP land in that part of the state, and so there wasn't as much business anymore. And some of the shippers were willing to put some money in. It would have been a partnership between the railroad and the shippers and the state, but they just couldn't ever get it together, because I think they needed about $7 million. And most of the line was subsequently abandoned.
Okay. This is a question I was going to ask the railroads, but maybe it's just as well to ask you. And what recourse is provided to a buyer who wins service through an auction if that service is not delivered in accordance with its on-time performance guarantee? Do you have any recourse if you don't get what you bid for?
Right now, on the COT program, for instance, in the BN, if they are more than 15 days late, then the shipper can get a $200 per car penalty, one-time payment. Now, sometimes that might cover his extra costs, sometimes it might not, and that was what I mentioned about a one-time penalty. His costs may continue to accumulate if he's continually late. And the shipper has, on that particular program, bid in this auction, and most of the time would have paid over the tariff rate. And so that's what really frustrates them, when they bid a premium over the rate and then they're still late.
So $200 car rebate after 15 days is not exactly fully compensatory.
Well, no, that used to be, I think it was $400 up until about 5 years ago, and then they cut it back. And then earlier this year, they were going to change it to $150 for a 10-day window. They had that in effect for a while, and then they switched back to 200 for a 15-day window.
When they make these changes, are these negotiated changes, or you pretty much take it or leave it?
It's take it or leave it. And in fact, I brought along some sheets here that I printed off of the BN website of some changes that were made earlier this year. And it gets confusing sometimes for managers to be able to keep up with them. Changing rates and train sizes and so forth, and it gets kind of baffling.
Mr. Keith, railroads sometimes claim that agricultural shippers often will hold their product waiting for the best price and then begin moving it all out at once and all demanding service simultaneously, making it impossible for the railroads to deliver. Do you want to comment on that?
There are some years when the nature of the market encourages shippers to hold grain for longer periods than other years. It's true, and sometimes too much grain needs to move at once, and some of that's driven by the marketplace. The marketplace places a certain value on storing grain and selling grain at particular times. Right now, the marketplace is encouraging actually people to store, but the industry can't afford to store it, so they're having to sell it to pay the banker and to pay the Chicago Board of Trade on their hedges. But yes, in fact, that does happen some years, and so you get this pre-harvest rush, and it's a seasonal business, and sometimes the seasonality gets more extreme than other years.
At least this year, the prices have been better than in previous years.
Yes.
It's been noted about the capacity in the rail system, and that this recent report that came out, which said that only 3% of the rail infrastructure was beyond capacity or at capacity. But if you look at the nation's highways, you can make the same observation. The vast majority of our highways are empty most of the day, and that there are parts of the highway system or the railway system that are choke points. And it's the fact that 3% of the whole system being at capacity could, in fact, have an impact on the entire network. So isn't it true that the 3% number really doesn't capture the potential for congestion and problems on the network? Terry or John?
Vice Chairman Mulvey, that can be the case. And one of the focuses of the last highway bill was precisely choke points. There was an effort to identify areas where the bang for the buck in terms of investment would be the greatest. That tends to get tangled up in donor-donee issues and so forth. You're familiar with the problem. Don't misunderstand me. I'm not comfortable with the prospects for us to be hauling freight for the foreseeable future in the way we need to. All I am saying is that I think there has been some exaggeration of capacity issues in support of other aspects of the railroad's desires in terms of how they're regulated.
Thank you.
I thought that's a very good point, Mr. Mulvey. I can say as a former state highway commissioner, I mean, I could try to get away with telling the Virginia General Assembly that 85% of the 7,000 miles of Virginia roadway were not congested most of the day. But when you look at what's going on in Northern Virginia and around the Hampton Roads area, they would throw me out of the Capitol if I told them that we didn't have a problem. But yet it was a fact that when you looked at the whole geography of the Commonwealth of Virginia while I was there, including Southwest Virginia and the Shenandoah Valley and South Side, the percentage of overwhelmed with congestion highways was probably pretty small. But the impact was huge and very threatening to the state's economy, and continues to this day in that state to be one of the top issues that the Commonwealth's going to have a special session of the legislature on and everything else.
Once again, Chairman Nottingham, we're not denying that there are problems here and there, but it's important to be a little bit skeptical sometimes about claims that things shippers want have to be turned down because capacity is constrained. And, well, for example, the argument that excess capacity is gone, you hear that a lot. I used to say that myself. I'm not sure that's always accurate. That's the only point we're trying to make.
Fair point. Thank you. Mr. Voss, you made the point, I believe, about car supply. And is it your position that railroads have a common carrier obligation to provide cars upon request of all types, some types, all the time, sometimes?
Yes. No. Certain types of cars, yeah. Tank cars, I don't think so, because, like, for example, in soybean oil, that's food-grade edible product. You certainly don't want cross-contamination or the risk of that anywhere like that. Covered hopper cars, it's a generic manila folder. I think they've got, they certainly have a large fleet. You saw the BN slide this morning, and they're continuing to grow their fleet. I think they have an obligation to furnish them, yeah. I mean, they furnish lumber cars, furnish auto racks, through trailer train and stuff, our boxes. I think, they've got an obligation. We just don't know what it is. We don't know where the obligation stops and the auction starts.
Commissioner Buttrey?
Mr. Strega, you were talking earlier about the difficulty in getting single car deliveries. You were also talking about being charged for cars sitting too long at your facility or at a facility in North Dakota. What is the situation if you keep a car too long, according to the railroad's requirements? What kind of penalty do you pay, and what kind of penalty does the railroad pay if the railroad doesn't? Is there any reciprocity at all between what you pay and what the railroad pays when the service is not what it is purported to be or what it's agreed to be?
The penalty for being late loading a car is demurrage. I believe it's $50 a day, and there's probably some commodities in some markets there's a 1 day free day or 2 days that you get, and after that then $50 a day. On the COT program, once you get the car, you have that much time, or if it would be a car ordered on the regular tariff program. But under the COT program, you would get that $200 penalty that we just discussed. But under the other program, just the lottery, tariff lottery, I know I'm throwing out a lot of terminology here that maybe you're not familiar with, but there is a lottery for cars at the tariff rate, which is a limited supply of cars. On those, if the railroad would be late in pulling the car, for instance, there would be no penalty. That's one of the things that frustrates shippers too. And as Terry was talking about here, that loading a car and then it sits there for a week or something like that, and maybe you had to hurry up and load in order to avoid a penalty, but then if the car sits there for quite a length of time, it's not always a problem. I'm not saying that, but it happens. Can I elaborate a little bit on that lease question that you asked me, Mr. Chairman?
Sure, yes.
Came to mind a little more after we talked. In 2003, the grain dealers got a bill introduced into the North Dakota legislature that would make it illegal for a railroad to impose liability on the lessee for damage that was not the fault of the lessee. And the response to the railroads was pretty caustic. In fact, the Canadian Pacific sent out a letter that said that if that was to pass, they may have to cut the leases, and people would have to move their facilities off the property. Anyway, we had some support from other lessees, but then that started to fade away. It was a process of intimidation, and we had to back off, and the only thing we got in the end was a limit on the liability that we would have to third parties. We would still have to absorb any damage to our own property, but there was a limit placed on liability to third parties. Then we had another bill in 2005, and I don't remember the details of that, but I can get it to you.
Thank you, Mr. Strachey. Vice Chairman Mulvey, any more questions?
No, that'll be all for today. Thank you very much.
Commissioner Buttrey?
I'd just like to ask anybody on the panel, really, what would be wrong with having a system that provides total reciprocity, that I do this, I get penalized this much if I do something
that's not according to the agreement, and you pay the same amount in case you don't live up to your side of the agreement. What would be wrong with the system?
Absolutely nothing.
It would require reciprocity between the two.
It's just it's nothing. I mean, we've absolutely nothing wrong with that concept. We've proposed that before. It's basically, for simplification, we've called it reverse demurrage. Whereas if we've got 24 or 48 hours to load a car, and it sits 96 hours, what's good for the goose, good for the gander.
You said you proposed that. Where did you?
We proposed that to some carriers.
Okay, but you haven't proposed it to us.
No, we have not.
Okay, I didn't think so.
No, we have not.
Okay.
Mr. Chairman, could I do one follow-through back with Commissioner Buttry? Talking a little bit more about that Montana Rail Link. I am not aware that Montana Rail Link ever came to you, and I'm not aware that they ever went any further than saying that they were willing and able. It's a paper barrier issue. It would have to require acquiescence of the Burlington Northern. That's not a critique of the Burlington Northern. What I'm saying here is that there would be no reason why the Montana Rail Link would want to push that, because they have other business interests with that carrier, and there would really be no reason for them to want to go just for that particular movement to go to the bat for it.
What you're really saying is, I think, what I'm hearing is that it's not that it would be not to be to their benefit. It would be unadvisable for them to do that. That's what you seem to be saying.
That is perfect, perfect diction.
Were you aware of the fact that 10709D1 of the Act directs the board to ensure that the essential terms of each contract for the transportation of agricultural products, including grain, be made available to the general public? Were you aware of that provision?
Summaries, yes.
Summaries.
Yes, I do know that. And for years they were very hard to come by, because you had to actually send somebody over and have them monitor those to be able to get them. And we've done that because we've needed to know what the contracts are, and we have people that would come over and just monitor them. But if they were published on the web, it would be very helpful.
Thank you. Just curious about what you thought about that.
There's some computer service companies that have been providing those for quite a while at a cost. And I understand. I made a call today, and they are on the website today.
Good, thanks.
Hey, one more question, Mr. Whiteside. You say on page 24 of your statement that dominant rail carriers are forcing shippers to negotiate transportation contracts by refusing to publish tariffs or provide service under tariff. These tactics amount to self-deregulation by the railroads as to attack the two rates of service. My understanding is they have to they have to have tariffs available. I mean, this is a violation. Do you have evidence, specific evidence for this?
I do have evidence. It was with, and you notice I did not mention the situation with the ag processor. Those are kind of things that occur. That isn't the first time that's occurred, where they would just cancel a tariff and say, we want you to deal with us on a contract. Is it widespread? No. But does it occur? Yes, sir.
Thank you. Thank you, panel. You're dismissed. Wish you safe travels home, and thank you again for being with us today. Next, we'll call up the next panel, panel 4B, a group of chemical shipper associations. Mr. Jack N. Gerard from the American Chemistry Council. He's the president and CEO of that organization. Mr. Arthur Dungan and Mr. Paul Donovan. Mr. Dungan is the president, and Mr. Donovan is the counsel for the Chlorine Institute. And from the Fertilizer Institute, Mr. Bob Felgenhauer, vice president for transportation and distribution for the Potash Corporation. Welcome, panelists. Give you a moment to get situated. And when you're ready, Mr. Gerard, we will start with you.
Thank you, Mr. Chairman. Am I doing that right? There we go. Thank you, Mr. Chairman, and Vice Chairman Mulvey, and Commissioner Buttry. It's a pleasure to be here today and appreciate the opportunity to testify on behalf of the American Chemistry Council. As the Chairman mentioned, I currently serve as President and CEO of that group, a group that we believe is very important to our domestic economy as well as our livelihoods and the value of the products that we produce and enjoy on an everyday basis.
Hearing others testify and hearing your earlier remarks, Mr. Chairman, I'm going to try to abbreviate mine today and not use my full time and thus gain whatever that reward was you were referencing earlier in the day. So I'm going to be quick here. Our $635 billion industry employs more than 850,000 people in all 50 states. These are direct employees. Products supplied by the chemistry sector are essential in manufacturing, agriculture, energy, transportation, technology, communications, health, education, defense, and in virtually all aspects of our lives. In fact, more than 96% of all manufactured goods are directly touched by the business of chemistry. The business of chemistry depends on the nation's railroads to deliver approximately 170 million tons of products each and every year. Not unlike other bulk commodities, rail transportation is vital to our industry because of the unique composition and characteristics of many chemical products and the large volumes required by our customers. At the outset, I would like to make clear that the railroads have an obligation to serve the transportation needs of this country. Railroads are required to operate in the public interest because the public depends on safe and reliable service in the delivery of a wide range of products on which we all rely. Congress wisely recognized the importance of the common carrier obligation as being fundamental to the effective operation of a rail system to serve the needs of our nation. As long as a railroad holds the operating authority over a line of track, it must respond to all reasonable requests for transportation service on that line. And while Congress has given the board the authority to enforce the common carrier obligation, the power to amend that statutory obligation rests solely with the Congress. I would also like to be clear that railroads have been and will continue to be valuable partners. All major North American railroads are partners of our Responsible Care Initiative, a program originated and managed by the Council which since its inception has been dedicated to the continuous improvement in health, safety, security, and environmental performance, including the safety and security of chemical transportation. While we and the railroads have some differences regarding the best way to promote improved access to competitive and reliable rail service, we will always strive to have a cooperative and constructive relationship to enhance safety and security. Testimony from the railroads suggests there are serious capacity challenges throughout the rail system. Assuming this to be the case, the STB certainly should be considering how it can help address such challenges within the framework of the common carrier obligation and in pursuit of the public interest. We're concerned, however, that with today's hearing, the board is pursuing the wrong line of questioning. If the railroad's projections of increased demand are correct, we should be focused primarily on issues to improve rail capacity, specifically competition and efficiency, and preparing for that increased demand. For the past 25 years, we have watched the railroads consolidate to the point that a handful of railroads control 90% of all rail freight traffic in the U.S. As the Washington Post pointed out this week on the front page, this newfound market power has doubled their industry-wide profits since 2003 and sent their stock prices soaring. To even consider reducing the common carrier obligation instead of addressing the current barriers to competition in the freight rail system would only serve to extend the monopoly power the railroads currently enjoy over their customers. For example, we believe that requiring railroads to quote bottleneck rates and allow for reciprocal switching and additional reforms would greatly expand access to competition and improve the efficiency of the system. And as our members will note in their testimony, removing these barriers can, in many instances, reduce the distance that hazardous materials would have to travel. Rail is a safe mode for transporting chemicals, including hazardous materials. And thanks to efforts on all sides, the railroads, the shippers, car designers, and government regulators, rail transportation is getting even safer. In addition, the federal government has announced several rules, such as the new tank car design standard, analyzing routes and addressing human factors that take a comprehensive approach toward enhancing the safety and security of hazardous rail shipments. We've witnessed a century of safe transportation of these critical materials. but the NTSB has determined that the cause of the most recent fatal accidents were railroad maintenance and operational failures. Now, with increased traffic and perceived capacity constraints, the railroads wish to avoid their common carrier obligation for hazardous materials to focus on other traffic. This clearly has nothing to do with the public interest. The railroads argue that it is not in their interest to move these vital materials. This raises serious questions, including which of the thousands of products made from chemicals and the jobs of Americans who make these products do the railroads wish to eliminate from U.S. commerce. These materials are critical for the production of life-saving medications and medical devices, body armor used by our military and law enforcement, de-icing fluids for airplanes, energy-saving solar panels, and the list goes on and on. To make matters worse, the railroads are trying to sell a fantasy that there are benign alternatives to all these crucial materials in order to avoid their responsibility and appropriate liability for the safe transportation of these products. The current system appropriately places legal liability on the parties that are responsible for an incident. Railroads, as well as hazardous material shippers, should continue to bear liability for their own actions. Removing that liability could erode safety performance by creating a disincentive to address the multitude of factors to enhance rail safety. Our members would be happy to entertain a discussion to address the railroad's liability concerns that would strike a reasonable balance between all parties. However, when the railroads tell our members that we don't want to move your materials unless we are relieved of liability, even in the cases involving gross negligence on the part of railroads, it doesn't set the stage for a very constructive dialogue. As you'll hear from our member companies on later panels, our other great concern is that any curtailing of the railroad's common carrier obligation will serve to extend the already unprecedented dominance they enjoy over their customers, further harming the public interest. Mr. Chairman, we've shared with you our significant concerns regarding policies that protect the railroads from competition and have allowed the railroads to wield monopoly power over their customers. Clearly, any erosion of the common carrier obligation, which could allow railroads to pick and choose the traffic they serve, will greatly exacerbate the market dominance they already enjoy. I will leave it to the individual companies who will testify after me to highlight specific examples of undue leverage, and there are many. In sum, the common carrier obligation is vital to my members and the products they produce, which in turn are part of the lifeblood of our economy and the thousands of essential goods we take for granted each and every day. Thank you again for allowing us to testify. I look forward to responding to any questions. Thank you, Mr. Chairman.
Thank you, Mr. Gerard. We'll now turn it over to Mr. Duncan and Mr. Donovan, who have the next 10 minutes.
Thank you. Mr. Chairman and members of the board, my name is Art Dungan, and I am president of the Chlorine Institute. The Chlorine Institute supports the Surface Transportation Board's efforts to establish a more thorough understanding of the common carrier obligation and to inform those who are affected by this obligation. The Chlorine Institute is a 220-member trade association of chlor-alkali producers, repackagers, distributors, users, and suppliers to the industry. The Institute's mission is the promotion of safety and the protection of human health and the environment in the manufacture, distribution, and use of chlor-alkali chemicals. Chlorine is a naturally occurring chemical element that is essential to life. Chlorine chemistry is used to manufacture thousands of products critical to society's needs, and in particular provides affordable and reliable disinfectants for the benefit of public health. Any suggestion that chlorine can be replaced in this nation's economy is pure fantasy. In more than 95% of the uses, there is no ready substitute. In order to realize these benefits, it is essential to deliver chlorine from production locations to end users, which are often significant distances apart. Approximately 85% of the long-distance delivery takes place via railroad tank car. Rail transportation of chlorine has over time proven to be a safe and efficient way to deliver this product. The continued ability to economically transport chlorine via rail is vital to both our economy and to public health and safety. Common law provided a basis for railroads being considered as common carriers with certain obligations to provide service on demand. The Interstate Commerce Act codified many of these common carrier obligations and also created new ones. The Surface Transportation Board announced that this hearing will focus on various topics related to the common carrier obligation. The Chlorine Institute has offered its written testimony to the 8 specific items raised by the STB. However, time permits me only to address some of them at this time. First, service limitations resulting from a constrained environment. Increased international trade and movements within the United States have resulted in higher demand on the U.S. rail system. However, it is the obligation of a common carrier to increase capacity to meet this demand. It is incumbent on the carrier to make the needed investments in technological and infrastructure improvements. Railroads have increased their operating income by 85%, and their stock prices have nearly doubled in the 3-year period ending in 2006. The rate of return on investment by railroads in 2006 was over 10% for the first time since 1929. The railroads have the ability to provide additional capacity if they choose to do so. Regrettably, in many cases, the railroads have failed to make the needed investments. A strong U.S. economy requires a rail system which supports it by providing transportation upon reasonable request. The Chlorine Institute urges the Board to use its regulatory and moral authority to require the U.S. railroads to increase capacity to overcome restraints to shipments. Cost and safety issues related to the transportation of hazardous materials. The rail transportation of TIH materials, and chlorine in particular, has been very safe. The Chlorine Institute and its members are working with affected parties, including government regulators, to make such transportation even safer. Since 1909, there have been over 2 million loaded shipments of chlorine with 6 fatal releases. Of these 6 releases, 2 occurred in the 2004-2005 period. The National Transportation Safety Board investigations attributed the 2004-2005 releases to railroad operational failures. A common carrier has a responsibility not only to transport goods upon reasonable request, but to do so in a safe and secure manner. Clearly, the railroads have the ability to make their respective systems inherently safer by such systems such as greater use of signaling track and by adopting more comprehensive operating procedures. Regrettably, for the most part, these vitally needed improvements have not been made. Because the common carrier obligation is a statutory one, the Board is not an appropriate forum on which to argue for a change in this obligation. The Board should not allow unilateral action by a railroad to change statutory requirements. The Chlorine Institute urges the Board not to make any change to the common carrier obligation unless such change is debated and authorized by Congress. Carrier-imposed requirements for infrastructure investment by shippers. We are concerned about the reasonableness of some carrier-imposed requirements for infrastructure investment by shippers. Recently, the Association of American Railroads adopted new standards for railroad tank cars transporting TIH materials. These requirements were done without sound engineering and without government and industry concurrence. Further, these requirements would have provided only marginal improvement in accident survivability at a great cost to industry. In the meantime, a separate initiative was launched, which included members of the Chlorine Institute as well as one of the Class 1 railroads, with the objective to develop a rail car with 5 to 10 times better performance than the current rail car and significantly better than the proposed AAR standard. Instead of working with this team, the AAR simply ignored this initiative. The AAR also ignored the root cause of the incidents that brought about the activity. The Chlorine Institute supports the continuous improvement in the design of chlorine rail cars. However, such enhanced design must be based on sound engineering and must be authorized by the Department of Transportation, not the AAR. Economically motivated service reductions and metering of the demand for service. Railroad transportation is an industry which has a unique role and which has been given unique privileges. In contrast to the trucking industry, the rail industry has a much higher barrier to entry from a regulatory perspective and from a capital perspective. Rail rights of way were deeded to railroads long ago, and in most cases on very favorable terms. It is virtually impossible for a new competitor to obtain the necessary new rights of way, effectively barring them from entry. Accordingly, the common carrier obligation cannot reasonably be limited while preserving the public good. The idea of economic metering of service has no place in rationing the common carrier obligation. The underlying motive of the U.S. rail industry in attacking the obligation to provide common carrier service to TIH shippers relates to liability for these movements and the costs related to the two recent incidents that the NTSB attributed to railroad operational failures. The chlor-alkali industry was saddened by the deaths and injuries that resulted from these accidents and understands that the costs of the responses and cleanups were significant. The chlor-alkali industry has undertaken numerous steps to develop rail cars which would be more likely to survive the types of railroad operational failures that have occurred. It must not be forgotten that there has been a very strong long-term safety record with the current robust standard rail car design. The Chlorine Institute fully supports the intent of the FRA TIH tank car standard, which we expect will result in chlorine and other TIH tank cars with greater accident survivability through the use of new design and fabrication technology and through safer railroad operating procedures and practices. In summary, the common carrier responsibility, particularly as it is applied to railroads, has a long history in U.S. law. Limiting the applicability to exclude essential chemicals would have a devastating effect on the U.S. economy. There is no justification to limit this obligation. The Chlorine Institute urges the Board not to make any change in the common carrier obligation unless such change is debated and authorized by congressional action. Thank you for allowing the Chlorine Institute to present its views to the Board. I'll be glad to answer your questions later.
Thank you, Mr. Duncan. We'll now turn to Mr. Bob Felgenhauer from the Fertilizer Institute.
Thank you. Good afternoon, gentlemen. My name is Bob Felgenhauer, and I work for Potash. Sorry? Is that better? I guess it is. Yeah. My name is Bob Felgenhauer, and I work for Potash Corp. Potash Corp is the world's largest fertilizer producer by capacity, with headquarters in Saskatoon, Saskatchewan, and U.S. headquarters in Northbrook, Illinois. We ship over 8 million tons of fertilizer per year on the U.S. rail system, generating freight revenue in excess of $300 million a year. Included in this is over 600,000 tons of anhydrous ammonia shipments per year, generating freight revenue in excess of $22 million. I am here today as a member of the Fertilizer Institute. TFI is a national trade organization that represents the interests of fertilizer producers, wholesalers, retailers, and others involved in the use of fertilizer in agriculture. TFI members are particularly concerned today with the common carrier obligation as it applies to the transportation of anhydrous ammonia. As you gentlemen know, anhydrous ammonia is a TIH commodity, and there has been much discussion as it relates to the movement on the rails. We believe that rail transportation of anhydrous ammonia is critical to our food supply, energy policy, clean air, industrial production, and the national economy in general. The most prevalent use of anhydrous ammonia is as a nitrogen fertilizer essential to growing food for millions of Americans. It is the least costly and most effective source of nitrogen fertilizer to American farmers. In addition to its direct application as a fertilizer, it is also the base raw material for a lot of downstream nitrogen materials like urea and UAN solution, and also phosphate materials like DAP and MAP. Fertilizers high in nitrogen are essential for crops like corn, which is the largest consumer of a direct applied anhydrous ammonia. A single rail car of ammonia produces approximately 128,000 bushels of corn, which can be used to feed 1,600 head of cattle or produce 345,000 gallons of ethanol. Corn is also used in thousands of basic food products that are found on our grocery shelves. Export food security is quickly becoming the #1 issue around the world. Export tariffs in China, as well as civil unrest in Haiti and Egypt, are all a result for increasing demand for better quality food that can only be produced with an effective and reliable source of nitrogen fertilizer. There is simply no substitute for anhydrous ammonia in maintaining our country's and our world's food supply. Anhydrous ammonia is also used in a variety of industrial applications and is the only raw material available for some consumer goods. For example, anhydrous ammonia is necessary to produce certain pharmaceuticals, adhesives, feed supplements, personal care products, and nylon fibers. If you just look around this room, the carpet on the floor, the cushions on the seats, the ink in our pens, and if anybody's wearing cologne or perfume, the perfume on your bodies was all manufactured with anhydrous ammonia as the raw material feedstock. None of these products have a substitute material to produce them. We believe that rail is much safer than any other alternative to trucks for hauling anhydrous ammonia. It keeps this essential TIH commodity off of our nation's highways, where we believe the potential for accidents is many times greater to the general public. According to the AAR's own data, in 2005, which is the most recent year that they had information, 99.997% of all rail hazardous material shipments reached their final destination without a release caused by an accident. AAR statistics also show that on average, a little over 50,000 rail shipments totaling 4 million tons a year of anhydrous ammonia is shipped between 2000 and 2005. It takes 4 trucks to equal 1 rail car of ammonia. If all this was converted over to trucks, this would equate to over 200,000 truck shipments. If stacked end to end, would extend all the way from this hearing room to Los Angeles, California. We don't believe that's in the best interest of the nation. The AAR has called upon producers of TIH commodities, including ammonia, to cease their production and has even urged Congress to enact legislation to require such action. We believe this to be an unreasonable request, unsupported by the facts, and based upon an irresponsible, short-sighted, and self-interested attempt to avoid the common carrier obligation to haul these commodities. In a misinformed attempt to show that rail transportation of ammonia can be significantly reduced, the rail industry has suggested that farmers replace anhydrous ammonia with non-hazardous nitrogen fertilizers like urea or UAN. We don't believe this is possible. I'd like to just take a few minutes to explain why. First, because ammonia is the critical raw material to all other downstream materials, urea, UAN, and a lot of nitrogen-containing phosphate materials, you cannot produce those downstream materials unless you have ammonia available at the production sites to produce the substitutes. Second, ammonia is a much higher nitrogen content. The substitutes are a much lower content. If you were to try to replace this with ammonia, you would end up having to ship, store, produce, and apply 2 to 3 times more the amount of nitrogen fertilizer that's currently going down in the ground. Third, even if you could do that, if you had the storage available, if you had the infrastructure available to handle it, there's not enough production capacity in the world today that could handle the substitutes. All the production capacity in the world is operating at full, and you cannot replace the ammonia that's out there. Fourth, ammonia producers and distributors have a tremendous amount of money invested in infrastructure. All of that would be stranded, and a tremendous amount of capital would have to be put back into new infrastructure in order to handle the substitute products. And fifth, and very, very important, is ammonia gives you the ability to apply nitrogen in the fall. The other products, you cannot put nitrogen down in the fall for the production of a grain crop due to potential environmental losses. So if you didn't have the ammonia, you would have to take all of this that's being direct applied, put it in the spring with everything else that's being done, which already is a very tight window, in between rain showers in order to get everything done. And agriculture is really only part of the picture. The U.S. industrial market, which is defined as ammonia, which isn't used to make downstream fertilizer products or used as direct application, consumes about 6 to 6.5 million tons of ammonia a year. Of this, about 2.3 to 2.4 million tons is shipped on the rails. In some manufacturing processes which use ammonia, product substitution just isn't possible. The rail industry has suggested that ammonia could be shipped in a diluted solution known as aqua ammonia, which is a 29% anhydrous. This would require 3 times the current number of rail shipments with a substantial increase in infrastructure investment, such as rail cars, storage facilities that are currently not in place for most shippers. In addition to tripling rail shipments, making costly production modifications, and significantly increasing infrastructure investment, aqua ammonia would require the treatment and disposal of over 2 billion gallons of water annually. The most obvious way that the railroads have tried to keep ammonia off the rails is by rates. TFI members report that their rail rates have nearly tripled over the time since 2004, excluding fuel surcharges. My company, Potash Corp., estimates that we're paying about 110% premium to ship ammonia versus other commodities, which is costing us about $6.5 million annually in additional transportation costs. By increasing rail rates to such high levels, railroads are able to discourage the shipments of ammonia without actually having to refuse to transport those shipments. Rail rate increases have actually made trucks a little bit more competitive. Typically, you can only take a truck out about 200 miles before it wasn't competitive with rail anymore. But with the increase in rail rates, you can now take trucks out about 500 miles and still be competitive with rail. Again, we don't believe this is in the best interest and feel that it is the rail industry ability to demarket ammonia through higher rates. Because of that, more ammonia is moving by truck. If you took my company, Potash Corp., and took all of our ammonia and switched it over to truck, all of our rail ammonia and switched it over to truck, we would add over 20 million truck miles to an already congested U.S. highway system and consume over 3 million gallons of diesel fuel annually. This is 2 million gallons more than the railroads are consuming. We understand that liability is an issue. And as TFI, we have presented a proposal to the railroads to help solve this. We believe you have to come up with a business solution first before you can go for a legislative solution. We have offered to work with the railroads to look for an insurance policy. We have been told that there's $1 to $1.5 billion of available insurance out there in the event of a release caused by an accident. TFI is willing to work with the railroads if they'll carry primary insurance, and then the TFI would pick up insurance over this amount to cover in the event of a release. This does not indemnify the railroads. It does not take the liability away from them. But what it does do is they're constantly telling us that the reason our rates are so high is because of the cost of the insurance. We're offering to pick up a portion of the cost of this insurance. In return, we would like a reduction in our rates and stability in rates going forward. My red light is on. Thanks for your time, gentlemen. I'll be happy to answer questions.
Thank you, Mr. Felgenhauer, and thank all the witnesses. Mr. Gerard, if I could start with you. You quoted some impressive statistics at the beginning of your testimony about the size of your association, your membership companies, the number of employees. Just ballparking, have you had occasion to compare the size and scope of your member companies with that of the U.S. freight rail industry?
I haven't. We compete in a global world, as I'm sure you appreciate, so we operate all around the world, in Europe, China, the emerging world, India, and elsewhere. So we're probably significantly larger, but I haven't taken the time to make that comparison. I'm not sure what value that would provide, but we're happy to do it if you'd like to see it.
No, I just think it's interesting. I mean, the scope and the size of your industry is just enormous. And it leads to my next question. I've had the chance to visit some of your member facilities, and I've appreciated that opportunity. And I've learned in those visits that, of course, many chemical company facilities also have big-time rail operations on them.
Absolutely.
And in some respects, your members are very much in the rail business, so to speak, and that you've got infrastructure on your property, track that your members own and need to maintain and build. Do you keep track of the investments that your industry makes directly into rail infrastructure?
We do not keep track of it. I could probably find that out. We have generally moved, if you will, into the rail sector to that extent, largely because we have to. When we're told that if we want additional places to park rail cars, tank cars, or whatever, that we have to build it out on our own facility, we do that. That one member company told me about 6 months ago that their investment in their rail structure over the next 2 years will be $300 million. Not by choice, but by the reality of the competitive relationship between them as a customer to the railroads. So yes, we are in that business to the extent we have to be to remain competitive in the global environment. But if that would be helpful to the board, I'd be happy to go back and try to put together those numbers for you.
I think it would be helpful, just for a number of reasons, but there is a lot more going on, it occurs to me, in the area of rail infrastructure than just maybe what the big four Class 1 railroads account for. There's the short line sector, which is not your responsibility, but and also industry. And I think it relates too to something that's not really front and center at this hearing, and I won't make it front and center, but which is the proposal pending in Congress for an investment tax credit for rail infrastructure. I mean, it occurs to me if you've got a member company or more than one investing something like $300 million over a period of years in rail infrastructure, that they should be incentivized. I think that's a tremendous benefit they're providing not only to their bottom line, the shareholders, but to the country's transportation system in avoiding backlogs and choke points. And frankly, I think your members are more than maybe some shippers, frankly, able because of their size and scope to actually make a meaningful difference on the infrastructure landscape.
Yes, we have looked at that. Let me make one comment if I can there, Mr. Chairman. First, this might be a great question for some of those who will follow me who specifically are making these investments. I think if you look at the question historically, what you see is that over time there have been more and more of the rail infrastructure that has been shifted to the shipper. I think the GAO pointed this out in a recent study. For example, in our case, all the tank cars are held or leased by us as companies. The railroads don't own those cars. And likewise, the infrastructure at our individual plants or connecting routes or others, more and more of that is falling in our lap. Not by choice. We haven't preferred to be in the railroad business, or we would have gone into that business. But the reality and what we need to try and compete across this country. I hear your message on the investment tax credit. If we felt we had a good mutual relationship currently in the economic realm with the railroads, we'd be happy to support that initiative and others. And that's why I mentioned in my testimony, we think the line of questioning here is headed, if you will, either too narrowly or in the wrong direction. If we look down the road over the next 10, 15, 20, 30 years and we say, what is the capacity that's going to be required in this country, not only to serve the needs of our growing population, but for those of us who compete in the global environment, I believe that's the question we should have on the table. How do we expand that capacity, and how do we do it in a meaningful way so that we have adequate capacity in the future, as opposed to looking at this more narrowly, saying, well, how can we get out from under this obligation or this obligation and use justification like constrained capacity or liability costs or whatever. I think we ought to change the debate and be forward-looking to be more visionary in what we're talking about.
Are you suggesting then that you might forego supporting a pending bill that would provide enormous benefits to your members just because it might also benefit a group of companies you don't particularly care for right now, the railroads?
No, I didn't say that at all. In fact, we're not convinced it would bring benefits to our members. Our belief is that we should bring together and once again look to the future and say, what is the appropriate relationship between railroads and the customers they serve, and then how do we make sure we expand that capacity? Is it through an investment tax credit? Is it further relationships on questions of liability? Is it further routing issues? What is it? But we believe the economic relationship between us and the railroads is currently at such imbalance that that must be corrected first in the current environment before we move to that future look and to see the vision of the future, if you will.
And I'm not suggesting how you should do your job, Mr. Tour. Lord knows you've been doing your work much longer than I would ever care to pretend to know about. But it's, if you suggest that you've got at least one member that's planning to spend $300 million on rail infrastructure, and there's a pending bill that would give that member and all your members the ability to get a tax credit for those kind of investments, it's hard to believe that it's not in your members' interests to support that. And I'm not pushing that bill today. I'm just probing because I think it's just a point of curiosity.
We think it's a pretty short-sighted view. In order to get a small tax credit for the $300 million investment and turn around in the current relationship and be forced to spend $1 billion 2 years from now, we don't think it's a very good investment. And so our view is let's look at the long term. Let's balance the various relationships across the rail customer situation. And when we do that, let's do it holistically. Let's talk about this capacity question. Let's talk about the current relationship we have now in the competitive environment. And if we do it that way, you'll see us become the biggest cheerleaders for their activities to expand this capacity.
Okay, thanks. How are your members doing financially? I saw yesterday in the Wall Street Journal that DuPont reported 26% increase in first quarter profits from a year ago. It's a pretty impressive number. Congratulations. We'll have DuPont with us in a minute. I'll
Absolutely.
Congratulate them. That's impressive, especially given some of the challenges facing our economy today. And I realize that numbers like that have a major international component and dimension to them, I'm sure, given the nature of the business internationally. But how are your members doing in general? Could you give us a quick overview financially? Is yours an industry that is on the brink of disaster, massive layoffs, or doing pretty well, posting significant profits? Give me a sense of how it's going.
Yes to all the above. Let me explain if I can. It's relatively complicated. Let's look at it in two different ways. You look at DuPont's earnings, for example. They may have done well in this particular quarter, but if you look at it globally, that's the way to assess, if you will, the strength of a company like DuPont. What we're talking about here today is by and large limited to the borders of the United States, a domestic service, in this case rail capacity. The impact that it has on us to do well globally is significant from this base of the United States. Now, what do I mean by that? In our sector here in the United States, over the last 5 or 6 years, we have lost 120,000 jobs. Now, these are high-paying jobs, the best jobs around, with great benefits, well-educated people, et cetera, et cetera. The challenge is because of domestic policies. Our first great problem right now is the price of natural gas, which we use as a feedstock. We take natural gas, we convert it to products, chlorine chain and all the rest of it, and then convert it into all the materials each of us enjoy every day. 96% of all manufactured goods are touched by us. That's number one concern. Number two concern to a lot of our members is their transportation costs. And that's why, as you probably sensed in my opening statement, we feel so strongly about this issue right now. It impedes our ability to compete globally. We have companies in this country who limit the infrastructure they build in this country and potentially move it offshore because of the cost of rail rates. You'll hear from one of our CEOs today who will tell you that his rail rate costs are now higher than his manufacturing costs. Now, when we've got that type of imbalance, yeah, we can look at a company on a global basis and say they're doing pretty well. Start looking behind the curtain and you'll find the revenues are coming from China, India, the Middle East. I spent last week in Dubai. Why? A lot of our companies are building great relationships with the Middle East now, by and large through the cost of petroleum and natural gas. That is the future of this domestic industry if we don't get these domestic policies right. We don't want to go to China and India at the expense of the United States. But if the economics are such, if we can't get competition in a rail system so that it's unclear what our costs will be to build a major facility. By the way, we're currently building 120 major chemical plants around the world, a major plant being at least $1 billion of investment. Not one of those is in the United States. Why? Because of the cost structure here in this country. And our transportation cost is a big factor. So again, our point would be, let's look at this from a domestic perspective, which is what it is. But it impacts those of us who compete globally and dictates, are we going to build that facility here in the United States? Or are we going to put another plant in the Middle East or China or India where the emerging market is? Is that helpful?
It is. Offhand, do you know how many of your member companies last year reported a loss?
I don't know offhand. I certainly hope none of them do, and I certainly hope none of them do in the future. For the sake of the country, for all the stocks that each of us enjoy in our 401ks and everything else, I hope they do well. I would hope the board feels the same way.
Me too, and you went to some length to point out that in recent years, railroads have been doing pretty well financially.
Absolutely.
And I just think it's only fair to try to give a good snapshot of how your industry is doing too, and just to have it all laid out there.
Well, let me put that in context if I can, Mr. Chairman. I think the comment was made earlier, and I don't know if it was a panel before us or earlier today, about a lot of the concern in the rail industry early on when we used to talk about these competitive interests was based on revenue adequacy. That was always the excuse why we couldn't have a hard competition discussion. That's not an excuse anymore. So what's the discussion today? Capacity constraint. And now from our sector, it's a liability issue. Well, when did liability come on the scene? It's been the last few years. Liability wasn't a big concern 10 years ago, 20 years ago, yet they were hauling volumes of our materials, TIHs, hazardous materials, etc. So we believe some of this debate is ebbing and flowing. We don't want to be so cynical as to suggest there's strategy and other things involved with this, but at the end of the day, we think it's critically important that we reassess the competitive relationship between our industries and others which are customers of the rail sector and figure out a way to balance that relationship for the benefit of all of us, particularly our domestic economy.
Thanks. I have some more questions, but I want to share the time and let Vice Chairman Mulvey have some questions.
I have, let me start out with the question to the Fertilizer Institute. Have you done any estimates of the output effects on American agriculture if anhydrous ammonia were not available, or if you had to substitute it with the available amounts of urea or other substitutes, what that would mean to the total agricultural production of the country? In terms of total fertilizer. Like corn, for example.
Yeah, in terms of total fertilizer, we estimate that without fertilizer, we wouldn't have 40% of today's food. Breaking that down into just ammonia, there's about 4 million tons of ammonia consumed, direct applied as fertilizer, and there's probably, I'd have to get you the exact numbers, but I would guess that it's somewhere in the, Pam, you can help me here, 40-50%, I guess, of the total goes down as ammonia.
You mentioned about the willingness to fund primary insurance with the railroads picking up secondary, or the railroads on the side covering the primary, then you would go beyond that. What percentage of that insurance cost would the railroads be responsible for, or what would be the primary?
Yeah, what we looked at is the railroads have been telling us for some time that the reason our rates are so high is because of the liability, and a lot of that has to do with what they have to spend for insurance in order to cover that liability. So we started doing our own research into the insurance markets, and we spoke to a few brokers, and we visited with some offshore insurance markets. And what we've come up with is that we believe there's somewhere between $1 billion and $1.5 billion worth of insurance coverage out there to cover the railroads in the event of a release from an accident. What we have requested from them is that they cover the first $500 million under their primary insurance. That would be the first to pay under an accident. Anything above that, then, up to the maximum that we could secure, which we believe to be another $1 billion, would be covered by insurance policies purchased by TFI members that would be purchased through an assessment per ton for ammonia shippers that ship by rail.
The railroads sometimes claim that they're betting the firm, or betting the farm, whatever, every time they carry hazardous materials, and that the cost of a spill, for example, say in Chicago or New York or Washington, D.C., could be tens of thousands of lives, and even $1.5 billion wouldn't cover that. Do you see a need for something like a Price-Anderson kind of approach, whereby, especially if the railroads were also required to contribute to it?
We have talked about that, and our belief on that was that no one would listen to us until we exhausted all business solutions. And that our intent here was to work with the railroads to try to exhaust that business solution. Once we have maxed out that insurance market, we then have offered to go with the railroads to either the Surface Transportation Board or to Congress or to wherever we need to go to in order to enact overall caps for the movement of TIH materials.
In your testimony, you mentioned about the relative cost of moving it by truck versus rail, and you said that the higher rail rates up to 500 miles, it's expanded to 500 miles, I think that's like one way, by truck. Is that still true given the current price of diesel of almost $4 a gallon and the higher driver wages and the lack of drivers? Are these estimates fairly current, or are they a little bit dated now?
I looked at it last week, and for us, the break-even is right around 400 miles, is where rail becomes more competitive than the truck.
Most anhydrous ammonia, though, if I recall, especially that used in agriculture, moves by pipeline, correct?
There is, in total, there's about 2 million tons that moves by pipeline, about 4 million tons that moves by rail.
So it's 4 million by rail and 2 million by pipeline?
Yes.
Is it possible to shift more to pipeline? I know there's two major pipelines, I guess, coming out of Louisiana and the Texas Gulf area, right?
That is correct. That is correct. Pipelines are about at capacity. There's not, you couldn't push all 4 of those million tons through the pipeline. And then also, with the pipelines, you're fairly restricted to where they end. The pipeline's pretty well run up the river system, the Mississippi River system, then branch off to the west into Iowa, branch off to the east into Indiana. They stop in Indiana, and then they head out a little bit further west. But for those that are significant distance from the pipeline, it's really not an option. Those that are close to the pipeline certainly haul that material by truck.
Right.
The ones where we have to ship the rail to is really where truck is not an option.
The Chlorine Institute, the problem is often with the delivery of chlorine to water treatment plants, or at least that's what's been brought up as a threat, that these water treatment plants are in urban areas and that chlorine moving through cities to these water treatment plants are problematic. Is that, can you isolate the chlorine that's moving to water treatment plants compared to movements of chlorine to other places, and that perhaps the movement to water treatment plants in urban areas can be addressed by rerouting the trains, for example, as was suggested here in Washington?
Well, certainly most of the chlorine, I wouldn't say most, a vast amount of the chlorine that goes through the urban areas is directed eventually to water treatment areas, certainly in the Northeast, that's correct. But frequently that chlorine goes by rail car to a repackager who then puts it in a 1-ton container or a 150-pound cylinder, then sells that to a water treatment facility. Now, there have been several water treatment facilities, both drinking and wastewater, that have converted. Certainly in the Washington area, wastewater facility has converted. The Washington Sanitary District has converted their wastewater treatment system to bleach. But there are many of these, and others are considering it. But many of these facilities cannot. I visited a facility in Chicago and one in New York City. And in Chicago, it's the world's largest water treatment facility. They just physically cannot have the capability. They don't have the capability to install bleach or any other kind of chemical treatment. They have to put a whole new infrastructure system in. And most facilities, even if they have a different system for primary disinfection, they have chlorine, and it's usually elemental chlorine, as a residual, which is required by the US EPA. So, but water treatment is only 5%. 95% of chlorine has no alternate uses. And while there's a vast amount of chlorine that's shipped, we need to remind you there's a lot of chlorine that is consumed on site. Probably about 75% of the chlorine produced in the United States is produced on site or transferred by short-distance pipelines. But we're talking 3.5 million tons of chlorine that are shipped primarily by rail.
Yeah, I was referring to the chlorine shipments that had elicited the greatest attention, and that seems to be that which is moving in urban areas to wastewater.
It's my understanding the railroads, and certainly the CSX system has implemented some voluntary agreements to reroute chlorine around Washington, D.C., and now there's a proposal out that the government will be looking at the options and what are the best routing routes, and we support that. That's really a carrier decision on which is the best way to transport chlorine.
There's always a trade-off between the most direct routes, which often go through urban areas, but go over Class 6 track, well-maintained, good track, versus moving around more roundabout routes, but unfortunately over Class 1, Class 2 track or accepted track where the likelihood of an accident is greater because of the quality of the infrastructure. So there is always that trade-off.
That's correct.
Versus risk. So.
Right, yes.
You mentioned about a 10% rate of return for the railroads, and I guess it's similar to Chairman Nottingham's question. Is 10% a high rate of return for firms in your industry?
We don't calculate that because, one, our members are part of the American Chemistry Council, and we don't ever see and we don't track chlor-alkali results separately. We can certainly say the last few years the chlor-alkali industry has done reasonably well, but the last year there has been a downturn with the housing industry. We've seen cutbacks, and while we'd like to see our members profitable, one of our members unfortunately did go into bankruptcy early this year. Another one who is very big in vinyl, has sustained massive losses. Those are just what I read from press accounts. But certainly the stock prices of the chemical portion of our members, or certainly the chlor-alkali, if you just look at the chemical portion of our members, they haven't doubled in the 3-year period from 2003 to 2006. In fact, another member company, I heard, because their profits are dropping this year, have instituted travel curtailments for non-essential travel. So we're seeing more of this in the industry now. So certainly this year in the chlor-alkali, I would expect there'll be a downturn in profitability.
Mr. Gerard, you were talking about the competitiveness of the U.S. chemical industry and the investments being made abroad, et cetera. But I believe it was someone testifying from the railroads one time, referring to the problems facing the American chemistry industry and the top 10 problems, and transportation wasn't one of them. What percentage of your total cost for most shipments are, and I'm sure this is kind of a broad question, I guess, because you have multiple different kinds of products, but are transportation costs and high transportation costs really critical compared to, say, government regulations, compared to environmental rules and regulations, compared to, as you said, the cost of natural gas? Aren't these much more determinant than the cost of rail transportation in your investment decision making and location decision making?
Well, transportation is a critical factor, or an important factor, if you will, in our decision making process. And let me give you some anecdotal evidence as to why that is. For some time, I think our industry has had some concerns with the process and the relationship with the railroads. Since I took over the American Chemistry Council a little over 2 years ago, what we do each year is we identify through the CEOs, we do a survey of priority issues and priority questions for the industry. What are those issues that matter most to us? Transportation, specifically rail transportation, has been in the top 5 in the last 2 years. So is it the number one cost? Probably not. Most of their number one costs right now, like I say, are feedstock costs, in this case natural gas. For example, Dow Chemical, I'm trying to remember the numbers, their annual energy cost was typically around $25 billion. Today it's about double or almost triple that. It's outrageous what's going on in the energy markets right now. But close behind that, many will tell me that transportation is their number 2 cost. Now, again, that varies from company to company, so I don't want to make a blanket statement here and leave the impression it's number 2 everywhere. But clearly for some, particularly those who have less competition opportunities, it's a bigger factor. But again, just like all these factors, it plays into the decision-making process. Where do you site a plant? Many of our people will tell you quietly, they're always a little reluctant to say this publicly, but they will tell you privately that unless there are at least 2 rail lines to a particular location, they will not build a plant. That's how important it is to them. So it's a factor that influences heavily board decisions as to invest money in the United States, or we have to take that money elsewhere to be competitive in this global economy. So I hope no one underestimates this is a critical factor to us, a very important consideration as we look at our cost structure and try to remain competitive.
Thank you.
Mr. Buttry? Mr. Felgenhauer, is that the way you pronounce that?
Yes, very good.
I think you said that you had a proposal on the table that would provide that the railroads pay the first $500 million, and then you would get insurance. There would be insurance to cover the rest of the liability up to $1.5 billion.
As high as we could get, yes, and we believe it's $1.5 billion.
And are you saying your company has that proposal on the table, or does the American Chemistry Council has that proposal on the table, or who actually has that proposal?
That proposal was made by the Fertilizer Institute, first to the AAR, and then the AAR has told us that they would prefer that we deal directly with each of the Class 1 railroads. So that proposal has now been made to each one of the Class 1 railroads. Now, in return for that, of course.
Do they all serve your company?
No, they do not. They do not all serve our company. But the way that
the AAR is not brokering this deal.
Well, the AAR asked us to work. We met with the AAR, but they did ask us to work directly with the Class 1s.
Okay. So is there a similar proposal on the table from your organization, Mr. Gerard?
No, we don't have a proposal.
Do you have any proposal on the table?
We have had conversations with the
just
railroad.
opposing everything.
No, we don't oppose everything. We'd like to have a good dialogue. The last proposal we saw was a proposal by the railroads to give them complete release of liability, even in cases of gross negligence. So we would hope that they'd move from that position a little bit so we could have a candid, reasonable dialogue, and we have committed to do that.
Do you like Mr. Felgenhauer's Fertilizer Institute proposal?
I haven't seen the proposal. We'd clearly be happy to entertain it. The fact is, the other proposals have been talked about, a Price-Anderson structure, et cetera. We're open to all opportunities, all proposals to somehow balance this relationship.
Are you open to capping the liability to $1.5 billion?
We'd be happy to consider any proposal.
Commissioner Butcher,
If the railroads agreed to the 500 and the 1.5, then you're saying you would help the railroads get a cap at 1.5?
We'd be happy to sit with our members and look at that in light of the various economic factors in our broader relationship and decide, is that the best way to address this issue? And if we agreed, absolutely.
How do your members insure against catastrophic release at your facilities, at your production facilities?
Well, they obviously
I have the same question to you, Mr. President.
Yeah, they obviously have insurance to cover all those, which is the other factor. We're quite sophisticated and understand what that takes. We deal with these materials, these hazardous materials and TIHs all day, every day of the week. So we're expert, if you will, in this, and we can be very helpful in this dialogue with the railroads. As this might be a secondary consideration of them, if you will, as they're trying to run their railroads.
And you, Mr. Felgenhauer?
yeah, we also have, part of our insurance is certainly self-insured, but we also have insurance policies at our production facilities, and our risk managers are working with us and the railroads to develop this policy. If I could just add one thing to clarify our position, what's very important to us, too, is to do this, we would expect to see a reduction in our rates for hauling anhydrous ammonia, and we would expect to see rate stability going forward, because we feel like we're taking away the biggest risk that they have.
So the railroads are telling you that part of their rate, or at least a certain percentage of their rate that they're quoting you, is based on the fact that this is a serious issue for them in terms of liability, and you know what that percentage is above the base rate. You know what that percentage is?
I'm not sure I follow your question about
Well,
the
if it's
percentage.
$1,000 a car and you're having to pay $1,500, it's $500 worth of that. Do you know how much the surcharge is for liability coverage?
The railroads haven't told us directly what that is, certainly. They're not going to, but we've run the math ourselves and just basis what they charge us for other commodities versus what their charges for anhydrous ammonia on similar lanes. As I mentioned, we've seen our ammonia rates triple since 2004. During that same period, if you look at the railroads' SEC filings, their rates up during that period are up around 35%. So, we can do the math and estimate that variance is due to the liability of ammonia.
Okay. I think that does it for me.
Thank you, Commissioner Buttrey. Mr. Gerard, I just want to make sure I understand where your association is on the possibility of some type of consensus legislative proposal that would address what I hope you at least recognize as a problem. I think earlier today, previous panels certainly helped us recognize the problem, which is railroads, of course, have this common carrier obligation. Certain types of materials are more risky than others, and sadly, the sorry state of our American tort liability system, especially in certain states more than others, actually means that it's possible for a railroad to not be negligent, yet to experience a release because of an act of nature or an act of a truck wrongfully crossing onto a railroad track and knocking over a car, but still find themselves liable for billions of dollars in damages to the extent that it could bankrupt an entire company. And given the choice, obviously, any business would prefer not to have to be exposed to that kind of risk. Your members are no strangers, as you just touched on, to risk management. You're probably some of the most expert practitioners of it. Similarly, I would hazard to guess that one of the few businesses that the tort liability bar would take pleasure in suing above railroads would be chemical companies. And deep pockets, not everybody agrees out there that with some of the environmental history of the chemical industries, and I'm not this is not my position. I'm just saying your members know full well the problems of our American tort liability system and what it's evolved into. I don't think the system has always been as troubled as it is now. In fact, I'm pretty comfortable in saying, we talked earlier in my opening comments, that the common carrier obligation goes back to Roman Empire times and certainly British common law times in the Middle Ages. And I can certainly say that those societies did not have a tort liability situation that we have here. And if they did, I'm not quite sure they would have structured, and nor would Congress have structured the playing field quite the way it is now. So anyway, we have the situation as it is. Do you recognize that this presents a problem? Because we heard earlier that, of course, these insurance costs and the risk management costs have to get paid for by somebody, and they're getting passed along to shippers. The first shippers that we can presume railroads try to pass the costs on to are chemical shippers, if they associate the increased insurance premiums primarily with the requirement that they carry products of the chemical industry. But then beyond that, we heard earlier today that railroads pass on those costs in part to all shippers. So every shipper is paying because of this problem, and I would argue it's rippling well beyond that into the economy. What's your position on what the solution should be?
Well, let me react, if I can, a couple different ways. The first one is, I guess, let's assess what the problem is. Is the problem the tort system in the United States, or is it liability assumed as a result of a common carrier obligation? And obviously, we as an industry assume all those other risks just like every other industry does. Tort lawyers, all the rest of it. It's part of doing business in this country. Unfortunately, in that case, it gives us all additional exposure we prefer not to have. We are willing, as I mentioned in my opening statement, and very happy to sit down with the rail sector and talk about this question. Again, I think we should put it in the context of what we're looking at generally. Has this become a function of a recent accident? Therefore, it's become front and center. I think, as the Fertilizer Institute mentioned, they've seen their rates go up, 3 times in the last 3 or 4 years. So was it a recent incident that sparked this issue? And if so, let's assess that situation, look at this generically, or more broadly, if you will, as to what the answer should be to it. We're happy to have those dialogues, those considerations. We'll tell you that we're fully liable for any risk and any activity that goes on in our facility as we work with these chemicals and these important materials that are critical to our lives and to our well-being. The reason we live 20 years longer in this century than we did last century is directly a result of the chemistry and the things that we do in the area of pharmaceuticals and life-saving instruments. The list goes on and on. So I think it needs to be clearly understood. We understand those issues well. We're happy to work with our colleagues in the rail industry to better help them understand them and to work with them on what the right solution is. But the right solution is not to give us complete liability for their activities. And to date, that's been part of their position. So if we can get rid of that, let's move to the center and figure this out. We're open to dialogue. But we also feel very strongly that as part of that dialogue, we need to talk about the relationship between the rail sector and those of us who use them, those of us as customers. We don't often feel like customers in this relationship, which was something, frankly, that kind of shocked me and appalled me when I came to work for this industry. I've never had anybody treat me so poorly as a customer. And so we want to look at that question. As you well know, Mr. Chairman, we're active on Capitol Hill right now because we believe there's some fundamental changes that have to be made to that relationship. So we want to look at it in a holistic approach, just like we look at the question of safety. We've worked with the rails over time. Within our industry, we've had for 30 years the Chemtrek operation. We're the first responders, I shouldn't say responders, we're the first notification when there's an incident around this country, be it in the rails, be it on trucks, or anyplace else. We mobilize our people. We've paid for that asset because we take full responsibility for the materials we work with and we use to advance our common interest in our society. So yes, we do not oppose everything. We're very anxious to have a dialogue, but we want it to be a balanced dialogue, and we think it should be a holistic dialogue so that when the agreement is reached, we can look to the future and say there's a fair economic commercial relationship between these entities, and it will govern us for the next 10, 20, 30 years as we try to compete globally and as they try to get a fair return on their investment. both of which we hope can be accomplished.
Thank you. You said something earlier that was news to me, that the railroad's position is that they need to be relieved or absolved of total liability exposure for acts of gross negligence. We'll have some railroad people with us again tomorrow, and I'll certainly explore that with them, because that to me just flat out doesn't make sense. I don't know how you ever would get...
I agree with you on that, Mr. Chairman. I would encourage you to ask them about it.
Assuming we can get through that in about 5 minutes, which I'm confident I can, and get them to abandon that position if it ever was.
Okay.
Let's just assume their position is probably going to be what I've heard it is before, more along the lines of, when it's not gross negligence, can we talk about a cap as a society for the one industry out there that's required to carry highly dangerous poisonous material through the largest cities in America? And if we decide to change that, it doesn't give me much more relief to say they're bringing it through the smallest towns in America, because frankly a life in Mayberry is just as valuable as a life in Washington, D.C. So we'll quickly get to that point. And when we do I understand your position to be, well, we have to somehow put together an omnibus bill that addresses all of the chemical industry's concerns with railroad regulation, that go back to things that maybe the chemical industry didn't get when Staggers was passed, and we've got to have everything all in one package, and then we'll try to get that through Congress, because that to me sounds like an awfully unrealistic scenario.
If you were representing the railroads, I'd expect they would say that to me.
And I'm not.
Oh, okay.
I'm just giving you.
Just wanted to make sure.
As I have with you, I've certainly had discussions with them.
Understand.
It's my job to, because it's an incredibly important problem, and I'm going out of the way not to restate what you've told me in more what I would call off the record context, because that's not appropriate. But I sort of know what your bottom line is, but I'm trying to let you state it here on the record.
Well, if I haven't been clear, let me try to restate it if I can. I'm obviously not being very articulate. We think it's important, as we look at the issues before us today, to take a holistic approach. Look to the future, not to figure out how to narrow the common carrier obligation in this country, but to figure out what is in the best interest of the public, what is in the best interest of our society to continue to move goods and services so we can compete not only domestically, but globally. So we believe there are factors that should come into that discussion, liability being a very important one, and we're prepared and willing to consider all proposals and come up with some of our own as we address that component of a holistic approach. Does that help?
A little bit. I mean, I wish for a little more of a specific answer. What I believe you're saying is that until you get the railroad's complete capitulation on your other legislative agenda, you're not going to help work out a consensus bill that affects everybody, grain shippers, all shippers, American society, to try to get a handle on possibly capping or limiting this liability exposure.
I appreciate you putting words in my mouth, but that's not what I said. I said that we think there should be a holistic approach to this question.
What does that mean?
Holistic.
You say holistic, and I say
liability question?
Complete capitulation by the railroads on all of your legislative agenda.
No, I wouldn't say that at all, any more than us being capitulate to them completely in terms of gross negligence. Let's look at the liability question. Let's also look at issues like bottleneck that we think is critically important to us. We think it would provide more competition, would give us a more competitive rate to compete. Reciprocal switching. Those are but a few, and I think we could do that in a holistic way. We ought to include this board. We ought to include the Congress. We ought to include others. We ought to have that dialogue. But we need to recognize the importance of it to the future of our domestic economy and for those of us who have to compete globally. Because if we don't get it right, it's going to have outcomes, perhaps negative if we don't do it well. So our hope is, rather than do this piecemeal one at a time, it's a little bit like an energy policy. Let's not go out and do a little bit of nuke over here, a little bit of natural gas here. Let's have a broad, comprehensive energy policy. We think we ought to have a rail transportation policy and address the various components of that would look to the future, expand capacity, deal with liability, and deal with these other concerns so we know what the future is and how it'll play out. Does that help?
I appreciate your effort. It's still it's very general, but I think you are making an effort to respond. I'd like to explore is just to make sure I understand the chemical American Chemistry Council, if I understand what you've said, does not support any proposal currently to address the situation of unlimited liability exposure borne by railroads and thereby and passed on in the way of costs through rates, et cetera, to all shippers.
We think we have been in ongoing dialogue with the railroads, and this has been one of the pieces of that discussion, and it's our intent to continue that dialogue and continue to consider all proposal. We don't believe we nor the railroads have settled on the perfect answer yet. So we think the process is evolving. It should continue to evolve until we can work it out, and then we can both support what it is we agree to.
Can I ask when the last time you spoke to them about this is?
To the railroads?
Ongoing dialogue, what does that mean?
We've had personal meetings at the highest level late last year, and we're working on some things internally that we hope to have further dialogue with them in the near future. Very near future, we hope.
It just occurs to me, it's just ironic to me that your position currently of really non-support for anything specific that's on the table or close to being on the table is basically identical to the position of the trial lawyer and tort law bar, which typically I wouldn't associate your association having a lot in common as far as policy agenda, and you're just playing right into their hands and just making this whole problem even worse, because instead of having people who should be highly incentivized towards working towards a consensus solution, you're playing into the hands of folks who, for their own selfish reasons, don't want common sense in addressing our tort liability problems.
Well, I appreciate your characterization, and again, let me for the record state I strongly disagree with your views, Mr. Chairman. We are not playing into anybody's hands. We believe there needs to be a commercial relationship, and right now we take full responsibility and full liability for our product on our premises. When we turn it over to a carrier, we expect that carrier to take full liability for it because they are in total control of it. If you look at the National Transportation Safety Board's conclusions of the last incidences that we've had that have raised this issue, it hasn't been the fault of the chemical industry. So what's the answer to that? We think there's probably a balance there between those two positions. We're happy to consider a solution to that. We believe there's ongoing dialogue. We think there needs to be ongoing dialogue. I don't know what the trial lawyers have to do with it, and I don't know why your position is such that you characterize us as playing into their hands one way or another. Could be nothing further from the truth. So let me again state, if it's not clear, that we're happy to consider any and all proposals. We think the first position on the part of the railroads was irresponsible, making us take complete and full liability even in the cases of gross negligence. So if we can get some movement from that position a little closer to the center, we think we can probably have a good constructive dialogue and hopefully come out with a good positive commercial answer.
Vice Chairman Wolf, you've been very patient. Let me let you get some questions.
Thank you. In fact, I was afraid I was looking impatient because I wanted to follow up on this. Your group, the Chemistry Council, was very supportive of HR 2125 and S953, and there's an awful lot in those bills which would affect the railroads, the bottleneck rates, reciprocal switching, and on and on and on. And you said you wanted a holistic approach, and I think the chairman was characterizing it as more or less capitulation on all of these things. If you really got all of those things passed in either of those or both those legislations, do you not think that it would have an effect on the railroad's bottom line so that they would not be anywhere near the astounding 10% return on investment they got last year? And wouldn't that also then cause a problem for the quality of service that your companies might receive?
Well, we think the bottom line is, and having been the process for a number of years, that obviously the lists included in the pieces of legislation before the Congress are probably a good starting point for a healthy conversation and discussion about what the real issues are. Do we expect that that'll be the final product of the Congress? Probably not, as all of you well know, and I think each of you here having much experience in that forum understand. But you got to start someplace. We have not yet received from our colleagues in the rail industry exactly which parts of that they would like taken out, other than proposals to get rid of all of it. And so I think we do have a bit of a polarized situation, and my hope would be that perhaps with the help of this good board that we could help bring us closer to the center.
So you are willing to compromise that?
Absolutely, absolutely. I don't think we're expecting anything. We don't expect anybody to capitulate all their position. We want the railroads to be healthy. Let me just state that for the record if it's not understood. Our hope is that moving forward that they do very well. We just don't want them to do it at our expense. And so right now, let's find a balance between the two interests and the commercial interest. And we think we sort those out, then we can both move forward and both do well into the future.
We previously heard from the agricultural community, and they were saying they didn't want it done at their expense, and we expect to hear later from the coal shippers who don't want it done at their expense. And I don't know how much we can charge at the modal movements, but someone has to pay the freight, so to speak. And obviously, given the nature of the economics of the railroad sector, there does need to be what economists call price discrimination, which is sometimes given a euphemistic line of a price differentiation, but differential pricing, but that's what it means to. There does have to be these differential prices. And the railroads obviously will need to cover their costs some way if they're going to make the investments that most people feel are going to be needed to meet the demands of the future. I have one other question for the Chlorine Institute. In the written statements on page 4, the example you provide is an instance in which Class 1's actions seem to actually reduce system capacity. And I have a question. Was there a paper barrier involved in that example that you talk about on page 2? Page 2, I believe it's paragraph.
Yeah. I don't know if there's a paper barrier. It was just the railroad did not want to transfer to the short line. They wanted to keep their, we can presume, I don't know what their real motives were, but our member believes that their motives were to retain all the revenue for themselves, so they went a longer distance.
Okay, so this was just they wanted to keep it for themselves. It may not have been a case of a paper barrier, which of course is one of the things that is addressed in your legislation. Thank you.
Commissioner Buttrey?
That's all for me.
I just wanted to just to say to Mr. Felgenhauer, I commend the Fertilizer Institute for actually coming up with a proposal. I haven't studied it. I look forward to learning a little more about it. I mean, it's too important an issue. It appears that you agree to not be working on specific proposals, and I really do commend you and your staff for making that effort. If the board can be of help, I say this to all of the witnesses, including Mr. Gerard, we are more than happy to be a forum for bringing parties together, either informally or formally, and we are very much a problem-solving type group here. Our general preference is not to have a lot of preconditions that say if we don't promise to solve these 107 problems, then we won't talk about this other one. I mean, everything should be on the table, but I commend you, and I look forward to learning more about that.
Thank you, Mr. Chairman. We'd be happy to keep you informed of our progress.
Good. Any other questions, colleagues? No. Thank you. You've been very patient, panel. We appreciate it. We will bring the next panel up, please. We've got a panel of chemical shippers, the Dow Chemical Company, represented by Cindy Elliott, Director for Global Supply Chain Sourcing, Charles Cogliandro from the Calabrian Corporation, Gary Spitzer from DuPont. Welcome, witnesses. Thanks for being with us today. I know you've come from out of town, and we appreciate it. Our first witness on this panel we'll hear from is Ms. Cindy Elliott from the Dow Chemical Company. I've had the pleasure of getting to know Ms. Elliott and both visiting her facilities in Texas and meetings here in Washington. It's very good to see you again, and we welcome you here.
Thank you. Thanks for the opportunity to present comments regarding Dow's view of the railroad's common carrier obligation. I'm the Global Supply Chain Sourcing Director for Dow, responsible for ensuring that we have the most effective logistics infrastructure in place to serve our businesses and our customers globally. We are a diversified chemical company with $54 billion in sales annually and 46,000 employees. We deliver a broad range of products across virtually every industry, providing functionality for 90% of the goods people use every day. We believe the common carrier obligation of the railroads is to serve the public need is clear. Since the earliest days of the industry, railroads have been regarded as public highways, organized for the public interest and to serve the public good and convenience. It is inconsistent with the common carrier obligation to consider only the needs of the railroads while ignoring the needs of the shippers and the nation's economy and public welfare. Dow supports a constructive approach that arrives at mutually beneficial solutions and shared responsibility to support U.S. industry competitiveness, safety, and security. We are very concerned about the railroad's aggressive efforts to stop or avoid transportation of selective chemical products. This issue is important to us because Dow's investment in North American rail transportation is very significant. We manage a 26,000 rail car fleet and process more than 130,000 shipments per year, half of which are liquid chemicals. Our first priority in managing our supply chain is to do what is within Dow's control to create a safe and secure environment in which to work and transport goods for our employees and the communities we serve. We have a long track record of innovation and consistent investment to improve our safety performance with respect to the transportation of chemicals. To that point, Dow has worked closely with our logistics service providers across all modes of transportation to achieve an incident-free rate of 99.97%. Our safety efforts have been extensively recognized by the railroads. In 2007 alone, Dow received awards from Norfolk Southern, CSXT, Canadian Pacific, Canadian National, and BNSF, highlighting our leadership and performance in safety practices. Since 9/11, we have bolstered our community outreach as well as partnered with government agencies like the Departments of Transportation and Homeland Security to develop and implement joint safety and security programs. Those efforts are essential to the long-term sustainability of U.S. industry, allowing manufacturers to produce and ship vital products and at the same time improve the safety of our neighboring communities. Rail and chemical industry initiatives are further improving safety and security. In 2006, Dow published a comprehensive 10-year strategy for supply chain sustainability that is based on the premise of eliminating incidents. This program is aligned with our vision of zero, a company-wide total safety commitment aimed at zero accidents, zero injuries, and zero excuses. 4 components of that strategy include, first, redesigning our supply chain to reduce the number of shipments and container miles for specific products to enable shorter routes and product swaps. We have set a bold goal, regardless of mode, to reduce the number of hazardous shipments and container miles in half. Second, improving the visibility of shipments through implementation of GPS and sensor technologies so that product movement can be tracked anywhere, anytime. Third, redesigning our shipping containers to prevent tampering and to reduce the potential for chemical releases due to accidents or security incidences. For example, Dow has been an important participant in the federal R&D effort for the next generation rail tank car, which provides a step change in safety performance, specifically 5 to 10-fold improvement. Fourth, enhancing our collaboration with carriers and local communities to improve emergency preparedness and response should a chemical release occur. We are a founding member of TransCare, a proactive and collaborative effort between the chemical industry, railroads, and communities to appropriately respond to emergency situations. While we've been conducting outreach via TransCare for more than 20 years, since 2007 we have stepped up our efforts specifically along rail transportation routes. In fact, as we speak, Dow is involved in a 10-city tour on a route that starts in Louisiana and ends in Chicago. Dow takes very seriously our obligation to responsibly manufacture and move our products, and we believe public, private, and cross-industry partnerships are vital to our nation's security. Just as Dow manages its risks as a producer and or user of hazardous materials, the railroad industry should focus its efforts on doing the same. rather than trying to avoid its common carrier obligation to transport these materials altogether. Does it cost more money to focus on the safety and security of transporting our products? Yes. And at times, it appears to have unreasonable cost disadvantages. In fact, it is literally 3 to 5 times more expensive for us to ship TIH materials on a per-car basis than any other chemical product. Some Class 1 railroads have claimed that they are now pricing their transportation of TIH materials to discourage longer distance movements and shorter distances. However, that has not been our experience. In one recent example, Dow worked collaboratively with industry partners to reduce the number of miles we were shipping chlorine by 2/3, going from 1,400 miles to 450 miles. In return for this successful supply chain redesign, we were penalized with an 88% rail rate increase, the equivalent of a $1 million impact annually. The price tag for reducing risk was hardly motivating. It is becoming clear to us that the railroads are more interested in using price to eliminate these movements altogether than creatively exploring options where everyone wins. This is just one example to illustrate the point, but there are many. In fact, despite our efforts since 2006, Dow has faced significant rate increases of 100% or more for TIH products. And based on the way the railroads have structured future track agreements, we continue to assume the full burden of infrastructure costs required to move these materials. Rail is the most effective, lowest risk way to move chemical products. A scenario that involves the loss of rail service due to the common carrier obligation disappearing would result in 4 times more chemical shipments if we had to move them by truck. The increased number of shipments would have a cascading risk effect in both transportation hazards and in on-site loading and unloading operations. Furthermore, the new truck volume would compound practical concerns around highway congestion, accident prevention, and lack of available specialized tank truck and driver capacity. Imagine for a moment if just Dow's chemical rail shipments were to move by truck. If you consider our rail car volumes and convert them to tank trucks, that translates to an additional 250,000 tank trucks per year. This represents a 15% increase in the bulk tank truck market sector today, and there are simply not enough trucks in the market to absorb this demand at any price. Bottom line, converting our chemical rail shipments to truck is not physically possible, and efforts to do so would bring U.S. manufacturing to a screeching halt. The safety and security of chemical shipments by rail is a shared responsibility of the industry and the railroad and the government. Dow urges the STB to protect the common carrier obligation from being eroded by the railroads because that obligation is vital to public interest. As common carriers, the railroads enjoy numerous privileges in addition to their responsibilities. We acknowledge many of the special commercial protections the railroads have enjoyed over the years, but we also believe that in return for these privileges, they are obligated to support our business and our customers' business. The railroads operate in a highly concentrated industry with very high barriers to entry. This leaves companies like Dow with no reasonable competitive alternatives if the railroads are unwilling to serve us. As a shipper, Dow has been challenged with extraordinary rate increases on TIH products, taken steps to redesign our supply chains, asked for significant concessions from our customers, participated in community outreach, and worked with the government to enhance safety, security, and emergency response. The common carrier obligation is an obligation that requires the railroads to transport materials as long as the request is reasonable. We believe the chemical industry in general, and Dow specifically, has been very reasonable. We have lived up to our obligation and, in fact, stepped up our investments, and we believe railroads must do the same. Thank you for the opportunity to comment and provide our input on this critical issue.
Thank you, Ms. Elliott, and your timing was perfect. I wish I could have you give some of my testimony when I go up to the Hill. I always struggle to hit the right second of a minute. Thank you. Mr. Cogliandro from Calabrian, we'll turn to you now.
Thank you. Good afternoon. My name is Charles Cogliandro, and I'm president of Calabrian Corporation. My oral comments today will summarize the main points of my written testimony. Calabrian's story highlights the importance of enforcing the common carrier obligation and providing better avenues of relief for small shippers like Calabrian. Calabrian is a small family-owned chemical company located in Texas producing sulfur chemicals that are used primarily for wastewater treatment. Calabrian is the largest U.S. producer of sulfur dioxide, a hazardous chemical which is transported primarily by rail. In recent years, the U.S. rail carriers have raised rates on sulfur dioxide movements to the point where Calabrian's business has been seriously jeopardized. Moreover, Calabrian has had little or no recourse, nor does it have alternatives with regard to the imposition of rate increases and fuel surcharges. We are, for the most part, captive to the KCS Railroad at our Texas plant. Any attempts at negotiating lower rates have not only failed, but for the most part have been totally one-sided. Clearly, the railroads prefer not to move sulfur dioxide for Calabrian and have so indicated to us on numerous occasions. So they employ a take-it-or-leave-it approach to the rates while maintaining that Calabrian has tacitly accepted, quote, contract rates that are being imposed. Any objection on our part results in a non-shipment of the product. The underlying basis for the huge rate increases offered by the railroads are in direct contrast to the statements that are prepared for their investors, and more importantly, are not borne out by the numbers of the facts. While the railroads report record profits, tout their safety record in the handling of hazmats, and show no material ongoing adverse effects from incidents involving hazardous chemicals in the last 10 years, they insist to us and to the board that the handling of hazmats presents an enormous risk and potential ruinous liability, forcing us to pay exorbitant rates as a result. In fact, their arguments fall way short under close scrutiny. I would like to address some of these points in more detail. Until 2005, Calabrian was expanding its business and shipping over 50,000 tons of sulfur dioxide per year. Starting in 2005, the railroads began imposing severe rate increases on SO2 every 6 months. Increases from 2005 to 2008 ranged from 71% to 156%, resulting in a major negative impact on Calabrian's business. Two examples highlight the inequitable rates currently being paid. First, the current cost of shipments from Texas to a customer in Florida accounts for 72% of the delivered price of sulfur dioxide. Secondly, Calabrian ships both sulfur dioxide and sodium bisulfite to another of its customers, and both commodities are hazardous liquids. Both shipments travel to the same destination in near identical tank cars and weigh roughly the same. The sulfur dioxide rate before fuel surcharges is roughly double the rate for sodium bisulfite. Until February of this year, Calabrian was still paying fuel surcharges, which were assessed as a percentage of the rate, resulting in a surcharge that was roughly double that for sodium bisulfite, even though the same amount of fuel was consumed. As rate terms expired, mileage charges, as required by the STB, were assessed on the new rates, but the old surcharges were baked into the new rates in every case, and in every case, base rates are now dramatically higher, resulting in total cost per car equal to or higher than the previous rate structure. Our complaints about this practice were totally ignored, leaving us essentially no relief. Numerous conversations with the railroads regarding the devastating effect of these increases have been fruitless. Out of frustration, Calabrian contacted the STB's Office of Congressional and Public Services in October of 2006, but we determined that there was no effective avenue of relief for us. Over the last 3 years, Calabrian has been told repeatedly by several major U.S. railroads that they prefer not to haul sulfur dioxide at all. Essentially, with the astronomical rates, they are making that happen. There is no other method of land transportation that is as efficient, safe, and appropriate for the long-haul transport of sulfur dioxide. According to CSX, motor carriers are 10 times more dangerous than railroads for transportation of hazmats. Norfolk Southern's most recent annual report states that no mode of transportation is safer for rail for transporting chemicals, which in the same report they also state are essential to U.S. commerce. Despite these advantages, the railroads are raising the rates so high that rail transport is unfeasible. This practice allows the railroads an undue concentration of market power in violation of the national rail policy. Now let me turn to the rationalization the railroads use to justify these outrageous rates and how the data clearly does not support their position. The railroads have claimed in their reluctance to transport hazmats is due to enormous risk of such transportation, which allegedly creates the possibility of ruinous liability that cannot be covered by insurance. These claims are simply not supported by the facts. The CEO of the AAR has noted that the rail hazmat safety record is extremely favorable. At 99.9 Moreover, 99.997% of rail shipments of hazardous materials reached their destination without incident, and rail accidents involving hazmats have decreased 26% since 1990 and 86% since 1980. Statements directed at investors in Wall Street tout these statistics. While the railroads contend that ruinous liability is risked every time hazardous materials are transported, recent examples of TIH derailments do not bear this out. While the Graniteville derailment and the subsequent release of chlorine were tragic, NS reports that the financial impact was hardly ruinous. In its current annual report, NS states commercial insurance policies are expected to cover substantially all of the expenses related to this derailment above NS's self-insured retention, including NS's response costs and legal fees. And while the NS suffered the direct monetary effect of the accident, the other major railroads have raised their rates on sulfur dioxide to similar levels, using the Graniteville accident as a basis to support their increases, even though they experienced no direct financial impact as a result. Moreover, the probable cause of the tragic Graniteville accident was employee error. The cause was not any inherent characteristic of the chlorine being transported. It appears the fact that a hazardous material was involved may be used to deflect attention away from the root cause of the accident in an effort to relinquish the railroad's common carrier obligation to transport hazmats. To give this a different perspective, consider the case of a drunk driver who crashes his car into a parked car during a busy workday. The car hits with such tremendous impact that the gas tank ruptures and the vehicle explodes, killing the driver, 2 others, and injuring 6 others who happened to be walking in the vicinity of the accident. In legal proceedings following the crash, the defense lawyers point out that the gasoline being carried in the car is extremely dangerous and poses an enormous risk to the public, arguing that the government should impose a $10 per gallon tax on the oil companies because their gasoline was responsible for killing and injuring all those people, even though the oil companies had absolutely no involvement with driving the car. And they argue that the oil companies should assume the future cost of all liability for the movement of any car. In this way, the attention is diverted away from the real cause of the accident, the gross negligence of the driver, and the oil companies, even though the gasoline in the car presents a minimal statistical risk, are forced to pay for the grave potential risk in the future. This example is not used to diminish the tragic consequences of serious accidents. However, it is spurious for the railroads to rely on events like Graniteville as evidence that they should not have a common carrier obligation to transport hazmats. Of the 3 recent events that took place in the last 10 years involving hazmats, all were caused by railroad error, all were largely covered by insurance, and none resulted in ruinous liability. Some railroads claim insurance coverage is not available or is too expensive. Before giving credence to these claims, the board should require the railroads to substantiate that assertion that insurance coverage is unavailable or is so expensive as to justify these massive rate increases. For example, based upon the average rate increases experienced by Calabrian, freight costs have increased approximately $2.2 million per year. Calabrian doubts that any alleged increase in insurance premiums would come close to the overall rate increases imposed upon Calabrian. Furthermore, if you apply this average to an approximately 100,000 shipments per year of only sulfur dioxide, chlorine, and ammonia, total revenue gain for the railroads would amount to approximately $530 million per year, which certainly would dwarf any potential exposure and or premium increase. While any loss of life is tragic, the railroads have wildly exaggerated the level of risk incurred by them in transporting hazmats. In the last 10 years, 3 incidents involving hazmats have resulted in 13 fatalities. While any loss of life is tragic, these figures are dwarfed by other railroad accident deaths. By comparison, railroad street-causing accidents result in roughly 300 to 400 deaths each year in the United States. Moreover, employee-related injuries and claims actually make up a large portion of all railroads' casualty expense. Just as the costs associated with these claims could not justify a railroad abrogating its common carrier obligation, the railroad should not be allowed to apply a different standard to sulfur dioxide and other hazmats. Calabrian appreciates this opportunity to express its views on the common carrier obligations of the nation's railroads, and I will gladly answer any questions.
Thank you, Mr. Cogliandro.
Thank you.
We'll now turn to Mr. Gary Spitzer from the DuPont Company. Welcome.
Thank you. Chairman Nottingham, Vice Chairman Mulvey, and Mr.
Buttry, good afternoon. I am Gary Spitzer.
Make sure the red light is showing.
Got it. There we go. I am Gary Spitzer, Vice President and General Manager for a global segment of the DuPont Company, a global science corporation with revenues of more than $30 billion per year. We operate in more than 70 countries, employ 36,000 people here in the United States, and offer over 70,000 products and services for many markets, including agriculture, energy, national defense, housing, transportation, and electronics. I appreciate the opportunity to express the views of my company here today. I am here to testify in strong support of the statutory common carriage obligation of the railroads and to urge the board to consider revisiting an existing exemption to that obligation. Without common carriage, the railroads would almost certainly refuse to carry regulated materials which are essential to our modern way of life and our nation's economy. America's freight railroads are vital to our business in DuPont. For example, we produce two life-saving fibers, Kevlar and Nomex. Kevlar is used in bulletproof body and vehicle armor to protect our troops at war and law enforcement at home. Nomex is a fire-resistant material used in firefighters' turnout gear and aerospace applications. To produce these and many other DuPont products, we require regulated materials which, due to their composition, characteristics, or volume, must be transported by rail. Some have advocated moving these materials via our nation's waterways and highways. Geographic realities limit barge as an alternative, since there is not always navigable water between origin and destination. Shifting transportation of materials from rail to truck would increase air pollution, increase fuel consumption, exacerbate highway congestion, and decrease our collective security. Moving those products by rail is 16 times safer than moving the same materials by truck. A rail car can carry the equivalent of 4 truckloads, and a typical train takes the freight equivalent of several hundred trucks off our nation's highways. The AAR has argued that companies like DuPont should adopt inherently safer technologies to transport more benign products or eliminate the need for regulated chemicals altogether. DuPont and other companies already pursue and employ inherently safer technologies where possible and viable to do so. However, just as water is required to sustain life, many products require specific chemicals for which there are currently no substitutes. Common carriage is the historical bedrock of this nation's rail transportation system. It remains the statutory law of the United States today, and its statutory duty runs not to shippers alone, but to the public as well. Recent actions by the railroads involving intermodal transport of hazardous materials demonstrate their intent to gut the common carriage principle. Here's an example. In October 2005, DuPont was notified that within 2 weeks, a rail carrier would no longer transport TIH materials in intermodal service. The carrier refused to carry ISO tanks that were already en route to one of our customers, and even declined to transport empty ISO containers then at the customer back to DuPont. Because the customer could not accept rail cars, and due to the higher costs associated with trucking, DuPont ultimately lost this customer to an Indian competitor. Other carriers have also adopted the same exclusion in their tariffs, forcing DuPont to move regulated materials for other customers over the U.S. highway system. In effect, the railroads are contravening the national interest by denying shippers access to the safest means of land transport, and we urge the board to revisit the current intermodal exemption as it applies to regulated materials. Furthermore, railroads are implementing a demarketing strategy to avoid transporting TIH commodities by imposing exorbitant price increases and capital demands on shippers. The railroads are critical to a viable manufacturing sector and are by far
the safest, most energy efficient, and environmentally sound mode of land transport. Allowing the railroads to reduce or eliminate their common carriage obligation would cause companies like DuPont to be unable to move basic raw materials and deprive us of the safest means of land transport. We would be at grave risk of no longer being able to produce products important to the health, safety, and security of the American people. This would also put at risk jobs to support local economies and exports to help balance our nation's trade deficit. In closing, Chairman Nottingham, Vice Chairman Mulvey, and Mr. Buttrey, I want to thank you for allowing me to share my company's views today. DuPont stands prepared to work with the railroads, with government, and with others in industry to enhance the safety and efficiency of the rail transportation system on which our safety of our nation and economic well-being so depend. Thank you.
Thank you, Mr. Spitzer, and all the witnesses. I just have a couple questions. Do any of the witnesses agree that we should be, and maybe you're already working on this individually as companies or collectively, as a country, should we be trying to figure out a way to minimize the distance involved with the movement of TIH materials, for example, and try to sort of look at a comprehensive risk management strategy where we perhaps through a database make sure that there's not a buyer, for example, of TIH that happens to be 2 miles from a supplier, but who for some reason is getting it from 1,000 miles away. And I've heard this actually happens out in the economy. I just, from a risk management perspective, it doesn't look ideal, but obviously I realize it'd be probably pretty complicated to implement such a fix. But if you give thought to this, and I'd welcome any ideas or comments on that regard.
Well, I'd be happy to take that first. I believe certainly that there are incentives that already exist for shippers to reduce distances where possible. Given the extreme increases in freight, difficulties in service, we are a captive shipper, as I've testified before, at 80% of our locations and have seen significant rate increases. So certainly where we can shorten our supply chains, we're going to do it. Recently we just did at one of our plants in the Gulf Coast. We stopped producing a product in Louisville. We have concentrated manufacture of that product in Louisiana and have thereby taken 600 rail cars off the roads. However, I don't quite know how government would get involved in making something like this happen. I believe incentives already exist in our free market economy to do these types of things.
Anybody else care to speak to that? And I think it has sort of homeland security type implications too. I'm not the expert on that area, but I think it's the idea of having some type of database or some type of way of trying to minimize the distances that some of these materials travel.
We've experienced, we are the largest U.S. manufacturer of sulfur dioxide, and our major competitors are actually coming out of Canada. And they're actually transporting SO2 past our facility in the U.S. And we question why that's happening. I mean, we would be in support of looking at those kinds of things, looking at those kinds of actions. In our case, not only is U.S. commerce or U.S. manufacturing discouraged in that case, but we question how they can possibly do that and why they do that, and why are they paying differential rates. A lot of it has to do with freight costs. They pay, their rates coming from Canada are actually lower than what we pay here in the U.S. They have a customer in Mobile, as an example, that they transport product from the West Coast, and our rate to that same customer is greater than what theirs is transporting from the West Coast.
Mr. Spitzer, you mentioned a case where you lost a customer to an Indian competitor from India. How do you know much more about that? How, was that competitor of yours able to truck or barge, or did they contract with another rail carrier, or how did that happen?
Well, actually, it was a customer that was ultimately in Latin America. They brought the product in over the seas and then did land transport for the final step. The alternative that we had in this particular situation was truck from Northeast United States, and we were just unable to be competitive.
Okay, I understand. Thanks. Mr. Spitzer, I'm advised that that DuPont is an example of sort of how we can possibly try to minimize distances on these on the carriage of these TIHs. That DuPont recently decided to expand a facility in Tennessee that produces titanium tetrachloride, which is apparently a pretty poisonous gas, but it can be used in the manufacturing of paint. And that the major purpose of expanding this facility in Tennessee is to serve a paint processing facility in Utah. Do you take into account the transportation costs and the risks of having a long distance delivery supply chain like that, and why do it that way? Why not try to produce this stuff in Utah or someplace closer to where it needs to get to?
Yeah. Well, I would just say I'm not sure where you receive the data in that particular example, but it's actually not correct. It is not used for paint manufacture. It's ultimately going to be used in an application that relates to national defense needs. In this particular case, it was not possible to shorten the supply chain. There was a very specific and special use for the titanium tetrachloride, not related to paint, and it was simply not feasible either to locate their production at our location or to locate our production at their location. To answer your question, we certainly do look at the risks of transport. We believe that having been in this business for 206 years and working with the railroad since the middle 1800s, we have an exemplary safety record. We continue to look at how can we make that even better towards the goal of zero. It is definitely a consideration in what we do. If I can come back to a question Mr. Mulvey asked earlier, I would also say that as we look at the future of the current plant sites that we have in this country, as a business leader in DuPont, responsible for over 20 plants, one of my major considerations is, will I be able to ship these materials in the future? Will there be a common carriage obligation? And if the railroads will carry it, what's it going to cost, and will I still be competitive in these businesses? It is definitely a key consideration.
Thanks. Commissioner Buttry, any questions for this panel?
One of the witnesses mentioned the fact that you had some discussions here at the board about some rate issues. And I was wondering whether I sort of got the impression that you may have gotten the impression from somebody here that you should not bring a rate case. Did somebody say that? Or
we had discussions in 2006 with one of the officers of the STB, and after a very thorough discussion on the problems that we were having, we were told in an off-the-record kind of capacity that we would have an exceedingly difficult time getting anywhere with basically our situation.
Mm-hmm. Had you been shipping under a contract before?
Well, we ship under contract. I'm not sure the word contract is. I'm not sure how that's any different from tariff today, to be honest with you.
I was talking about historically.
Yes, we ship under contract.
Shipped under
contract rate.
Contract rate. But the contract expired and you went to a tariff rate. Is that it?
We didn't. No, actually, in a lot of cases, the railroads refused to quote us a tariff rate. Mm-hmm. They insisted that we agree to contract rates and would not openly offer us a tariff rate.
They refused to quote you a tariff rate.
In a number of cases, they've refused to quote us tariff. We specifically asked because the rules are so specific in terms of, we've considered bringing a case here. The problem that we have is we're a small company. We're the classic David fighting Goliath. We don't have the resources. It's very complicated.
With our small rate case?
Yes, I am very familiar with it.
Okay. And
it's still an exceedingly complicated venue. It's not, and it's obvious watching the DuPont case, there are a lot of avenues that the railroads and the attorneys can go down that would basically exhaust our revenues. Again, as the David and Goliath scenario. Today we have to fight with very sophisticated weaponry against a force who has unlimited resources and dodges so deftly because of its attorneys that we can't ever hit the target. So, it's a very, very complicated thing for us to do, and it'd be exceedingly costly. In our case, we move commodities. We move this particular commodity to to numerous customers. If we were to bring an action here, we would have to bring 4 separate actions. in order to look at any real relief. 4 separate actions, strictly from a legal cost standpoint, would be way in excess of $1 million for us, and the potential relief is $1 million per action. It wouldn't nearly cover the amount of damage that we have incurred in the last 3 years, never mind 5 years. We've suffered a tremendous amount of damage. We've lost a number of customers because of these very, very high rates, and we can't recover. So yes, we've looked at it. We've been watching very closely. We've been observing very closely what DuPont is doing. But in our case, we're not real optimistic. And we were told this back in 2006, that our options were really limited. We were, like I said, we were fighting such a huge force.
Are you all members of the American Chemistry Council?
Can't afford it. But I support everything Mr. Gerard does.
You support everything he does?
Yeah.
Okay.
I mean, we are very supportive.
I presume Dow and DuPont are members.
Yes.
Yes.
DuPont's a member. And for the record, I know the question was asked in earlier testimony if any members lost money in the business. We have. We're losing money. The rates have increased so dramatically, so quickly. We've lost money. And if I could, one other point, substitutes. This is a big discussion about substitution. A couple of years ago, one of our customers actually did substitute. There is a substitute available in our business. Because of all of the impending safety concerns and all of the discussions with the railroads, they're a huge company, huge conglomerate. They were very concerned about handling sulfur dioxide in the future. It was cost related, but it was also the concern, would they be able to get it, because the railroads were threatening not to ship it. So they converted at every one of their plants. We have just we received a phone call recently from them that said that they didn't understand when they did it. The cost of the substitute is now 3 to 4 times what they paid for the sulfur dioxide, and the volume is 7 times, and they're bringing it all in by rail. It complicates the problem even further. So they're spending an additional $8 million a year for treatment, which we've discussed with them could have gone to insurance premium coverage, to use a substitute. They're considering going back. But under these rate circumstances, again, our major concern is the discussion and the response by the railroads that they don't want to haul it at all. They don't care what the price. I mean, the message is very clear to us. If we could, we wouldn't haul it. And that's not by inference. That's direct. We don't want to haul it, and if we had a choice, we wouldn't. And by doing what they're doing, effectively, that's what they're going to do.
It's my understanding that the chemical companies and other shippers of hazardous or inherently dangerous commodities are engaging in customer swaps and things like that to cut down on the distances involved. Is that something that you all have been involved in, or can you speak to that?
I haven't been specifically involved with customer swaps, but we do consider all the tools available, whether it's routing, whether it's product swaps, whether it's inherently safer technology. I mean, it's one of the toolkits, but I don't have any specific examples.
Okay. It's exceedingly difficult, I believe, in our industry because there was a lot of scrutiny in earlier years about antitrust matters and price fixing and territory fixing, and I know every time we've had a discussion about that, again, the lawyers get involved and say we'd prefer not to.
Mm-hmm.
Agree, Gary?
Yeah, I would say there's many challenges, as he just raised, and if they are done, they're an extremely minor amount.
Thank you.
Vice Chairman Mulvey?
This issue of swaps is one that requires some sort of oversight by the Department of Justice, but perhaps under this whole idea of Homeland Security and minimizing exposures to the public, that there may be some opportunities to minimize movements by doing swaps. But I know it's been talked about, and I am familiar with some of the problems with it. Ms. Elliott, are you familiar with the new AAR's proposed tank car rules, and could you comment on those?
I have been exposed to them through other colleagues at Dow, so I am familiar somewhat with them. What kind of comments are you interested in?
Well, you compare those to, say, the FRA's two proposed rules. You think it's been said here that the new AAR rules are unreasonable and that they are far in excess of what is needed in order to bring about an improvement in safety.
I really can't comment on if they're in excess of safety. We're not involved in the development of the rules, and as you are aware, we are in development of a new next generation rail tank car. And in that specific example, that car is 5 to 10 times safer, if you will, than the current technology. So we are involved in what we are developing.
You talked about, Mr. Coliandro, you talked about eliminating, and you mentioned this in your oral testimony, but in written testimony you mentioned eliminating the hazmat identification on railroad tank cars to reduce the risk of terrorism, and putting barcodes in there. But wouldn't that cause a real problem for first responders, whereas currently it's readily available, they can see what the material is and act accordingly rather than trying to get close with a barcode and do a reading on a barcode?
Well, in hazmat response, I mean, we use that as an example, but with modern technology today, from a distance, you can read computer chips, barcodes, probably as close as you can the name on a chemical car, on a tank car. To me, also, keeping that information available on with the engineer himself. I mean, they would have all that information readily available on a chip. There's an amazing amount of information that you can gather that way. And to me, I think that would be a better alternative. I think we advertise the fact that we transport hazmats. We advertise it. We put it on the side of the car. If there's a concern about terrorists sitting a rail car, why give them the opportunity? I think there are a lot better methods of doing it.
I'm a little concerned about this presumption we seem to have that the country is full of terrorists walking the streets with RPGs on their back looking for targets or opportunity. I think there's some exaggeration in that. I mean, there are terrorists out there, we all know that, but I think if they're looking to target a railroad tank car, they're not going to be basing it on just walking down the street and saying, hey, I mean, they will research it out and they'll be ready for it, so I don't think that's going to be, I'm not sure that's an appropriate solution.
Excuse me, no disrespect, but half the time we try to find out where a rail car is. The railroad doesn't know. I'm not sure a terrorist would know.
Point well taken. You also mentioned, by the way, that you had contacted our Office of Congressional and Public Affairs.
Yes. But
we also have an Office of Consumer and Compliance and Enforcement, which I would have thought would be the one you would go to in order to find out what kind of relief that you might have. And that was back in October of 2006. And I'm not asking who you spoke with, et cetera, but to have it indicate to you that you had no relief strikes me as probably there are opportunities for relief that you can pursue. Now, it's also true that our small late case guidelines were not out then. They are out now, and you've already said that you're following with interest DuPont's progress. So are you considering to following a case in the future if it works out for DuPont? Or?
Yes. And let me tell you, at the time that we contacted the STB, I must tell you that your people were extremely nice and extremely professional and highly sympathetic. We explained our case in great detail. They were, but unfortunately, they weren't very optimistic. The fact of the matter is that, and I will tell you also, that after that discussion with the STB, we were told by one of the railroads that they had heard about those discussions, and we believe they acted in somewhat of a retaliatory manner, which, you know, I'm not the type to shy away from a fight, but if it becomes too expensive, I don't have a choice. So basically, we kind of pulled back, and the vice president of our company actually issued me a warning and said that, you know, we need to back off. A small rate case, we've looked at it. We've seriously considered it. We've done estimates. We've done forecasts on what it would cost. Cost benefit to us is dramatic. And again, we've seen, again, no disrespect, with the history. And I know things have changed. So history is a relative thing. And I think, Mr. Chairman, you said that earlier. You know, new history is probably better than old history. But, you know, the attorneys for the railroads are very proficient. They're very creative. They're very brilliant. And that's the best thing I can say about attorneys in general. But they are very good at keeping the case open for as long as possible. And we just don't have those kinds of resources. Now, if my friends at DuPont would happen to be successful, I suspect that possibly us and possibly a number of others, might entertain that in a greater way, having some sort of precedent. At least we know that we might have some sort of chance, some sort of possibility. But, and we have never tried to take the position until recently that we don't want to be cooperative. We're a small company. We've pleaded with the railroads. We haven't fought them. We haven't cursed them. We haven't done anything. We've pleaded with them to please understand you are putting us out of the business. And we do not believe it is their purview to make that decision. That's the Congress's purview. If they don't like the fact that hazardous chemicals are being manufactured, that's the Congress's decision. They've considered that many times in the past. If they want to discontinue the manufacture of hazardous chemicals in this country, that's their responsibility. By not allowing us an outlet to ship the product, they're effectively telling us, we're not going to allow you to produce it. And I don't think that's their right. I do not believe that.
Thank you. Mr. Spitzer, you talk about the railroads refusing to carry hazardous materials in ISO containers, in intermodal containers, under the idea that the intermodal traffic is exempt. But the material is not exempt. The material is a regulated commodity, correct? So it's sort of a tension here between the commodity being regulated and the container not being regulated. Have you thought about filing a case saying that this is an unfair practice or an unreasonable use of the exemption and ask for a revocation of the exemption?
Well, I appreciate the comment, Vice Chairman Mulvey, and that's why today, in my testimony I said we would urge the board to reconsider this exemption and some of the very points that you're making. ISO containers are a preferred container by many of our customers, particularly in international commerce, and it is certainly something that we would hope there would be an opportunity with the board to follow up on.
Thank you.
Just briefly on that point, Mr. Spitzer, is there a difference in the level of safety between the two containers? When I think of and I'm not expert on this, but when I think of intermodal containers, I don't have the same image that I do of your typical tank cars that are designed specially for hazmat and chemical carriage.
No, these are, obviously DOT regulated, well-designed mini rail cars, if you will, that ultimately can go by land and then be put on top of a rail car. And one of the reasons they're so preferred by customers is they could serve as on-site storage at that customer facility and also eliminate the need for disposable packaging, as with drums or other types of materials. So they are a very robust container. They're part of the fastest growing types of containers that we see, and I believe removing this exemption would be very important both for us as well as other chemical shippers.
Thank you. I certainly intend to look into that further. Mr. Cogliandro, I believe you had mentioned, and maybe it was Mr. Spitzer as well, about apparently railroads occasionally not quoting a tariff rate. Please let us know, let our staff know, let us know if that happens. My understanding, the law is that railroads must quote a tariff rate. Shippers may not like what that rate is, and there are various things you can do after, when you see that, but just saying no, we won't give you one is not an option. It's not the first time I've heard this, but I do urge you to let us know, because unless I'm missing some nuance, I just don't think that's acceptable. I appreciate you sharing it. Mr. Cogliandro, I'm sorry that our rate dispute resolution process and our rate regulation authority does not extend to the dues of the American Chemistry Council, but I see Mr. Gerard is still here. You've been a very able spokesman for the industry. I certainly hope you consider giving you a break, but that's not my business. But it sounds like they're pretty tough on rates themselves if they're not allowing you to be part of the association when you're clearly a very articulate leader.
Not allowed. I think, it's like Vegas. I would hope he would comp me, so maybe I have a chance now that Jack can probably comp me into the organization. So.
Yeah, that's only fair, but, again, going beyond my jurisdiction there, but just a public interest suggestion. And lastly, I will assure Mr. Spitzer that we won't let anyone apply the David and Goliath analogy to your pending cases here. I've heard others use the same analogy, implying that perhaps your company is Goliath. So I guess it just depends on who's involved in a particular case and who's doing the labeling. But we welcome all the Davids and the Goliaths and everyone in between to come here, and we've done a lot to make it, I believe, easier to come here and get, and we are, I'm sure we are on track to have decisions in early July, meeting our 8-month target in our regs on those cases. So I won't say anything more about those cases except to say that we are very serious about keeping those small rate cases moving along quickly. Filing fees only $150, and while a single complaint may not pay for all of a shipper's past harms or concerns over history, I think it certainly can, if they've got a case, they ought to bring it because it can make a pretty powerful statement. But anyway, thank you. Any other questions for this panel? Thank you very much.
Thank you, Mr. Chairman.
I will call the next panel forward, panel 4D, chemical shippers.
Others in your company. Help yourself. Still awake.
Welcome. Good afternoon. Appreciate your patience, and we'll proceed with panel 4D. Our first witness we'll hear from is Mr. Howard I. Kaplan, Vice President for Chemicals and Byproducts with the U.S. Magnesium Company. Mr. Kaplan, welcome.
Thank you, Chairman Nottingham, and good afternoon, gentlemen. I'm Howard Kaplan. I'm with U.S. Magnesium located in Salt Lake City. We would like today to address the issues surrounding the legal obligations of the railroads to provide rail service with respect to the transportation of chlorine. Without the rail transportation of chlorine, U.S. Magnesium would quite possibly go out of business, and the vital chlorine that it supplies to companies like Thatcher and Chimera Water Solutions, Western United States bleach producers, and municipalities for water treatment would not be available. We have attached letters from Thatcher and Chimera Water Solutions to our testimony for the board's convenience. As can be seen from these water treatment companies, chlorine is essential to the effective treatment of drinking water and wastewater in municipal treatment systems. U.S. Magnesium has about 500 employees in Salt Lake City, Utah, and it's the only surviving magnesium metal producer in North America. It's the only chlorine producer from magnesium that sells chlorine commercially in the United States, as 99% of all chlorine produced in the United States for sale is produced by chlor-alkali companies. Our plant is located in Raleigh, Utah, on the southwest shores of the Great Salt Lake. The lake is inexhaustibly rich in materials like the magnesium chloride that is used in our production.
It is also the source of other raw materials for plants for productions of potash and salt. U.S. Magnesium is one of the world's largest commercial users of solar energy to remove water via an extensive system of evaporative ponds to concentrate raw brine so that the lake's magnesium chloride can be efficiently electrolyzed to produce magnesium and chlorine. Magnesium is critical to aluminum alloying for beverage cans and all aluminum sheets such as truck bodies, aircraft skins, and many aluminum castings as well. Magnesium usage in the automobile industry is growing and helps reduce weight and therefore fuel consumption. Magnesium is irreplaceable in producing titanium, zirconium, beryllium, and uranium for aircraft, nuclear, and chemical uses, and it's also important in military applications such as fuels, explosives, and flares. It is thus critical for a growing economy, provides many environmental benefits, and is important in national defense as well. The benefits of chlorine to the economy and to the national health and well-being are well known and have been well documented in these proceedings by the testimony of the Chlorine Institute and others. However, it must also be noted that without the production, sale, and transport by rail of chlorine from our Raleigh plant, it is highly doubtful that U.S. Magnesium could stay in business producing only magnesium. U.S. Magnesium and its predecessors developed an entirely new technology that allows chlorine to be extracted from magnesium chloride and captured for sale as a co-product of magnesium. Previously, chlorine had been vented to the atmosphere pursuant to Clean Air Act permits. That venting was wasteful, uneconomic, and not very beneficial to the environment. In 1989, the U.S. Magnesium predecessor company emitted approximately 55,000 tons of chlorine to the atmosphere. By 2006, that number has been reduced to virtually zero. The inability to ship chlorine from our Raleigh plant would possibly result in a closure of the magnesium plant and the accompanying elimination of the only North American supply of that vital metal. Since the end-user markets for products such as bleach and water treatment chemicals are so distant from our plant, and because bleach can only be shipped relatively short distances in the high temperatures of the West, economics preclude the production of these products at our plant in favor of safe shipment of chlorine to remote locations. If we were not able to ship chlorine and we were able to stay in business, we would be forced to dispose of the chlorine co-product as we have in the past. In either case, these are highly unattractive consequences. We have no doubt that the railroads would like to avoid the potential liabilities that follow from their negligent handling of chlorine and other TIH materials. But we also have no doubt that they are in a position to prevent these incidents that they so justifiably fear. In reality, however, we also recognize that the railroads don't really want to stop handling these materials, that they move at rates that must be called astronomical and perhaps even predatory. They simply want the shippers, who have no real power to prevent the railroad's negligence, to indemnify them for that negligence. If this board were to hold that the railroads had no obligation to carry chlorine under the common carrier statutes, the railroads would immediately demand that shippers supply indemnification or other liability protection for the carriers. This is what these claims are all about. Let me give you a specific example of this. Our plant is served solely by the Union Pacific. The Union Pacific and the other major carriers have, through their trade association, the Association of American Railroads, been demanding that shippers who own or lease rail tank cars convert to a new tank car of unproven design and unproven performance characteristics over the objections of the shippers and the Federal Railroad Administration. This new car, when fully loaded, will weigh 286,000 pounds as compared to the current cars at 263,000 pounds. We have an additional metallurgical facility building a plant next to our magnesium plant to take advantage of numerous synergies in the production processes, who also want to use this new car to handle their feedstock. When we were both in the process of leasing and purchasing many of the new 286,000-pound cars, we both approached the Union Pacific and noted that the line leading from the main line to our plant was not able to handle the additional weight and should be upgraded. The Union Pacific declined to do so and said if it was to be upgraded, we should do it. When we said that we could not afford this expense, as our company has recently emerged from bankruptcy, the Union Pacific said, fine, just light load the cars, leave out 18,000 pounds of product per car. This would result in requiring us to purchase additional expensive chlorine cars for our fleet. We would have to ship 10% more cars, pay 10% more freight, by the way, and would increase the potential for accidents
by that amount as well. We concluded that notwithstanding their constant drumbeat about how they're concerned about safety, the UP was prepared to spend the shippers' money to improve safety, but not their own. In conclusion, the railroads have been given a wholly unique position in the U.S. economy. They can charge extraordinarily high rates with impunity. They can operate without any meaningful competition in many industry sectors. And the government, through this board, seems to be constantly seeking to ensure their inordinate profitability. All of this is based on the need for the railroads to exist, and that need is based on their willingness and ability to provide service on reasonable demand, and presumably at reasonable rates. To the extent that they are not so required, one is forced to wonder why they are so pampered and protected. Without the common carrier obligation, perhaps the laws should be amended to allow free and open competition to exist in the rail industry, as it does in our industry and the other industries represented here today. I thank you for your time, and be glad to answer questions at the conclusion of our panel.
Thank you, Mr. Captain. We'll now hear from Mr. Bernard Claude from Total Petrochemicals USA. Welcome.
Mr. Chairman and members of the board, my name is Bernard Claude, and I'm the President and Chief Executive Officer of Total Petrochemicals USA, Inc. Thank you for the opportunity to testify. First of all, I would like to introduce you to Total Petrochemicals USA, Inc., which I will call TPI. We are a U.S.-based producer of petrochemical, including polypropylene, polyethylene, styrene, and polystyrene, base chemical, and transportation fuels, with production facilities in Texas and Louisiana. We are part of the Total SA Group, which is the world's fourth largest publicly traded integrated oil and gas company, with operations in more than 130 countries, spanning all aspects of petroleum industry, including oil and gas exploration, development, and production. Downstream operations include refining, marketing, and trading, and shipping of crude oil and petroleum products. In addition, Total SA is a market leader in the liquefied natural gas industry and is helping to secure the future of energy through its commitments to developing renewable energies such as wind, solar, and photovoltaic power and alternative fuels. Total Petrochemical in USA has built its North American petrochemical business with a strong manufacturing bias based on world-scale plants and technology-advanced operations. We manufacture petrochemicals for the plastic industry. We produce plastics for use in everyday household items like food containers, furniture, carpet, car industry, and bottles, to name just a few. Many of our products enter the commercial and industrial sector as well, performing in critical applications, from natural gas distribution and water pipeline to building insulation, from medical packing and device to erosion control. In the next few minutes, I would like to share with you TPI's concerns as the common carrier obligation of the nation's railroads. Over the years, TPI has built some of the world's most competitive manufacturing sites in the Gulf Coast regions of the United States, including the largest polypropylene and styrenics facilities in the world. We want and need to be competitive and to remain competitive in the USA. We have spent about $2 billion in the last 10 years on capital projects in the USA and continue to show support for US-based manufacturing with an additional $3.5 billion approved by our board for the next 5 years. And I repeat, this is not exploration production projects, those are all manufacturing side investments. Beyond the scale economies, the success of our manufacturing sites depends on an efficient, safe, and cost-effective transportation and distribution network. Due to congestion and rail infrastructure limitation, transporting our product via rail all too often involves poor service, unpredictable delivery schedules, and costs that continue to rise at an alarming rate. In fact, transportation costs have risen so much in the last several years that TPI's logistical costs are now higher than our manufacturing costs, jeopardizing our global competitiveness. Benchmarking has shown that our sites are across the world third class in manufacturing, but this is more than offset by the logistical cost. TPI produces over 9 billion pounds of product each year, much of which is delivered to our customers via rail transportation. Of the volume moving by rail, 4.5 billion pounds is comprised of plastic pellets, a non-hazardous commodity. TPI also makes overland shipments of materials such as styrene monomer, aromatic solvents, and various oils. These materials are classified as hazardous materials by the United States Department of Transportation. Although those shipments are not toxic inhalation hazard shipments, TPI has concerns that should the railroad common carrier obligation for these types of products be discontinued, it will negatively impact transportation safety as well as the ability of the U.S. industry to compete in the global market. But the main part of my talk addresses our 4.5 billion pounds of plastics pellets, which is a non-hazardous material. The common carrier obligation plays an important role in the ability of U.S. industry to compete globally. The widening of trade deficit in the U.S. relative to the chemical industry business is continuing. Meanwhile, more and more new and existing railroad infrastructure is being consumed to support imports as railroads allocate increasing percentage of their infrastructure to support intermodal traffic. As a result, U.S. chemical manufacturers are increasingly unable to export due in part to gridlock in existing rail infrastructure. We have experienced such gridlock firsthand with respect to export out of the Houston, Texas area. In this area, serious rail congestion has resulted in intermittent rail service stoppages and seriously impacted our ability to move our products to facility for necessary pre-export packaging. If railroads are given the opportunity to forego shipments currently protected by the common carrier obligation, we fear that the situation will be exacerbated. The market of petrochemical is a worldwide business. The same plastics are manufactured and consumed across the world. There are times like now when the economy in the USA is slow, and export is the way to stay in the business and to keep our plants running. There were several months last year when the market favored exportation, but serious rail congestion has seriously impacted our ability to move our products. It is also important to note that the chemical industry is struggling to compete with products manufactured in foreign countries, in part because foreign producers enjoy the freedom of choosing their ports of entry in the United States based on areas with competitive rail services. There are times when it is cheaper to import plastics from Middle East to the northeast side of the USA than to send it from the Houston area to the northeast of the USA. This allows foreign manufacturers to strategically avoid areas where railroads engage in non-competitive pricing practices and to capitalize upon this advantage to the detriment of USA rail shippers suffering from non-competitive pricing. We believe that removal of the common carrier obligation would enable such non-competitive pricing practices to flourish to even greater extent than they do today and put the U.S. industry at a greater disadvantage. As I conclude my testimony, I would like to recognize the railroad for lowering incident rates on the rail lines in recent years. The safety improvements of the railroad, coupled with the initiative of the Department of Homeland Security concerning rail movement of various chemicals, will continue to magnify the safety advantage of shipping products by rail. We believe that continued implementation of the common carrier obligation will preserve the progress that has been achieved rather than undermine it by pushing freight off the rail lines and onto the nation's highway system. I would like also to take this opportunity before the board to commend the Federal Railroad Administration and Pipeline and Hazardous Materials Safety Administration initiative, as well as the efforts of the shippers, railroad, and key railcar manufacturers in their continued mission to increase the inherent safety of railcars. I further commend the FRA for implementing realistic yet deliberate timelines for shippers and carriers to upgrade the nation's railcar fleets for hazardous and toxic products. Their initiatives are costly for the shipping community, but consistent with our drive to continuously increase the safe transportation of our products, not only in the United States, but also to North America. Thank you, Mr. Chairman, and the members of the board, and I'll be ready to answer to your questions.
Thank you, Mr. Claude. We'll now turn to Ms. Robin A. Burns from the Occidental Chemical Corporation. Welcome.
My name is Robin Burns, and I'm the Vice President Supply Chain for Occidental Chemical Corporation, more commonly known as OxyChem.
Make sure the red light's on and make sure you're speaking right into the mic. Thank you.
Okay, I am here today to express OxyChem's position of support for maintaining the common carrier obligation. Of particular importance to OxyChem is an adequate rail transportation network throughout the United States. Railroads must continue to be required as common carriers to carry hazardous materials such as chlorine that are necessary for many of the industrial applications essential to our economy. The common carrier doctrine is a bedrock of remaining rail regulation and provides the sole basis for public comfort with rail industry consolidation. OxyChem is a leading North American manufacturer of basic chemicals and vinyl resins, including chlorine, caustic soda, and polyvinyl chloride, the building blocks for a range of products including pharmaceuticals, water purification, detergents, electronics, building materials, and many more. OxyChem employs 3,100 people at 23 domestic locations spread throughout the central to eastern United States. Our products, which are used in water purification, medical supplies, pharmaceuticals, construction materials, and agricultural chemicals, are vital to the economy of the United States. Our products are crucial to the health and welfare of its citizens. Safe and reliable transportation of our products is critical to our success as a company and essential to meet the needs of our customers and the public. Our various business units make over 70,000 rail shipments per year. Of those, approximately 48,000 are hazardous materials, which include chlorine, vinyl chloride monomer, caustic soda, and muriatic acid, among several others. Of the 48,000 hazardous material shipments, approximately 20% are chlorine, which is considered a poisonous inhalation hazard, or PIH. In total, we manufacture approximately 3.6 million tons per year of chlorine, of which 2.7 million tons are delivered by pipeline, with approximately 900,000 tons moved by the railroads. We operate a private car fleet of approximately 10,000 owned or leased cars, with 1,400 dedicated for chlorine. Due to the locations and needs of our many customers and users across the United States, rail transportation is essential for this critical building block. Pipeline transportation is not feasible for small or geographically distant customers. Generally, trucks are not cost-effective and are inherently riskier considering the number and distance required to handle the volume. 45,000 truck shipments would be required in place of the 10,000 rail shipments. OxyChem has a long-standing commitment to the safe transportation of our products. We have continuously moved to improve our railcar safety and security, including on-site rail yard infrastructure and security improvements, additional pre-shipment inspections, testing of railcar monitoring technology, and improved sealing of railcar connections. This commitment was most recently demonstrated by OxyChem becoming an active participant in the Next Generation Rail Tank Car project. The team is chartered with the objective of developing a railcar which will be 5 to 10 times stronger than current car designs in terms of withstanding a railroad accident. Our participation in this project includes a public commitment to replace our entire chlorine rail fleet with the next generation railcar design by 2017. It is essential that we partner with the railroads and work together to ensure the safe transportation of hazardous materials, as we have done for years as a leader in the Responsible Care Initiative, and we will continue to do so. OxyChem was recently given an award for contributions made to the training efforts of TransCare, an initiative co-sponsored by shippers, railroads, and other transportation companies that focuses on training of local emergency responders. Railroads have considerable discretion regarding shipments of goods and use that discretion to maximize revenue and mileage, sometimes at the expense of safety. OxyChem has obligations to mitigate customer freight expense and strives to reduce the number of miles that chlorine moves over the rails. Unfortunately, this objective is not always supported by the railroads. Recently, we had an opportunity to move a chlorine car 112 miles instead of 421 miles. The rate for the shorter move was significantly higher than the longer move. Our request to get the railroad to lower their rate, allowing us to move the material a shorter distance, was denied. When we challenged them on their decision, they stated they did not want the PIH to move on their railroad. As the STB is well aware, railroads are regulated by the STB when acting as common carriers, not when acting as contract or private carriers. Moreover, STB rate regulation is available only when the railroad is acting as a common carrier, there is no effective transportation competition, and the railroad is charging very high rates. STB regulation is vital because the shipper has no option but to transport commodities at the rates set by the railroad or the STB. Railroads insist on tying excessive rates on some routes to their willingness to offer contract rates on more competitive routes. In recent months, railroads have not always been willing to quote a common carrier rate at OxyChem's request, or in some instances have made their willingness to do so contingent on OxyChem agreeing to all of the rates that the shipper and the railroad are then negotiating. The STB should require railroads to quote common carrier tariff rates separately from contract rate quotations for each such movement if the shipper so requests. It is vital that the STB remain an effective regulatory backstop to encourage commercial resolutions of rate and service disputes. The only way that the STB can remain an effective backstop is to preserve the railroad's common carrier obligation without diluting the effectiveness of that obligation. The STB requires that railroads must, consistent with their common carrier obligation, quote a common carrier rate to any shipper which has made a reasonable request for such transportation. In the 1970s, the ICC held that railroads are and must remain common carriers of spent nuclear fuel and high-level radioactive waste, despite any risks associated with carrying those commodities. And they found that rail was several times safer than trucks to move radioactive materials. The ICC's finding extended to other commodities, and those circumstances are unchanged today. Therefore, the STB must continue to require railroads to carry these vital materials for OxyChem and the rest of American industry. Frankly, the railroad's stated position presents a fundamental challenge to this STB. Without maintaining the common carrier obligation, the Interstate Commerce Act would have no meaning for shippers because they would have no ability to compel railroads to carry what American industry absolutely needs them to carry. If the railroad industry believes that changes to the statutory common carrier obligation are appropriate, it must seek those changes from Congress, not the STB. Also, if there is to be any limitation, monetary or otherwise, on liability as the railroads have proposed, or a refusal to carry certain commodities, neither the STB nor the railroads are empowered to take such actions. Rather, Congress is empowered to do so because the existing statutes require railroads to carry all hazardous commodities tendered in conformance with all applicable governmental regulations. OxyChem has always been willing to discuss legislative issues with the railroad industry, but this proceeding is not the appropriate venue for doing so. You will hear the railroads say, railroads do not produce TIH, do not use TIH, and do not own the tank cars used to transport TIH. However, I guarantee that every single railroad employee, along with every single person in this room, use products made from chlorine every single day. OxyChem is grateful for the opportunity to speak today on the need to maintain the current common carrier obligation. Chlorine and its derivative products are vital to the way we live. It is imperative that we preserve our right to transport OxyChem products, including chlorine, safely, securely, and economically via rail, and to do so, the STB must continue to enforce the railroad's current common carrier obligation. Thank you for your consideration.
Thank you, Ms. Burns. And we'll now turn to John McIntosh of the Olin Chlor-Alkali Products Company.
Chairman Nottingham, members of the board, I'm pleased to be here today on behalf of my company to testify about this important issue that's before the board. Today I am testifying as president of Olin's Chlor-Alkali business, which is one of the leading producers of chlorine and caustic in North America and is an approximate $1.2 billion business. We have been involved in the U.S. chlor-alkali industry
for over 100 years, and we were the first commercial supplier of chlorine in the United States. We continue to grow and service the industry that we participate in. Our business includes manufacturing sites in New York, Georgia, Tennessee, Alabama, Nevada, Louisiana, California, Washington State, and 2 provinces in Canada. Each of these plants offers a favorable manufacturing cost structure, availability of highly skilled workers, access to our customer base, and historically competitive freight rates. But in every case, they have one common factor, and that is they are captive to only one railroad. As one of the nation's leading producers of chlorine and chlorine derivatives, our company produces an essential chemical, the criticality of which has been discussed in previous testimony and doesn't need to be repeated by me. These hearings, though, are ultimately about 2 facts. The first is how our products would be delivered to our customers without the common carrier obligation, because it has been explained to me in no uncertain terms by the railroads that without that obligation, they would not deliver our products. The fact is that more than 80% of the chlorine that we produce is transported by rail to customers who have no other option than to receive it by rail. Let me say that again. More than 80% of the chlorine we produce is transported to our customers who have no other option than to receive it by rail. The implication of those 2 facts is obvious to me. My testimony today will focus on the importance of the common carrier obligation as it exists today and its importance to Olin and our customers, as I previously mentioned. The obligation is cited by the railroads as an undue burden when it comes to the duty to transport chlorine and other TIH chemicals. However, in recent years, the railroads have systematically imposed massive and unprecedented increases in chlorine freight rates, allegedly to recover the risk premium. In our business alone, we have experienced average annual increases of 20% or more in the last 3 years, and find that by the end of the current year, our freight rates will have tripled from the average that our business incurred in the years 2002 through 2004. In one high-volume move recently, rates were increased by 177% in 1 year. The railroads' price increases threaten the ability of chemical shippers like Olin to keep their plants profitable and economically viable. Continued price increases will ultimately make the transport of chlorine and other chemicals by rail economically untenable and essentially have the same effect as the railroads refusing to ship chlorine if the common carrier obligation is eliminated. We are dependent on the U.S. rail industry for the safe, secure, and efficient transportation of our products. We emphasize that rail continues to be, historically and currently, by far the safest mode of transportation for chemicals in North America. For a substantial amount of the shipments from our facilities, there is no alternative to shipping by rail, and for safety and security reasons, we wouldn't want to switch to a different mode. Moreover, for most of our facilities, we, the shipper, have access to only one rail carrier. For a captive shipper such as we are, regardless of the size or location, the efficient movement of our traffic, in some cases even the very survival of our business, depends upon the rates and service provided by that one single railroad. Over the last 100 years, shippers like Olin have invested money in plants and equipment based on the continuing assumption that we would have the ability to ship our products economically from our manufacturing sites. As time goes on, the number of railroads is decreasing, the number of captive situations for shippers is increasing. We continue to rely on the common carrier obligation of the railroads to maintain our ability to ship product to our customers at a reasonable rate and with reasonable service. If that obligation is weakened or eliminated, and the railroads decline to carry product from our manufacturing facilities to our customers, the implications for both our business and our customers are obvious. When considering railroad service, it is important to recognize the common carrier obligation, which has been testified earlier is a statutory duty of the railroads to provide. The Interstate Commerce Clause of the Constitution grants power to Congress to write the laws that govern our nation's commerce. Using this authority, Congress recognized the obligation as the framework on which the entire national railroad system was founded, and it remains crucial today. Railroads are chartered to operate in the public interest, as commerce depends on safe and reliable service in the delivery of a wide range of products. The obligation underlies the role of railroads as a service industry that supports so many critical sectors of the U.S. economy. The federal courts have pointed out that even if it is inconvenient or unprofitable for a railroad to carry a particular product, the common carrier obligation obligates a railroad to provide that service. Also, Congress never intended for the common carrier obligation to be dependent on whether the railroads can operate without negligence or derailments. This has been illustrated in the NTSB findings on several recent accidents, but the railroads insist on passing along significant risk premiums in questionable pricing actions or attempt to renege entirely on their legal obligations based solely on the negligence of their part in these recent incidents. In summary, the common carrier obligation was established by Congress to protect all rail shipments, including chemicals such as chlorine. As our testimony demonstrates, the STB must enforce the common carrier obligation imposed by Congress for all of the aforementioned reasons. The ability of American manufacturers and producers to compete in today's global market is highly dependent on the railroad's compliance with the common carrier obligation. I would like to comment on some testimony earlier today from other parties, railroads, and others interested in the proceedings. It is Olin's belief, based on our experience in this regard, that there is not a strict liability standard for as has been testified by others. It is our experience that liability is based on negligence, on degree of negligence, and not strictly held. If there is no negligence, there is no liability, and that is different than testimony I heard earlier today. Olin also has not been shown evidence by the railroads that they are not properly insured or that they cannot obtain insurance. In fact, in discussions with the railroads, we have actually suggested that we would be willing to consider reimbursing them or paying a part of the incremental cost of the transportation of our chemicals if they would show us the data and demonstrate to us what that incremental cost was and how it affected their system. We have yet to find any of the parties we have had discussions with that have agreed to even show us the information or provide us a meaningful proposal on how to do that. So we are unsure in our mind as to just how much validity there is to that claim that has been made earlier. Speaking to the creation of cost competitive situations by reducing ton miles, I would comment that there was an attempt to do that on an industry-wide basis through a DOT Section 333 effort of some year or two ago. That never came to fruition because of concerns over by the Department of Justice on antitrust and industry-related matters. Speaking just as an individual company, when we have tried to do things to reduce ton miles, what we have found is that if the delivering carrier is captive to that delivering location, our attempts to reduce ton miles have actually resulted, as Robin relayed in her testimony, to increase costs for a route as opposed to decrease costs. I thank you for the opportunity to testify today and are willing to answer any questions provided.
Thank you, Mr. McIntosh, and all the witnesses on the panel. I'm impressed, Mr. McIntosh, with your offer that you recounted to the railroads that you would be willing to entertain a discussion about cost sharing, if I heard you correctly, on insurance costs, if you had the right data to back that up. I would certainly commend to the railroad's attention that they look at your proposal openly and give it some close considerations. I think it's the kind of spirit that I'm looking for of collaboration and actually looking for how we can get to a better place than the status quo, which is not ideal currently. And so I really appreciate your offering that. I don't know enough of the details to endorse it, but I just think it's the right spirit, and I hope the railroads take a serious look at that. And I'll be probably asking them about that tomorrow when we have some more railroads back with us. You mentioned, Mr. McIntosh, that a number of your customers have no alternative other than rail, if I heard you correctly.
Yes, sir.
On the vast majority, 80%.
80%, yes, sir.
And I don't, believe me, you won't find anybody at the STB who doesn't agree that rail transportation of chemicals is the safest way to go. But just struck how, just theoretically, even a truck movement is not even possible. What kind of facilities are these?
For the most part, truck movements of chlorine, in our mind, are not an effective alternative to rail transportation because they're not safer. As a matter of fact, they are much higher risk.
Absolutely.
Truck movements of chlorine are really very limited to the southeast or the California, Los Angeles area, where it is used predominantly for chlorine supplies to municipal water treatment facilities. Outside of that, in our system, there are no other truck shipments used for chlorine just because of the difference in risk associated with that mode of treatment. And when you factor in the volume multiplier necessary to deliver by truck versus delivering by rail, and the number of shipments that you have to make to get an equal volume of product delivered to a customer, it further skews what's already a losing proposition from a risk and a safety and a security standpoint. So our customers, even if we offered them transportation of chlorine by truck to their facilities, I'm confident would want no part of it, even if it was an economic break-even consideration for them.
So I'm hearing it's obviously riskier, certainly, obviously, probably impractical in many circumstances, but it's technically feasible. I mean, if you had a strike or something, or the rail industry was shut down as the aviation industry was after 9/11 for some weird reason, I mean, there are roads that go to these places, right? People drive to work to these facilities.
Yes, sir. It is feasible, and it is done on a very limited and very specific basis in certain parts of the country.
Okay. These are important. When we hear words like no option, no alternative, I mean, I want to make sure we get, dig into it, but appreciate that explanation.
Mr. Chairman, on the same question, in the plastic industry, our customers, even the largest customers, don't have enough storage, and therefore they want us to deliver in rail cars so they can use those rail cars as storage facilities. So with those customers, and the majority of our customers, they will only accept rail car distribution.
I understand. Several witnesses today, including a couple just on this panel, have indicated that the board shouldn't play a role in, I don't want to put words in with them, but in adjusting or in changing the dynamics of the common carrier obligation. But I do want to make sure everyone understands that on more than 100 occasions, the board has actually exempted commodities from regulation, which has the effect, the way the law is played out and precedents, of basically removing the common carrier obligation for all intents and purposes. So, I mean, Congress hasn't on a single occasion that I'm aware of, certainly not in most instances, reversed that or overridden that. Congress, of course, they can have the last word. But I think my view is, looking at the case law, looking at the statutory and legislative history, the common carrier obligation is it's very generally worded, as many statutes are, critically important, a touchstone concept for our transportation system for the agency. But there's an implicit, with the Congress also creating the ICC and then the STB, implication that it's the board's job to give meaning and life to it through enforcing it and through occasionally looking at exemptions, for example. I'm not suggesting that it'd be a brilliant idea to exempt TIH or something, but it's just want to make sure whenever I hear someone saying, board, you can't even sort of look at this or consider this. I mean, I think we wouldn't be doing our job if we didn't have hearings like this and consider all the different options on the table. Mr. Kaplan, I noticed and I heard towards the end of your testimony, you slipped in a zinger on me. I want to make sure I have a chance to respond to you. Your testimony said that the government, through the board, seems to be constantly seeking to ensure meaning the railroads, inordinate profitability. It's something I heard when I was a nominee before coming here. It's it's stated so often that it's easy to sort of just accept it as fact, but I can't, because I can tell you we're in court fighting the railroads on a number of fronts. They opposed us when we issued our first ever unreasonable practice finding on the topic of fuel surcharges. They opposed us when we completely turned around and reformed our small rate case rule, and we're in court with them now on that. They opposed us when we took up the issue of the cost of capital rulemaking and significantly changed the way we measure that important measure, and with the outcome, as we now know, of lowering their cost of capital determination. And they certainly, the railroad that we forced to sell its line in Lubbock, Texas, I can tell you, I mentioned this in my opening remarks, we forced a railroad to sell its line to a competitor who was willing to actually step in and meet their common carrier obligations. I can tell you there are a lot of railroads and on a lot of issues who don't feel that we are constantly focused on helping them obtain inordinate profits. Not to mention, if you actually compare the last 20 or pick your time horizon, the profits of the rail industry to that of all their customers or almost all their customers, you would see that rail industry profitability is generally lagged behind that of the chemical industry, coal industry, grain, which is nothing wrong with that per se. It's just a matter of fact, and I just want to make sure you may have used this line from a few years ago and not gotten challenged on it. I just need to call you out on that a little bit.
I understand that.
Thank you. Vice Chairman Mully?
A couple of questions, and I'll try and be brief. U.S. Magnesium, Mr. Kaplan, you talked about that you used to vent the chlorine into the atmosphere at 55,000 tons a year. What are the environmental consequences of doing that? If you had to do that again, is it a known carcinogen, or what are the problems with doing that?
Chlorine is an irritant, obviously, and in high concentrations can be problematic with respect to breathing. When it was emitted with the other materials we emitted, we emit over 100,000 SCFM of steam, for example, so it was combined in that. It dispersed fairly readily, and this was all done under clean air permits, and there was no detrimental impact of it to any people based on the location of the plant, et cetera.
You mentioned about the line that had to be upgraded to 286,000 to handle 286,000-pound cars, and the UP was unwilling to do it. How long was that line? You know?
It's 11 miles and change.
11 miles, okay. And did you talk to them about sharing the cost of doing that, or was it?
We felt the cost should have been paid for by the railroad and then put into the ongoing rates.
Okay. It's been mentioned that trucks are less safe in carrying the chlorine and other hazmats than rail cars. What's likely to have accidents, and that rail cars can carry 4 times as much product as a truck. But on the other hand, if a rail car derails and if there's a spill, there's much greater volume of material that can be emitted. And is it also true that rail accidents are demonstrably more dangerous and more harmful and more costly than truck accidents because they are carrying more material, more product? In other words, there may be more trucks out there, they may be more likely to have accidents, but because the volumes that they're carrying are much less, in a way there's less of a threat to the human health and safety when there's a truck accident as opposed to a rail accident.
I'm not sure that I'm really in a position to comment on that. Trucks, when they have an accident, are going to be right next to a car, whereas trains are often separated by some distance. But there is obviously 4 times more product than a rail car. Yes, that's correct.
Anybody else want to comment on that? We're hearing that it's very, very expensive to insure rail transportation of chlorine and other TIH materials, but the trucks are carrying them. I'm certain that they're getting insurance when they carry these materials.
I don't believe that there are more than perhaps 20 trucks in the entire United States.
It's a number close to that, yes, sir.
That handle chlorine, and it's only done for very specific applications.
There have been
Mines,
I was going to say there have been risk assessment studies done in the past taking into account the number of shipments, the typical routing of shipments, the accident frequencies for both rail and truck, the amount of product in carriage on average, and very complicated risk assessment studies have indicated that the overall risk, the safest mode for delivering chlorine is by rail, significantly safer than by truck. And as a responsible company, I have an obligation to not move chlorine out of an inherently safer mode of transportation to something less safe, because it makes it more convenient for the railroads to haul that product, or more financially acceptable for them to haul that product.
I appreciate that. These questions are,
Excuse me, Vice Chairman, but Mr. Flood also made a very valid point, and that is that most consumers use the rail car as their storage. So they keep the rail car. They don't, unlike HCL, where they generally unload it immediately into a tank, they keep the rail car on site, use it for storage, which avoids one extra transfer and one extra source of potential leaking.
Ms. Burns, you mentioned that the railroads raised the rates 88% after you reduced the mileage by so many. Was that in direct response to the reduction of mileage, or was that just coincidental that the rates happened to go up right after you did that, and you were somewhat surprised?
No, the situation was that we had a chlorine move out of our Taft plant moving on the shorter route. They significantly raised their rates. We then found the longer route at a lower rate available to us. We went back to the carrier and said, it's all in our best interest to move fewer miles. We have a rate that's far more competitive than what you are. Asked them to reduce their rate so that we could continue to move on that, and we're told that the rate was what it was and there was not going to be any reduction in the rate.
Let's see. Mr. Claude, you mentioned about the importance of the U.S. advantage in logistics, and has historically been a major U.S. competitive advantage, lower logistics costs, because we don't always have lower labor costs or materials costs, but our logistics system has been one of our real competitive advantages. And you testify that you see that evaporating and the U.S. losing its competitive advantage. Would that cause, do you see Total in the next decade or so beginning to move more of the operations offshore in response to higher logistics costs?
There are two aspects. But obviously, when we propose an investment in the company, this is looked versus investment in other places of the world. And they look at the total cost, and that's manufacturing cost and logistic cost. Another important aspect to this is obviously this is eroding our profitability in our business, but also those costs are passed to our customers. And I would like you to know that end of last year, early this year, there was not a month without one of the plastic transformer, huge company, getting bankrupted and either having to close down some of their plants or send that manufacturing transformer side to Asia and other places. So this has a chain effect onto our activity, but also our customers' business.
Thank you very much. That's all my questions.
Commissioner Buttrey? Mr. Claude, I was just curious. You're the fourth largest publicly traded integrated oil and gas company in the world. Your headquarters in Brazil, or where is it?
They are in Paris.
Paris.
Yes,
okay.
sir.
I was just curious. I know I could get this from your annual report, but I don't happen to have one handy, so maybe you can enlighten me. What are the global gross revenues of the consolidated companies? Do you have a feel for that?
Yes, as the other oil companies in the world today,
Consolidated income statements show in terms of global gross revenues.
Yes, as I was saying, as the other oil companies in the world, Total is doing very well for the moment. Now, you need to know that the petrochemical side is going through a very difficult cycle, and that is why most of the large oil companies, as Shell, BP, and others, have sold their petrochemical activities to financial communities, hedge funds, or to Middle East companies, and that's the majority of what the majority of the oil companies have done. So they are looking at all aspects of the business, and I have to justify the financial health of my activity, which is petrochemical, and it has been way below the 10% you will be talking about end of last year and this year.
And what percentage of the U.S., your operation in the United States, you're just responsible for U.S. operations?
Yes, sir. Yes, sir.
What percentage of your U.S. operations, what is the percentage contribution to the total? Do you happen to know what that is?
In the total group?
Total group, yes.
A small percentage.
A small percentage.
The petrochemical activity worldwide is something like 10 to 15%, and the U.S., I'm pleased to tell you, is about a quarter of that.
I just want to clarify the record, Ms. Burns, about something I thought I heard you say. I think you said that you had experiences where carriers refused to quote you a rate on a movement that you wanted them to do. So what was your alternative methodology after that?
We have several examples. The first was we were nearing completion of negotiations on a very large move out of Niagara Falls, and at the end we felt like we still had 6 lanes that were unreasonable. We asked for tariff rates for those 6 lanes, and we were told that if we were given tariff rates for those 6 lanes, all contract rates were off the table and all moves would move to tariff. Since then, we've been
everything would move to tariff.
Correct.
Okay.
Since then, we've been negotiating with another railroad, and this time we asked for tariff rates in parallel with contract rates.
Mm-hmm.
And we were first told that there was no tariff rates, and when we reminded them of their obligation that they had to give us a tariff rate, they told us that it was not their practice to give us a tariff rate until they exhausted all contract negotiations, and we're not going to give us a tariff rate until we completed negotiations. That contract is up next Wednesday, and we are still waiting on some of the contract rates.
So you're operating under a contract rate now?
Still under contract.
Okay.
Going off contract on the 1st of next month.
So what's the takeaway from that? That the carrier was forcing you to a contract, therefore those rates would be outside a rate relief petition?
Yes. And we wanted both in parallel so we could evaluate our options, so we could pursue a small rate case. But we have been told, not directly, but that the same thing would happen, that if we were to go ahead and get tariff rates, contract rates would be pulled.
Okay. Mr. McIntosh, you said that your rates, current rates and recent rates, were far greater than the rates you paid in 2002, 2004.
Yes, sir.
Now, the rates that you were paying in 2000, I know we're not here to talk about rates, but this is just really intrigues me. You'll indulge me here for a moment.
It has a funny way of coming up whenever we get together.
It has a funny way of coming up. It has a funny way of coming up all day, as a matter of fact. It's kind of like in trial lawyer, you opened this thing, now we're going to talk about it. 2002 through 2004, were those contract rates or were those tariff rates?
They were contract rates.
They were contract rates.
Yes, sir.
And they have gone up. Will you refresh my memory on what you said that they had increased in 2004?
Between 200% and 300% since the average over the average of the rates between 2002 and 2004.
2004. Okay.
Yes.
Okay. And you're not under contract. You're on tariff rates now.
No, under contract
you're under
rates
contract
for the
rates
most
now.
part. Yes, sir.
So you're able to move from tariff rates to contract rates during some type of negotiating process.
No, we have been under contract rates for that whole period of time, rapidly escalating contract rates. We're still under contract rates.
Okay. Did the carrier quote you tariff rates?
No, sir.
To quote you tariff rates?
No, they were not willing to quote rates as we were trying to negotiate contract rates for that period of time. or for the, in recent negotiations.
So during the negotiations, you got the distinct impression that there wasn't going to be a contract, wasn't going to be a tariff rate. There was only going to be a contract rate.
In any occasion when we were given tariff rates, the tariff rates were an even further penalty over the contract rates that we were given with 30-day, basically 30-day terms.
I just want to clarify that. Thank you very much.
I would like to mention that those cost increases happen also for plastics, which are non-hazardous materials. So we've linked a lot the cost to the hazmat problem today. I came today to testify that the same is happening for non-hazmat product.
You're not producing inhalants. You're not producing anything that could be toxically inhaled, correct? You're producing pellets.
We're producing pellets, and we're producing some liquids which are going by barges and pipeline at 95%.
But not by rail.
Not by rail.
Okay. Thank you.
I think it just bears reiterating that the board takes very seriously any refusal by a railroad to quote a tariff under any circumstances other than if it's involving an exempt commodity. Please let us know, let our Office of Rail Consumer is the most appropriate first stop, know about that, and we will be sure to dig in deep to find out what's going on and to straighten that out. This is not the first time I've heard that, but we've heard it repeatedly today. I'm very concerned about that. Any more questions for this panel?
No, not now.
Thank you, panel. Safe travels as you get home, and thank you for being with us today. We'll now call forward our final panel, Mr. Doug Kratzberg and Mr. Nicholas DeMichael from the National Industrial Transportation League. Just while the next panel comes forward, we'll reiterate that in the hallway, out as you leave this hearing room, there is a table that has information sheets on the STB Office of Rail Consumer Assistance, and urge folks to grab some of those on your way out.
Good evening.
Hello. Welcome, Mr. Kratzberg, Mr. DeMichael.
Thank you.
We wanted to give you the last word. I hope today, at least. So when we go to bed tonight, we'll have nothing but your wisdom wafting through our ears. We appreciate your patience. Someone had to have the last word today. We hope you're okay with the fact that it's you.
No problem.
And without further ado, we'll turn it over to you for the next 10 minutes.
Okay, thank you. Chairman Nottingham, Vice Chairman Mulvey, and Commissioner Buttry, I'm Doug Kratzberg, Rail Planning and Operations Manager for ExxonMobil Chemical Company. And I'm here today in my role as the chairman of the National Industrial Transportation League Rail Committee. Appearing with me today is Nick DeMichael, counsel for the League. I appreciate the opportunity to testify before the board at this hearing, which is designed to examine the issues related to the railroad common carrier obligation. As I believe you're aware, the League is one of the oldest and largest national associations representing companies engaged in the transportation of goods in both domestic and international commerce. The League currently has over 600 company members, ranging from some of the largest users of the nation's and the world's transportation system to smaller companies engaged in the shipment and receipt of goods. More than 100 years ago, the Congress codified the railroad common carrier obligation. Today, this obligation remains a statutory duty that requires railroads subject to the jurisdiction of the board must provide transportation or service upon reasonable request. The board maintains the authority to ensure that the railroads comply with this statutory duty and to determine whether the service requested by a shipper is reasonable. However, the board does not possess the authority to change or repeal the common carrier obligation, as this right rests solely with the Congress. It is the League's strong view that the common carrier obligation is an essential requirement of the U.S. regulatory system governing railroads. The railroad's duty to fulfill the common good and further the nation's commerce is as critical today as when the obligation was first recognized over 100 years ago. The railroads continue to serve a unique and special role especially for large bulk commodity shippers or shippers of very hazardous materials, hazardous chemicals, where rail cannot be replaced by any other mode. The issues facing today's rail industry, including a limited number of service providers and infrastructure and capacity constraints, creates a need for government oversight of the manner in which railroads allocate their supply of services. The League is aware that railroads are taking actions to increase revenue through price increases and reduce liability risk by refusing to provide service, such as in the case of intermodal service of TIH commodities. While the rail industry has the right to make rational pricing and service decisions based on market conditions and the economics of their business, as a regulated industry, such factors are not and should not solely determine who receives rail service and who does not. The national interest must take into account the shipping public's need for rail service to allow for safe and cost-efficient product deliveries. If left to their own devices, the League is very concerned that railroads would refuse to transport hazardous commodities that qualify as TIHs and perhaps other traffic as well. Some shippers already suffer from service problems that adversely affect their business, including insufficient car supply as well as unreliable and inconsistent service. Notwithstanding the current challenges faced by the rail industry and its customers, the common carrier obligation has long served to guarantee that shippers can at least obtain some level of service as compared to no service at all. This fundamental duty helps to ensure that the commercial needs of the U.S. shipping public are met, subject to a reasonableness standard. The League strongly believes that the Board's regulatory oversight of the common carrier obligation is absolutely essential to ensuring that the railroads provide service upon reasonable request and do not seek to transport only their most profitable and least risky traffic. Accordingly, the Board should not narrow or dilute its interpretation or enforcement of the common carrier obligation based on alleged capacity constraints. In its notice announcing this hearing, the Board asked for feedback on the cost and safety issues related to the carriage of TIH commodities. Class 1 railroads have made no secret of their preference not to transport hazardous materials that qualify as TIHs. The courts have previously determined that railroads cannot refuse to carry goods based solely on their dangerous nature or characteristics, as long as such goods are tendered for shipment in accordance with applicable safety laws and regulation. In this context, requests for transportation service are deemed reasonable when such requests conform with minimum safety standards such as Department of Transportation and Nuclear Regulatory Commission requirements. In enforcing the common carrier obligation with regard to the carriage of certain hazardous materials, the Court has sought to further the public interest in finding that rail carriage is the safest and most economical means of transporting such products. In sum, a railroad's common carrier obligation is comprehensive, and the circumstances under which a carrier could refuse transportation of hazardous goods are few. TIH products are used in many contexts to purify the water we drink, to operate pollution control systems, and as a component in many manufactured products across a variety of industries, such as automotive, defense, healthcare, among others. Based on the dangerous nature of these commodities, rail transportation, rather than highway transportation, is the safest manner in which to move these products to necessary delivering points. Thus, strong public safety considerations continue to require strict enforcement of the common carrier obligation with respect to the carriage of TIH products. If the railroads begin refusing to carry TIH commodities or impose unreasonable conditions for such carriage, producers of these commodities will be forced to either ship these products by truck or to not ship these products at all. The latter choice is simply not a viable option and will lead to such producers to ship their production overseas at the cost of American jobs. Turning to the issue of rail infrastructure investment, the League is aware that rail carriers are increasingly requiring shippers to make investments in rail infrastructure as a condition to obtaining rail service. In many cases, shippers are being asked to pay for new track construction or improvements that relate to the requested service. While the League believes it is reasonable for a carrier to make such proposals to its customers regarding infrastructure investments that directly concern the service requested by the shipper, the League does not believe that it is appropriate or lawful
for a carrier to condition the provision of rail service required by a shipper in exchange for the funding of infrastructure improvements. With regard to whether volume requirements or incentives, including in a rail service arrangement, affects the common carrier obligation, the League would simply note that a rail carrier should not be permitted to avoid the common carrier obligation merely by inserting such requirements or incentives into its common carrier tariffs. This issue appears to be related to another STB proceeding, Ex Parte 676, Rail Transportation Contracts under 49 U.S.C. 10709, in which the Board desires to establish a rule that will help to distinguish common carrier rates and service from contract rates and service. In short, the League does not believe that the inclusion of volume requirements and rate incentives in a tariff automatically transforms the document into a contract which would not be subject to the common carrier obligation. In its notice of hearing, the Board identified economically motivated service reductions and metering of demand for service as a topic of interest. In surveying the members of the League's Transportation Committee confidentially with respect to this hearing, the responses broadly demonstrate that shippers are experiencing double and triple-digit price increases at paces never seen before. However, in some cases, there appears to be a growing perception that the aggressive price increases are offered not only to secure market-based compensation, which include high energy costs, but to directly discourage the shipper from tendering the shipment. This is a very, very troubling phenomenon if these perceptions are in fact true. Although a shipper could attempt to challenge the rate, level of rate offered by a rail carrier as being unreasonably high, as the Board knows, that rate challenges have not been widely employed by shipper community in the past for various reasons. The League believes that a legitimate question exists as to whether railroads that price traffic at extremely high levels for the purpose of discouraging the movement of commodities is a violation of the common carrier obligation. Assuming that the shipper seeking rail service has made a reasonable request, a response from a rail carrier that is directly intended to discourage the movement appears to be inconsistent with the statutory duty to provide service upon reasonable request. This concludes my oral remarks. The League certainly appreciates the opportunity to participate in this hearing today, and happy to answer any questions. Thank you.
Thank you, Mr. Kratzberg. I'll yield to Vice Chairman Mulvey. Mr. Mulvey?
Just briefly, it's getting late, so I'm sure we all want to get out. It was a while back, seemed like hours ago, but the witness for DuPont mentioned that they tried to ship some ISO containers and the railroads refused to handle them, saying that this is an exempt commodity, even though it was a hazardous material, because it was a container, it was an exempt commodity. Are you aware of any other situations like that where the railroads have refused to ship hazmat because they were not in tank cars and rather they were in ISO containers? Have you heard about this before?
Personally, I'm not. I can add a little bit to that. I don't believe that the railroads are refusing to ship hazardous commodities because they're in ISO containers. They're refusing to ship hazardous commodities because they're an intermodal service.
That's what I'm saying.
And therefore, because of the intermodal exemption, they're basically saying that they will not ship. Mm-hmm. And at least I'm aware of a number of situations like that.
Okay. You suggested it would be helpful for the Board to clarify whether shippers faced with high pricing proposals may only challenge those rates through our rate procedures or may alternatively challenge the pricing as a violation of the common carrier obligation. If the Board was so inclined, how would you suggest we do so, and what factors would we have to use to determine that it was a common carrier violation?
I'm going to ask my counsel to assist with that one. I think, Vice Chairman Mulvey, that you would have to get into the level of the rate increase. There might well be questions of intent here, and I think this would get into a discovery matter just the same way that a unreasonable practice complaint would be done, just a ordinary garden variety.
Intent is always difficult to show.
It is true, but I guess we're not saying that the Board's rule should preclude a claim under the common carrier obligation based on the level and intent of the rate increase.
So it would be a practice rather than a rate case. And
that's correct.
You argue that the shippers should not be required to invest in rail infrastructure as a condition for receiving rail service. Does it make any difference whether the investment is on the shipper's property or in its plant, or rather say an electric switch that might be on railroad property? Do you differentiate between those two, investments made by shippers on railroad property versus investments made on the shipper's own property?
Well, my understanding would be that generally if a shipper is going to be asked for making investments, it would be on their own property. If it were on the railroad's property, it would be something that they would own and would maintain. So in general, those type of improvements would be on private owned property for the shipper, on the shipper side.
But there can be cases where the investment would need to be made on the railroad's property in order to give the shipper better service, and the railroad says, look, this is going to benefit largely your movements, so therefore we need you to pay for it.
I presume that could happen. The only cases I'm familiar with are those shippers that have indicated to me that they've been asked to make infrastructure improvements on their own property.
Thank you very much.
Commissioner Buttrey? I have no questions either for this panel. Thank you. The testimony was strong and clear, and we appreciate that. That will adjourn this hearing for the day. We will resume tomorrow morning at 9 a.m., same place, same general topic. We have some more good panels tomorrow. I want to thank the staff here in the room, and also the staff out in the hallways who provided security and throughout the agency for helping with this hearing, and thank all of you for participating.
Thank you very much.
Thank you.